the Mississippi Board of Nursing. The board is made up of 13 members. I'm sorry. Let me start over. Welcome to the Mississippi Board of Nursing. Before we begin, we're going to have Mr. Jeremy Cummins lead us in prayer.
Let's pray. Father God, we thank you for this day. We thank you for loving and caring for us. We thank you for a new day of life. We pray that today the decisions made will be in your will, that there will be calm nerves and peace and good decision making. We pray for those listening to be understanding of the decisions made, and we pray for your guidance. We ask this in your name. Amen. Amen.
I'm Sandra Culpepper, and the board is made up of 13 members, 7 RNs, 4 LPNs, 1 physician, and 1 consumer. We are a 3-member panel of the board, with 1 serving as an alternate, but who will not participate in either the deliberations or the decision concerning this case. At this time, I will introduce the other board members. I myself am Sandra Culpepper.
Laura Moore, APRN.
Mary Stewart, RN.
Jeremy Cummins, LPN.
And then I would like for the Assistant Attorney General.
Good morning, everyone. I'm Edward Wiggins, Special Assistant Attorney General. I'll be serving as the hearing officer this morning.
At this time, I'm going to turn it over to Mr. Wiggins.
We certainly thank everyone for being here this morning. We will try to move as efficiently through these proceedings as we can. And the first matter before the board panel, license number P326303, Victoria Prisock. Okay. The order of proceedings will move forward as follows. We will have opening statements. We will hear arguments from both sides. There will be time for questioning of any witnesses. At the conclusion of the presentation of both sides, we will allow for closing statements. The board will then make findings of fact and conclusions of law and render its decision, a copy of which will be mailed to the licensee within 30 to 45 days of the conclusion of today's hearings. These hearings are open to the public. I will note for the record that there is a quorum present. At this time, I'll ask that all witnesses to this proceeding be sworn in.
Oh, me, stand up.
Raise your right hand, please. Each solemnly swear that the testimony you're going to give will be the truth, the whole truth, and nothing but the truth.
All right, thank you very much. Ms. Prisock, are you represented by counsel today?
Sir, I'm not.
You understand you have the right to be represented by counsel?
Yes, sir.
You understand you also have the right to have witnesses testify on your behalf?
Yes, sir.
You also understand you have the right to have the board issue subpoenas on your behalf?
Yes, sir.
And your testimony today is you're ready to move forward with this proceeding.
Yes, sir.
Thank you. Ms. Saltzman, do we have any preliminary matters?
Yes, Your Honor. As a preliminary matter, I would respectfully request that we be allowed to enter into evidence exhibits B1 through B11. And Mrs. Prisock has been, I said that correctly, has been provided a copy of these exhibits as well.
Do you have any objection to these exhibits?
No, sir.
They are admitted. We can now move to opening statements. Ms. Saltzman, you may begin.
Thank you. We are here today for a hearing before the board panel on the suspension and possible revocation of the nursing license Victoria Prisock in Mississippi. Mrs. Prisock was first licensed as an LPN in Mississippi in August of 2011. The evidence today will show that Mrs. Prisock admitted to using a patient's EBT card for personal use. In exchange for a non-adjudicated sentence, she pled guilty to abuse of a vulnerable adult in the Justice Court of Winston County, Mississippi. It is alleged today that she violated Mississippi Code Annotated 73-15-29-1K and that she engaged in conduct likely to deceive, defraud, or harm the public. Thank you.
All right, thank you, Ms. Saltzman. Ms. Prysock, if you have an opening statement, you can make it at this time.
Good morning. My name is Nicole, been a nurse for 11 years. I've been in long-term care for 10 years. I've always provided dignified and compassionate care to my residents. And I did wrongfully use the EBT card for the resident. So I'm here today to do what I can to protect my license.
Thank you. Right. Ms. Salton, you have the floor.
Yes, the board would call investigator Tawanda Jones, please. Please state your name, county of residence, and place of employment.
My name is Tawanda Jones, and I reside in Rankin County, and I work for the Mississippi Board of Nursing.
How long have you worked for the Board of Nursing?
I have worked for the Board of Nursing for 5 years.
And during that time, have you participated in the investigation of complaints that are received related to individual clients by the board?
Yes.
And if you would, please turn to what has been marked as exhibit number B3 and identify that document, please.
B3 is a licensing document from the Mississippi Board of Nursing.
And who is this license for?
Victoria Nicole Prescott,
What is the license number is listed there?
326303,
And what is the license type?
licensed practical nurse.
And if you would, please turn to what has been marked exhibit B5 and identify this series of documents. Let's go to the second page specifically. Identify that document, please.
That document is an amended complaint.
And if you would, tell us what the charge is against Mrs. Prysock today.
Charge 1 is a violation of Mississippi Annotated Code 7315-291K in that the respondent had engaged in conduct likely to deceive, defraud, and harm the public.
And if you would, please tell us what additional facts are listed on the complaint related to Mrs. Prysock's actions.
On or about May 25th, 2022, the respondent entered a plea of guilty to 1 misdemeanor count of exportation of a vulnerable person in the Justice Court of Winston County, Mississippi, in exchange for a non-adjudicated sentence. The respondent unlawfully took money from an EBT card that belonged to a vulnerable person.
And if you would, please turn to what has been marked B10 and identify that document as well, please.
B10 is the Attorney General's Office Report of Investigation.
And who is the subject of this report?
Victoria Prescott.
And if you would, looking at that second page, can you tell us what the allegation against Mrs. Prysock was that was contained, or that were contained in this report?
The allegation was that Ms. Prescott used the resident's EBT card for her own personal use.
And looking at the third paragraph specifically, could you read that to us?
On September 2nd, 2021, I met with Nicole Prescott at her home in Louisville. Prescott admitted to using the EBT card for her personal use. Prescott said she used the card at Viles Market on October 26, 2020, in the sum of $125.94 for her personal use.
And after receiving this complaint from the Attorney General's office, did your division conduct an investigation?
Yes, we
And
did.
what did it do in that investigation? What did you do?
It confirmed the allegation that Ms. Prescott used the card for her own personal use.
And did you obtain copies of the EBT transactions?
Yes.
Okay, please turn to page exhibit B8 and identify that document, please.
That is a transaction activity report for an EBT card.
And is this the residence card in question?
It is.
Okay, if you would, could you turn to count the pages, sorry. 1, 2. The third page of exhibit B8 on 10/26/2020, and tell us what this EBT transaction shows.
On October 26, 2020, the transaction is for Vowels Marketplace in the sum of $125.94.
And if you would, please turn to B7 and identify that document, please.
B7 is a statement that Ms. Prescott gave to the Attorney General's office.
What does her statement indicate?
On her statement, she indicated that she used the residence EBT card on October the 26th for her personal use.
And did she sign this statement?
Her statement is signed
And what is the date of the statement?
September 2nd, 2021.
Please turn to what's been marked as Exhibit B6 and identify that document.
That is a court abstract from Winston County Court.
And who is the defendant listed on this court abstract?
Nicole Prescott.
And what is the date of the abstract?
July 8th, 2022.
And what does it say the date of the violation is?
Date of the violation was on December 1st, 2020.
And what was the court date?
Court date was May 25th, 2022.
And what was the judgment of the court at this time?
Guilty. She was found guilty.
And did she enter a plea at this time?
She did.
And did she enter a plea in exchange for a non-adjudicated sentence?
She did.
Okay, if you would, turn to what's been marked as B11 and identify that document, please.
11 is an order for a non-adjudication action.
And what is the court for this action?
Winston County.
And again, does this indicate that based on her entry of a guilty plea, she was given a non-adjudicated sentence for this charge?
Yes.
So in summary, Ms. Prescott admitted to use of a patient's EBT card for her own personal use. Is that correct?
That is correct.
I tender the witness.
Ms. Prescott, do you have any questions for this witness?
Let's see. If you will go to Exhibit 7. This statement that I was given to Trey Rogers, I did not confess to spending 125 on the EBT card. I have not seen these papers. I obtained a lawyer for this sentencing in Winston County. I was not shown these papers. My lawyer.
Let me stop you there. Ms.
Yes, sir.
Prescott.
Yes, sir.
At this point, all we need to know if you have any questions for this witness.
No,
regarding
sir.
these.
No, sir.
You have an opportunity to present your side of the argument.
Okay.
All we want at this point is questions for her if you have any.
Yeah.
Any questions from the board panel for this witness? Any follow-up, counsel?
No, Your Honor.
Any anticipated further testimony from this witness?
No, Your Honor.
Well, she may be excused. You have another witness, counsel?
Do not, Your Honor.
Ms. Prescott, you can now share with the board your side of this matter.
Okay. So the resident came to our cottage. When he came to us, he didn't have many clothes. His family lived out of town. He didn't have anyone, to help him out. He first came there, we all got very close to the resident in question. I provided clothes for him. We became very close. Everyone in the cottage became very close to him to the point where we called him uncle. It was just something everyone did. Excuse me. Eventually, the resident asked, would I go outside of work and buy him stuff using his EBT card? And I did. They would give me a list, a grocery list, and I would go and use his EBT card and buy stuff to stock his refrigerator. He would ask, for Cokes, just whatever he would ask for, I would go and do. Along with several others. I was not the only one that used the EBT card. I didn't receive this paperwork until after I had a guilty plea. I did plead guilty in Winston County. I obtained a lawyer out of Starkville who advised me to make a guilty plea. And I did. So it was after that I received this paperwork, and it's a lot of discrepancies in it. I did use the CBT card. I did. I used it for the resident a lot. But I was not the only one to use it. Multiple people used it. There's multiple charges from multiple different people that use this CBT card. So I'm just here to say my side of the story and pray that I don't have anything against my license when I leave here today.
Ms. Austin, do you have any questions for this witness?
To Your Honor. What's your current place of employment, Ms. Prysock?
I'm currently employed at an internal medicine and pediatric clinic.
Please tell the board your educational background.
I graduated from West Lauderdale High School in 2003. I got my license for practical nursing from EMCC in Mayhew. I graduated from there from 2011.
And when were you first licensed as an LPN in Mississippi?
In August of 2011.
Have you had any other licenses in any other states or jurisdictions?
No, ma'am.
And can you tell us prior to your current employment where you were employed?
Prior to my current employment now, I was employed at Winston Medical Center,
And before that,
Louisville Healthcare,
before that?
Winston Medical Center.
So as I understand your testimony today, you admit that you used the patient's EBT card for personal use.
Yes, ma'am.
You're just saying that other people did it as well.
Yes, ma'am. I did not buy anything that the resident did not tell me I could buy.
But you did in fact admit to using the resident's EBT card
Yes,
for your
ma'am.
own use.
Yes, ma'am.
And this resident, was they an individual in your care?
He was. Yes, ma'am.
And was that at a long-term care facility?
Yes, ma'am.
And did you enter a plea of guilty in Winston County in exchange for a non-adjudicated sentence?
Yes, ma'am.
Have you ever been arrested before?
No, ma'am.
Do you have any other criminal history?
No, ma'am.
You had any other disciplinary actions before this board?
No, ma'am.
Tender the witness.
Any questions from the board panel? We'll start here.
Mr. Stock, I had to ask, so were any other administrators or the employees of this facility aware of the EBT card?
Yes, ma'am.
How did it come to light that this resident had an EBT card in a nursing home or long-term care setting?
It was reported to the CEO, the administrator, and the director of nursing. How this all came about, state survey showed up, and they were there for different complaints, and it got brought up then that he had an EBT card. I was off that day, and I got a call from the director of nursing asking, did I use his EBT card? And I did. I believe that was when it came to light. But now everyone in the cottage, everyone in the college knew that he had an EBT card. Multiple people used the EBT card, and it had been reported to the CEO, Paul Black. It had been reported to him. It had been reported to the administrator, Lacey Jones Eves, and it was also reported to Dana Scrivener, the director of nursing.
Were any other employees charged with the same event?
No, ma'am.
So just to clarify, you were the only employee charged with this event, even though multiple people were accessing.
Yes, ma'am.
Okay. At any point, because I just need to confirm and clarify what you're saying because of B10 and B7, at any point, did you ever use that card for personal use?
I did. Along, with buying the resident stuff. But like I said, I did not use it without, him knowing. I did not use it maliciously. Everything that I bought, he was aware of.
And I think the last question I have for you is, I've worked long-term care for 15 years.
Mhm.
Do you know why the resident had an EBT card in a long-term care setting?
No, ma'am, that's a very good question. And actually, I wasn't aware until all this came about that he was not supposed to have an EBT card. There was no training, no in-services prior to this, that he wasn't allowed to have an EBT card. We weren't allowed to use the EBT card. No, ma'am.
I have just one last question.
Mhm.
Just out of curiosity.
Mhm.
Did you have to do restitution for the monies that you used for yourself?
I, well, I paid a fine to the Attorney General's office.
Thank you.
You're welcome.
You mentioned that there was a lot of discrepancies. in the
Mhm.
paperwork. Can you go in a little bit more detail about that?
So if you go to Exhibit 8 and it shows the transactions, this will show you where the multiple transactions were used. I had given the resident back his EBT card. It got to the point where it was just, he was asking me frequently to buy him stuff. My personal time, Cokes. I mean, it was just constantly that he was asking me to get stuff. And so I had given it back to him. So if you look at Exhibit 8, there was still multiple purchases after he was given back the EBT card. Going all the way to July 23rd at Gregory's Food Mart for $43.96. Just multiple people used it. Of course, that I just feel like multiple people should have been also investigated.
So if you're looking at these charges,
Mhm.
the one particularly in question that is for $125 vowels.
Mhm.
Why is that one in particular? on the card?
I don't know. Mr. Trey Rogers had put in the report that I admitted to using the card for $125 at Bowels, and I did not. I did not put that in my statement. I did not admit to that.
So when you said that the patient was aware, was he giving you permission to purchase things for yourself?
Yes, ma'am.
Was that in any type of exchange for service otherwise, or? I guess, was he trying to give you like a gift?
He would give me lists. He would ask me to buy stuff to cook for him. You've got a long-term care person who didn't have many visitors. You become attached to him. And, he had told me it had been years since he'd had, for example, a steak. And, being close to him like that, we grilled steaks and cooked baked potato and salad and took to him at the nursing home. So there
That
was,
was purchased with his, and
Oh.
that was, and he asked you to do that? Or
yes,
was
ma'am.
that an understanding that you had with him?
No, ma'am, he asked me to do that.
As far as his reasoning for being in long-term, did he have any mental instability or dementia or any type of issues as far as not being of sound mind?
No, ma'am, he is of sound mind.
Okay, was there anybody else that you have done the same for, use an ABT card with anyone else?
No, ma'am, he was the only one that has ever had an EBT card. We've had multiple residents that would, bring cash and have cash, and they would ask, for us to go to the store and get them something with cash. But he was the only resident I've ever come across to have an EBT card.
As far as your facility, is it common practice for y'all to run errands for the patients outside of work?
Yes, ma'am. They have an activities director that does it also. But yes, ma'am, many employees do for the residents like that.
Is it beyond just common practice? Is it allowed as far as your policies of your clinic? Or your facility?
Well, the administrator, Lacey knew that we were doing this. So I'm just going to assume that if it wasn't allowed, we would have been reprimanded.
Okay.
Ms. Pricelock, thank you for being here. and
Thank you.
answering our questions. What was the patient's diagnosis?
His admitting diagnosis was pulmonary disease, I believe.
Other diagnoses since he had been admitted?
He had a lot of cardiac issues. He was diabetic.
He was diabetic and he asked for Cokes and you bought them?
Not working. Okay. Yes, ma'am. I did. I did.
Okay, so, I think, Laura asked this question. I just want to follow up. So do you know, yes or no, is it policy that you buy these things for patients or cash, EBT, whatever?
Is it,
You assuming?
I don't know. I don't know. Yes, ma'am.
All right, so, what did you buy for yourself?
At the top, off the top of my head, I really don't remember. I mean, it's just, I would buy groceries for him and, ingredients to cook stuff for him. There's several times I, cooked for him.
Right, but what did you buy for yourself, for your own personal use?
I'm sorry, off the top of my head, I don't know. Maybe, maybe a few groceries,
Okay, and did you do this on one or more occasions?
a couple occasions.
I guess the only other thing I would say, and you said you did not buy anything without his permission.
Yes, ma'am.
So did you tell him you were using his money to buy groceries for yourself?
Yes, ma'am. He was aware.
And he said, great. I guess I'm unclear about how something like that would happen.
He's a very kind person. So yes, sir, he would allow us, to use it for whatever we needed, he would say, get something for myself while I'm there.
Why do you think he did that? Other than being a kind person?
I guess he felt like, since I was going out of my way, on my time to do stuff for him, that he felt like that was sort of like a repayment. I'm not real sure.
Yeah. So, do you understand that when the patient was admitted to this long-term care facility because why? You told me his diagnosis, but why are people admitted to long-term care facilities?
He had a lot of health issues, no caretaker at home.
Because he couldn't take care of himself at home, correct?
Yes, ma'am.
So, the patients, and I'm probably telling you something you don't know, but I'm a little, I guess I'm concerned that this happens. They trust us to do the right thing. And so I'm struggling a little bit with how, and it doesn't matter how many people did it. I'm struggling with how you could see that this was okay.
I just felt like I was taking care of my resident.
And yourself.
Yes, ma'am. But I didn't do it maliciously. I didn't see the legal purpose, the legal background of it.
Okay, I think that's one piece, and the other is it's wrong. It's not just illegal, it's unethical. You're taking advantage of a patient who has been entrusted to your care in this facility, and you were taking advantage of them. Do you understand that?
Yes, ma'am, I do. And at the time, I didn't see it that way. I just saw it as I was taking care of my resident.
And yourself.
Yes, ma'am.
And the other thing, I guess, is, and I have to say this because we have an audience here, and I think they
Yes, ma'am.
hear, it does not matter if every person in the institution was doing the same thing.
Ma'am, it was wrong. Yes, ma'am, I
It was
understand.
wrong, and it was an abuse of your position of authority and power over a patient who was institutionalized. And that's a serious offense to the public's trust.
Yes, ma'am.
I do want to follow up with something.
Yes, ma'am.
I was just curious as to, did the facility have any repercussions from this investigation?
I was suspended, and after this suspension, I was just told it would be investigated, that they would call me if, basically, once this was over, then I would hear from them. If you go to Exhibit 9, it shows that there were in-services, that were completed. I did not complete those in-services. It was July 29th. I was not working there at the time. I was at home suspended. But there are 2 in-services that they did once after the complaint.
So, and I'm trying to circle back around, were
Yes,
there
ma'am.
repercussions for the facility itself through the survey process?
I'm not aware of any. I don't know.
And so when you purchased the food that you brought home to cook,
Mhm.
he told you to pick up 3 versus 1, correct?
Yes, ma'am.
Ms. Price, like you mentioned, that there were other individuals who used the card.
Yes, sir.
As a part of the Attorney General's office investigation, did you report that to the investigator?
Yes, sir, I did.
How did you become aware that other individuals were using the card?
I mean, it was just everyone in the cottage knew he had the EBT card. There was multiple people used it. Dietary workers, activity workers, CNAs.
So were you with them when they used it, or you just made aware?
So,
after they-
no, sir, I was not with them when they used it.
Any further questions from the panel? Any follow-up, Ms. Osmond?
I have one question, Your Honor. If you look at Exhibit B, what is B8? I'm just looking at the date range in question. October 1st is the 3rd page. October 1st, 2020 through October 31st, 2020, which that's just 1 month. Approximately $388 was charged to that card. And then if you look at the next page, you'll see January 1st, 2021, for the end of that month. There was approximately $234 charged to that card. Does this resident have a kitchen or a refrigerator in his room?
He does, excuse me, he does. He has a refrigerator. And
Did you stock the refrigerator with groceries?
yes, ma'am.
And was that allowed at the long-term care facility?
Yes, ma'am. I mean, multiple residents had refrigerators and food in their room.
So he had no dietary restrictions?
Yes, ma'am. He had some. Mhm.
Did you comply with those dietary restrictions when you stocked his fridge?
I believe he had a dietary waiver signed so that he could eat what he wanted to.
That's all the questions I had.
One quick question on a dietary waiver.
Yes, ma'am.
Did you see that? Do you have evidence of that? Or is that just something you think?
I do not have evidence of it.
Thank you.
Further from the panel? Any follow-up, counsel?
Hey, Your Honor.
Anything further you'd like to share with the board, Ms. Price?
No, sir.
Counsel, you can give us your closing statement.
Mississippi Code annotated 731529 provides that the board has the power to suspend or revoke the license of a practical nurse for engaging in conduct likely to deceive, defraud, or harm the public. Mrs. Prysock has admitted to using the CBT card of a resident in her care for personal use. Quite simply, she stole from a vulnerable patient that she was entrusted to protect. There is no dispute related to the facts of this case. She's admitted the theft. She's provided a written statement confirming that she used the patient's card for personal use, and she's entered a plea of guilty in open court in exchange for a non-adjudicated sentence. In order to safeguard the life and health and welfare of individuals within her care, I would respectfully request this board consider revoking her license to practice nursing in addition to any other penalties allowed pursuant to Mississippi Code annotated 73-15-29-2. Thank you.
Ms. Prysock, if you have a closing statement, you can make it at this time.
Yes, sir. I did not maliciously use a CBT card. I've always cared for my residents with dignified and compassionate care. I get very attached to my residents, treat them like they're my family. Did I know at the time that it was wrongdoing? No. I see now. That's it.
Thank you. This time I'll entertain a motion for the board panel to close determination regarding whether executive session is necessary for this matter.
I will make the motion.
It's been moved and properly seconded. All in favor, please signify by saying aye. Any opposed? That motion carries unanimously. Now entertain a motion for the board panel to exit to the executive session for the deliberation on license E 326-303.
I'll second that.
It's been moved and properly seconded. All in favor, please signify by saying aye.
Aye.
Opposed? That motion carries unanimously. The board panel is now in executive session for deliberation on this matter. We will return with a decision. Thank you. All right, thank you for your patience, everyone. We are back on the record. Entertain a motion for the board panel to return to regular session.
I'll make that motion.
No second.
It's been moved and properly seconded. All in favor, please signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. The board panel is now back in regular session. Following deliberation on license number P 326-303, board panel renders the following. The license is restricted with non-drug related stipulations to include a $500 fine, 24 months probation, 1 year restriction from long-term care, formal reprimand, classes to include legal aspects of nursing, ethical decision-making, employer reports, indirect supervision. Petitioner must return to the board for restoration of their license once these conditions are met. Are there any questions? Hearing none, that will conclude this matter. You're excused. As with the previous matter, we will begin with opening statements. We'll hear the arguments from both parties. There will be an opportunity for questions from the board panel. At the conclusion of the presentation of both sides, we'll have closing statements. Board will make findings of fact, conclusions of law, and render its decision in the matter, a copy of which will be forwarded to the licensee within 30 to 45 days of the conclusion of these proceedings. These hearings are open to the public. I will note for the record that there is a quorum present. At this time, I'll ask that all witnesses be sworn in. Mr. Rhymes, your client is your only witness? Yes, Your Honor. Ms. Osmond, we can begin with your opening statement.
I just have a couple of preliminary matters. We would request introduction of exhibits B1 through B13, in addition to exhibit R1 that has been submitted on behalf of the respondent, Mr. Scott. If there's no objection, we have provided copies to counsel opposite as well.
Any objection, Mr. Rhymes?
Objection.
They are admitted. May proceed.
Thank you. We're here today for a hearing before the board panel on the suspension and possible revocation of the nursing license of Tyler Scott. Mr. Scott was first licensed as an LPN in Mississippi on October the 19th, 2011, and has been licensed as an LPN in the state since that time. Today, the board will view surveillance coverage of Mr. Scott having a physical altercation with a resident where he worked at Poplar Springs Nursing Home in Meridian, Mississippi. The evidence will show that on or about February 13th, 2022, Mr. Scott violated Mississippi Code Annotated 73-15-29-1C, and that he willfully and negligently acted in a manner inconsistent with the health and safety of a person under his care. And it will also show that he additionally violated Mississippi Code Annotated 73-15-29-1K, and that he engaged in conduct likely to harm the public. Pursuant to the authority found in Mississippi Code Annotated 73-15-29-1, this board has the power to continue suspension of Mr. Scott's license or to revoke his license to practice as an LPN in Mississippi. Thank you.
All right, thank you, Ms. Osmond. Mr. Rhymes?
Your Honor and members of the panel, Tyler Scott is an LPN who has, throughout his entire just around 10-year career, worked exclusively up until this incident at Poplar Springs Nursing Home. And he worked there because of his devotion to those patients. We are here about one incident, and it's an incident that we have a surveillance video of that's going to be at the heart of this case. That surveillance video does not have sound. And I would submit that that surveillance video raises some important questions for this panel to consider. Mr. Scott is going to walk you through that video and tell you exactly what was happening. So we are simply here today asking you to have an open mind and to appreciate the full context of what took place that day. Thank you very much.
Thank you. Ms. Osmond, you may begin with your case in chief.
Panel's investigator, Wanda Jones, please. Please state your name, county of residence, and place of employment for the record.
My name is Tawanda Jones. My place of residency is Rankin County, and I work for the Mississippi Board of Nursing.
And how long have you worked for the Board of Nursing?
I've worked for the Board of Nursing for 5 years,
And what positions have you held during that time?
investigating.
Is it part of your duties with the board to investigate complaints received from the public related to licensees of this board?
Yes, it is.
Please turn to what has been marked as Exhibit B3 and identify that document, please.
B3 is a license verification from the Mississippi Board of Nursing.
And who is the licensee listed on this verification?
Tyler Daniel Scott,
And what is the license number?
license number 326724,
And what is the license type?
a licensed practical nurse.
And when does this show his license was first issued with this board?
His license was issued on October 19th, 2011.
And if you would, please turn to what has been marked as Exhibit B5. Go into the second page of Exhibit B5 and identify that document as well, please.
That's an order suspending the license.
And if you would, please turn to the next page and identify that document.
That is the complaint.
And is this the complaint that was filed against Mr. Scott?
Yes.
And if you would, please tell us what the charge is as listed on the complaint.
Charge 1 is the respondent violated Mississippi Code 73-15-29-1C in that the respondent has negligently or willfully acted in a manner inconsistent with the health or safety of a person under the licensee's care. Charge 2, the respondent violated Mississippi Code, annotated code section 75-15-29-1K in that the respondent engaged in conduct likely to deceive, defraud, or harm the public.
And if you would, please tell us what additional facts are listed on this complaint related to Mr. Scott's alleged actions.
The respondent was employed as an LPN at Poplar Springs Nursing Home in Meridian, Mississippi on about February 13th, 2022. The respondent was observed on the facility surveillance camera having a physical altercation with a resident. The respondent was observed aggressively dragging the resident approximately 21 feet to a nearby dining room chair. The respondent aggressively placed the resident into the chair. The surveillance camera also observed the respondent grabbing the resident's roller walker and throwing it across the room.
After receiving this complaint against Mr. Scott, did you investigate the allegations that were made?
I did.
And what did your investigation determine?
It confirmed the altercation.
And if you would, please turn to what's been marked as Exhibit B8 and identify that document as well.
B8 is a facility report filed by Poplar Springs Nursing Home,
And what is the date of this report?
February 17th, 2022.
And who is the subject of this report?
Tyler Scott.
Let's get through this statement. Can you tell me why the patient was yelling at Mr. Scott?
The patient wanted food.
And what does this report indicate the patient suffered from?
He died dementia and behavioral. Find it again.
I believe that's going to be on the second page of Exhibit B8.
He had behavioral issues and it was moderate.
Do you know if Mr. Scott ever reported this incident with the resident to administration at the facility?
No,
Do you know if he was terminated from the facility after this incident?
he was.
If you would turn with me to what's been marked as Exhibit B7 and identify what that document is, please.
B7 is a document regarding the Vulnerable Adults Act.
And is this document signed?
It is signed.
And who signed it and what was the date of that signature?
Tyler Scott signed the document on November 10th, 2011.
And if you would, this document, which kind of summarizes Mississippi law on the Vulnerable Adult Act, would you tell us what number 1 and 2 are for crimes of abuse against a vulnerable adult?
Number 1 is physical assault against a resident, including but not limited to hitting, pushing, shoving, turning roughly, and smearing feces. Number 2 is a verbal abuse or slur against a resident.
Investigator Jones, in addition to obtaining these records and statements, and did you also obtain surveillance coverage of the incident?
I did,
And where did you obtain that surveillance coverage from?
from the facility.
Exhibit 8 is the surveillance of the incident. At this time, we're gonna upload what's been marked as video 1. And I would ask Investigator Jones if you would identify the date and time on this video once we get it up. I believe it'll have to go through the media player instead of opening in Windows. I'm sorry, VLC. Open with VLC.
Which ones of these 4? And are reflected on the video.
But the angle they got doesn't show me.
Okay.
Like number. She's the RNU manager.
Mhm.
But you didn't see what happened. No way, she's trying to find out what happened. She was on the other side of the building. She had no way to know.
And she's just saying what you said.
Yes.
Up an allegation that you heard him.
There wasn't any.
Takes the team effort. Yeah, thankfully we had done it earlier last week. We're back on the record. Investigator Jones, if you would please ID Mr. Scott in this video along with the date and the time.
Mr. Scott is a gentleman at the med card with the scrubs on, and the date is February 13th, 2022. And it's at 3:38 and 34 seconds.
And if you would, let's fast forward to 3:31:50 and pause it, please. $3:31:50.
She seemed at the time. Like, here.
Thank you. Go back. I can't see this.
Keep going on.
You're at 3:35 right now. Keep going.
Keep going.
You'll need to go back more towards the beginning of the video, sorry.
Keep going.
Keep going.
Yes. Keep going.
You can go run it if you want.
That's good enough. That's 3:31.
Okay,
Oh, I
I
got
know.
you.
if you would, Investigator Jones, we're gonna begin playing this, and I'd like you to identify the patient when the patient comes into view, please.
The patient is in view on the rollator with a white shirt and jeans.
And if we could, let's fast forward to 3:32:19.
Just like.
And when you get to 3:32:19, if you can describe what you see there, please.
Mr. Scott is at the medication cart talking to the resident with the resident's back was first turned and he turns around. He's talking to the resident.
As he speaks, what's Mr. Scott's demeanor like?
Looks like he's agitated.
We're going to continue playing through, and when we get to 3:32:57, please describe what you see.
Mr. Scott pulled his mask down. He's talking to him. He pulls the resident, pushes him back, grabs him under his arm while the resident is pulling the rollator and drags him off.
Could you stop that video, please, and switch to video 2? At 3:33, what is, just detail to us what is seen at 3:33.
At 3:33, that's a room where there are other workers sitting in the chair.
If you'd like to just let it play, you can as well.
See other workers and patients there entering the room. In the far distance is a patient coming up the hall in the rollator.
And that's the patient involved in this incident, is that correct?
That is correct.
And if you're able to move forward to 3:33, you can. If you'd like to continue playing it, we can do that as well.
Mr. Scott,
So the second video, is this a different angle than the first video?
yes, this is a different angle in the room.
So at 3:33, what will we see from this angle?
From this angle, if you look down in the bottom right-hand corner, you will see Mr. Scott with the resident.
And does the time correlate to the previous video that we saw with surveillance?
Yes. There you see the resident and you see Mr. Scott behind the resident dragging the resident.
Let's
With-
stop for just a second and rewind this. We need to stop at 3:33:01. And I know with surveillance, it's not always the easiest to navigate. Just a little bit farther, please. Okay, we can begin playing now. just as it plays, describe what you see as best you can.
Mr. Scott is behind the resident, dragging him with the rollator. Take.
Ideas to come out.
It should just be-
And then what happens?
He's placing him in the chair. And he's pulling the patient is pulling the rollator with him.
It's skipping. It's skipping. While we are waiting for the video to play, tell me what you saw when you reviewed the surveillance coverage.
What I saw in the surveillance coverage was the resident came over, Mr. Scott appeared agitated and he was lifting his hands, and then he lunged towards the resident, and the resident turned around and hit Mr. Scott, and then he put his arms up under the resident and drug him over to the chair while the resident was pulling the walker rollator with him.
And what was the distance that he drug the patient?
Approximately 21 feet.
And then what did he do with the patient after he finished dragging him?
Once he drug him over, he aggressively put him in the chair. Then he took the rollator and slung the rollator over towards the round circular table. And then he later came back and pushed the rollator over to the resident.
And if we need to set up video on a laptop so everyone can see it without this jumping, we can, but let's let it play. How many individuals are present when he throws that walker?
It was about 6 people in that room.
So Mr. Scott did this in front of cameras and in front of 6 individuals.
Yes.
And can you tell this board again what the resident did that made Mr. Scott so angry?
The resident continually asked for food.
And what is the resident's diagnosis?
He has dementia and he had some behavioral problems that are moderate.
Thank you. That's all the questions I have.
Brian, any questions for this witness?
Yes, Your Honor. Ms. Jones, can you tell us what you can, as there's no sound on this video, can you tell us what you can say with certainty was said in the video?
No.
As you investigated, was there any injury to the resident?
There was no known injury, no.
You had testified that Mr. Scott did not report it to the facility. And is it your testimony that he did not report it to a supervisor, or that there was not a formal report made?
The report was made after there was conversation among workers at the facility. And then there was a report to the director of nursing and the nursing home administrator. And that's when they pulled the video footage and looked at the footage, and a formal report for the facility was made.
Are you aware that Mr. Scott did speak with the family and inform them of what had taken place?
No.
If you would, you indicated that at the beginning of the video number 1, that Mr. Scott looked agitated. You don't know sufficiently to testify under oath that he was agitated, do you?
I don't, but I saw his hand gestures with the resident.
What legal training or professional training have you had in body language?
No,
If I could, I don't believe these were discussed as part of the testimony, but there are a few statements that are part of the evidence, the exhibits that were presented to the panel. Can you tell us, there is one from a resident and then the others are from employees, is that correct?
let me look at those.
Certainly.
Which exhibit, Mr. Ryan?
I'm sorry, that's exhibit 9.
Okay, the first is from a Connor McGowan who works at the facility. It's a statement. The second statement is a Jamecia Harrison. She works there at the facility. Then there's a Michelle, like Ryan, the LPN. She works at the facility. And Leanne Walden works at the facility.
Are you familiar enough with the video to tell us where each of these individuals come into play during these 2 videos?
No, I don't know them by person.
Do you know if Connor McCulgan is reflected at all in the video or if he witnessed it in person?
Based on the report that I received from the facility, he was the person that was standing towards the door.
Are we talking about the first video or the second video?
I think that's the first video where there's someone that's like in a wheelchair heading out. Second video.
As part of your investigation, did you speak to Connor?
No.
Is Jamaica Hairston reflected in the video?
I don't know how she looks, so I don't know.
Is Michelle? I believe that's Byers or
I don't know who she is now.
do you know if she personally observed what took place?
No, she says that Connor came and got her on hall A, telling her that Tyler and the resident were fussing and talking and had a run-in.
And then Leanne Walden, is she reflected in the video?
I don't know her, so I don't know.
What was the date of this incident?
February the 17th. But the incident occurred on February 13th. The report was on the 17th.
And the 17th is the date that he was terminated.
I'd have to go back and look at his termination report for the specific date.
After this incident, do you know if Mr. Scott worked additional days before he was terminated?
I don't know.
Do you know if he worked with this patient in question after this incident?
I don't.
As part of your investigation, were there any other complaints or concerns about Mr. Scott's treatment of patients?
That was not the focus of what I was investigating. It was just specifically on this incident.
That's all, Your Honor.
Thank you. Any questions from the board panel for this witness? Any follow-up, Ms. Salzman?
No, Your Honor.
Any further testimony from this witness?
No, Your Honor.
You can be excused. Next witness, Ms. Altman,
That's all the witnesses we have. We rest, Your Honor.
Mr. Rhymes,
And we would call Tyler Scott, Your Honor.
may proceed.
Could you please give us your full name?
Tyler Daniel Scott.
Be sure and speak into. the-
Tyler Daniel Scott,
And where do you reside?
4791 East Crescent Lake Drive,
Where were you trained as an LPN?
Meridian Community
Okay.
College. Sorry.
The court reporter's behind you, but she's asking that you slow down just a little bit.
Meridian Community College,
When did you begin work at Poplar Springs?
November of 2011,
And you were employed there until when?
February 17th, 2022.
During that time, were there ever any complaints about your treatment of patients?
No,
Did you have any disciplinary activity related to your interactions with patients?
no, sir.
Now, let's go to the date in question. You've seen the video. Had you seen the video before today?
No,
If we need to look at it again, we can, but can you tell us what was taking place when we first see you at the beginning of video number 1?
I just come on to start my shift and was getting a report from the previous staff, and the resident was upset because he was hungry because they didn't wake him up to eat lunch.
And how did you know that?
From the resident telling me I'm getting it in a report.
We don't have the benefit of sound on the video. Can you tell us only what you can specifically recall being said between you and the resident before there was any physical contact?
I was trying to explain to the resident that we just came on the shift was why I was pointing at the medicine cart, and I was trying to explain, give us time, let's get the shift started because we started late, that we were getting something to eat.
You heard the investigator say that you appeared to be agitated. Is that an accurate reflection of your state of mind at that time?
No,
What was your attitude?
I believe I was calm in the beginning of the situation from the aspect of I was left alone and everyone else left. The people that were in the video did not help. They left.
Okay. How much had you dealt with this patient in the past prior to that day?
I was his nurse 5 days a week. So as long as he's been there.
Okay. Can you tell us what led to the first contact between the two of you?
He was trying to push his walker into me.
Then you grabbed his walker and pushed him back.
Yes.
Tell us what happened next.
Right when I was trying to get him back, I was just trying to get away from him. He would reach up and slap me, and I took him under the arms to try to get him to a chair so I could get him seated so I could get away.
Okay. What type of training had you had for dealing with these types of situations?
None.
So in the entire time you were at Poplar Springs, you had not been given specific training by your facility?
No, we would have in services every other payday, sometimes once a month, and they would read from the same sheet that's in the in 2011. There were no further examples.
We see you go behind the resident and pull him across the floor. The testimony is that that was a distance of about 21 feet. Do you agree with that distance?
No,
How far do you think it was?
10 to 12.
And can you tell us any elaboration as to why you think it's a shorter distance than what the investigator concluded?
If you go diagonally versus walking around items, I went to the first chair that was near me.
Okay. Then was it a normal procedure for you and other LPNs or other nurses to grab a patient from behind and pull them in that manner?
No,
So why did you do it?
I thought it was the best way to get distance between us is to get him sitting.
Okay, I'm not sure the court reporter understood that, so sorry. Let's try that again.
I thought the best thing would be to get him to a seated position so I could get distance between us since it was just me and him.
Since it was just the two of you.
Yes.
Mr. Ryan, we're still having trouble with the client
Okay.
speaking too fast. Please try to slow down. She's trying to take down everything that's being said. That's why we're asking to slow down.
I believed the best thing to do was to get him to be in a seated position so I could get away. Due to being alone.
Then, as you put him in his seat, the testimony from the investigator was that you aggressively put him in the seat. How do you respond to that?
No one was there to help. I have asthma. I was losing grip on him, so I picked him up with the last bit of breath I had to put him in the chair. There was no aggression.
At the time that we're seeing here, were you angry at this patient?
No,
Were you angry at the situation?
no,
Then we see you take the walker and throw it, as was testified, across the floor. Tell us what happened.
as I was went to walk away from the resident, he went to grab his walker to stand up again. So I was worried that he was going to get up and try to hit me again. So I got it away from him. In hindsight, probably shouldn't have did that, but I went back and if you continue the video, within a minute, I went back and got his walker and returned it to him.
You said in hindsight, I shouldn't have done that. Were you angry when you flung the walker?
No, sir,
So what was your purpose at that time?
was to get away.
What did you do after he was seated?
I walked away.
Who did you first speak to after you walked away?
Michelle at first, and then said Jamaica wanted me to call her, so I called Jamaica, who was not at the facility.
Okay. And do you know Michelle's last name?
Ryan's.
Can you tell us what you told her?
I told her that why he was upset. I said that, he was getting aggravated. He hit me and I placed him in a chair so I could get away.
And trying to talk as slow as you can. What was the rest of that conversation?
That she talked to Jamaica and Jamaica wanted me to call her. So I called Jamaica.
And what is Jamaica's role at the facility?
She's the RN unit manager for that specific hall.
Okay. And you said she was not working that day, so you called her on her cell phone?
Yes.
Tell us what that conversation was.
I told her the same thing I told Michelle. She told me I needed to contact the DON, which I did by text.
And who is the DON?
Stephanie Martin.
Do you recall specifically what that text was?
Me and the resident got into it. He hit me and then I put him in a chair, I was charted as well.
So you made a notation in the chart that reflected what?
Yes, I did an incident report and contacted the family.
Tell us about contacting the family.
The family was kind, asked if I was okay and said that we don't know what we're going to do with his behaviors.
And that was on the 13th.
Yes,
You worked again the next day, is that right? How many days
Yes.
did you work until you were terminated?
I worked the rest of that shift because I worked 3 to 11. So I worked the rest of that shift on that same hall and I worked the next day on 3 to 11. I was due to come back on Friday, so it might have been Wednesday too. I don't really recall.
Have you ever intentionally caused harm to a resident?
No,
Have you ever negligently, to your knowledge, caused harm to a resident?
no,
Was it your intent to do anything that would cause harm to this resident?
no.
What have you learned from this experience?
I've learned a better way to handle situations and to walk away from it, despite being the last one left to it.
Now, your license has been suspended. What are you asking the board to do?
I want to get my license back, no matter, if I got to do classes or whatever.
Do you have an anger issue?
No,
Can you tell us, Amanda Culpepper, I believe I have that name correct, respondent one, wrote a letter. Can you tell us how long you worked with Amanda Culpepper?
almost a year and a half.
And how frequently did you have the same shifts as Amanda?
Majority of the time.
There are other people that are reflected in the video. Can you tell us what efforts you made to contact them?
I tried contacting the 2 ladies that were in the video and get a statement. I couldn't get in touch with them. They were the only ones that saw the whole thing, and there was no mention of their witness statements, which they did do for the facility.
So you believe there are other statements that were given to the facility that are not here today?
Yes,
If you can tell us, as not the names of any residents who observed this, but can you tell us who is reflected in the video? And if you need to look at it again, we can.
the 2 ladies that were sitting in the chairs across the room their names were Ebony and Zaylee. And then the first female that was in it was named Rachel. The nurse that came into it was Michelle at the end. And I don't recall the last person.
So are these individuals you just mentioned the ones that gave the statements that are not included?
Ebony and Zaylee. Yes, sir.
Okay, say that.
The ones in the video sitting in the chairs, kicking their feet. The left one to the leftmost chair is Zaylee, and in the middle is Ebony.
That's all we have, Your Honor.
Ms. Osmond?
Mr. Scott, you testified that you were not agitated in this video. Is that correct?
Yes, ma'am.
You also testified that you were calm for the situation. Is that correct?
Yes, ma'am.
What do you do when you are agitated with a resident?
I don't react.
So in this day, you acted in a calm manner. That's your testimony.
I believe so. Yes.
From the video, you did not appear agitated. That's correct.
Yes, ma'am.
Why did you shove the resident backward?
He was trying to hit me with his rollator.
Let's go back to that. He was trying to hit you. Did he hit you?
Push it into me. Yes.
He hit you with the roller?
He started to. Yes.
He started to, or he hit you?
I stopped it with my hand.
And then what did you do?
Try to prevent him from continuing to push it because he pushed it.
So you pushed the roller backwards and pushed him towards a table that also moved in the video. Is that correct?
Slightly. Yes.
Is slightly okay?
No.
Are you sorry?
Of course. I love my people that I took care of, and I treated him no differently than any other shift, even after this occurred.
You testified that you were not angry about the situation with the patient. Is that correct?
Yes,
And you testified that you drug him all the way across the room because that was the closest chair. Is that correct?
besides a sitting stool that rolls is a danger to falling, yes.
And the reason it appears that you so aggressively set him down in the chair is because you have asthma. Is that correct?
Yes, I was losing my breath and didn't want him to fall.
You were putting him in the chair, I think you testified, because you were worried he was going to hit me again. So you were concerned that this elderly patient was going to assault you again after you put him in the chair?
Yes,
And that's why you threw his roller across the room?
I was worried for that, yes.
Do you think you have an anger management issue, Mr. Scott?
No,
Have you taken any anger management classes?
no, ma'am.
So since you were terminated in February of this year, you've taken no anger management classes?
No,
Have you taken any type of continuing education classes?
no.
What have you done since February of this year, Mr. Scott?
I did agency at 2 nursing homes until I found out about my license being suspended, and then I stopped nursing and I went to work at O'Reilly's.
Is this patient that we see in the video the only patient that has dementia that you cared for while you were an LPN?
No,
And it's your testimony that you thought this was the best way to get distance. Is that correct?
I didn't know what else to do.
And if I told you that roller never touched you until you started pushing the resident backwards, would that be correct?
I'm not sure.
I can show it to you.
Okay.
Get back again.
No,
Did it touch you before you started pushing?
no, but he was in the
President
process of trying to.
Were you really concerned about your safety with this individual, Mr. Scott? Or did you just?
Yes, in any situation.
Do you lose your temper or were you concerned about your safety?
I was concerned for my safety.
I have no further questions.
Any question from the board panel for Mr. Scott?
I certainly do.
Do you have some? Yes. We'll begin.
Mr. Scott, how many hours were you scheduled to work on this shift?
8,
And how many days straight had you worked prior to this incident?
1,
Did you attend the facility's quarterly abuse and services?
I tried to.
Tried to, or you did?
I'm not sure.
My understanding that Poplar Springs has a licensed Alzheimer's unit, which means that they have a monthly dementia in-service. Did you ever attend these in-services?
I never recall a monthly one.
Do you feel, not do you feel, I think it's common sense, could the resident have been harmed by your actions?
I don't believe he was.
You don't feel like there could be any harm? I didn't say was there harm. Do you feel like he could have been harmed by your actions?
In some instances, I do believe that he could have been sad about it, but he was right back at the end of the shift doing the same thing.
Physically harmed? Do you feel like he could be physically harmed by your actions? Could a shoulder have been dislocated?
No,
Could a fracture have occurred?
I don't believe so.
So I want to follow up on that last question with Mr. Cummings. So he asked about the physical harm. What about the psychological harm?
Do you mean, do I believe he had any, or do you believe he could have had any?
I'm asking, do you believe you could have caused him psychological harm by doing the action in which you did?
In some aspect, yes, but I don't believe it did.
Okay, do you feel like this was the appropriate reaction based on the fact that he is an Alzheimer's patient? And it's pretty obvious that this is combative behavior.
You say the first part again? I'm sorry.
Based on what we're seeing here, he's an Alzheimer's patient. He was displaying combative behavior, which is known to them. Do you feel like you held the appropriate reaction?
No, every instance can go better in hindsight.
And then, have you ever had any complaints of abuse related professionally or personally?
No,
And then finally, you do realize by taking his walker away, you also violated his rights to move about freely.
Yeah.
So I think you do realize this is two different aspects. It's not just abuse, but a violation of those rights.
yes, ma'am.
That's all I have.
I just have a few questions. In your medical history, it shows that you have taken some medications on a pretty regular basis since 2019. Can you tell us what those are?
Ultram and Norco for a bulge disc.
Okay, so hydrocodone, acetaminophen, 60 every 30 days since January of 2021.
Yes,
And you said that's because of
bulge disc.
a bulging disc. Prior to that, like from October of 2019 to September of 2020, you were taking tramadol,
Yes,
or
same problem.
so you've had a bulging disc problem since October of 2019.
Say that verbally.
Yes,
Okay, now you testified that you have asthma.
yes,
There are no medications for asthma.
I take albuterol as a PRN and then Advair daily when my insurance, I had insurance.
Okay, so in this incident, when was the last time you took medication for your asthma?
Same day,
Do you remember what you took?
Advair.
Okay, and you were wearing a mask,
Yes,
and on the video, if I recall, after you put the patient in the chair and threw the walker, you put your mask back on.
yes,
And I'm just, obviously I was not there, I'm observing, but it didn't seem to be, you did not seem to be in any respiratory distress
I was when I walked off the video.
after you put your mask on. So you were in respiratory distress and then you put your mask back on.
Yes, ma'am, they're breathable.
So what did you say to the patient?
At which point? At any of it, all of it?
Well, let's just talk through it. What do you recall saying to them?
I tried explaining to him that we had just came on the shift to give us just a few minutes, let us get started, and we would get him some food. And he got agitated from there. The reason I pulled my mask down was because he said he couldn't talk to me with that D word thing on my face.
And that's all you recall saying to him?
Yes, and trying to get him to calm down.
So you testified to that you were, and correct me if I'm wrong, I'm just looking at my notes. So you commented that you were, due to being alone, you were trying to get away.
Yes, ma'am. The people in the video before that were all around him and they were helping agitate him. So I told him to spread out and just stay near. And no one came to help when it came to that point.
Were you irritated, frustrated at all that you were kind of left alone?
No, ma'am. It was common for my shift. I usually handle most of the stuff.
Okay. All right, so it's a little hard for me to understand how a patient who is dependent on a walker for mobility is a threat to you when you can walk independently.
He can walk without it as well. He's just not as fast.
He's not as fast. So why didn't you just walk away from him?
I should have.
Okay, so there are several statements by witnesses that I think were alluded to a little bit earlier. One is Michelle Byers. Is that right? Do you know her?
Yeah, she worked on the other hall.
So she, and these are part of the record, so I mean, clearly I wasn't there, but this is what she said. That Connor, and who is,
He was the 18-year-old guy that worked at the door during COVID,
worked at the door.
in and out, scanning foreheads for temperatures and
Just for the record, we're referencing exhibit B9.
Oh, thank you. That's why you were there. So Connor came, and this is Michelle, Connor came and got me off a hall, telling me Tyler and I assume this is the patient's name, were fussing and I don't know what that one is. Oh, physical, thank you. And then she says, so she was on the other hall. I ran to B hall and Tyler was telling the patient he needs to be respectful. The patient was cursing at Tyler and I asked him to calm down and that wasn't nice. I asked if he wanted to go to his room and he said he was okay. And then she contacted Jamaica, I'm sorry, about incident. Do you know if that's true or not?
yes, ma'am.
Okay. You know that it is true?
Yes, ma'am.
Okay, and then there's, I just want to give you the opportunity to explain. This is a witness, Leanne Walden. Who is she?
He was the infection control nurse at the time, working on the lock unit.
Okay, so this was the next day, and she said, I asked Tyler Scott what happened between him and the resident. Tyler stated, quote, resident threatened a female staff and I got between them. Then resident hit me and I moved him to the chair, end quote. I asked, quote, did you hurt him? End quote. Tyler stated, quote, I just put him in a chair, end quote.
Yes, ma'am.
Do you have any response to that statement?
I believe that's what I stated, but I did say that he's not hurt. He had no injury.
And I think, well, I know Ms. Culpepper already responded to this, but when you restricted the patient to the chair after dragging him across the room, and took his walker away, you basically put him in restraint. So you're saying he was able to walk, but we can't see that. And you also said that you were putting him in a chair to protect yourself. Is that correct?
Yes, and him as well, so he wouldn't fall.
I don't have anything else.
Okay. Any follow-up, Mr. Rhymes?
No, Your Honor.
Sauce?
No, Your Honor.
Mr. Staff? believe you testified that you spoke with the family about this incident.
Yes, sir.
Was that a part of your facility protocol to do that?
Yes,
Did the family file a complaint with the facility regarding this incident?
I don't know.
Prior to the date of this incident, had you had other instances with this particular patient?
No, sir.
Anything further from the panel? Any follow-up from the attorneys? There you go. We can begin with your closing statement, counsel.
Mississippi Code annotated 73-15-29-1 provides that the board has the power to suspend or revoke the license of a nurse where it's proven that the nurse has violated any of the provisions within that section. Today, the evidence has clearly shown that on or about February 13, 2022, Mr. Scott violated Mississippi Code annotated 73-15-29-1C, and that he willfully and negligently acted in a manner inconsistent with the health and safety of a person under his care, and that he additionally violated Mississippi Code annotated 73-15-29-1K, and that he engaged in conduct likely to harm the public. I don't think any of us today would argue that a patient that has a diagnosis of dementia or Alzheimer's is anything other than a vulnerable adult under the law. These patients are placed in homes because family can't sufficiently care for them and can't handle the special needs required for these types of diagnoses. As an LPN, Mr. Scott's inability to manage or contain his anger when caring for a dementia diagnosed patient has been clearly confirmed through surveillance coverage. And it shouldn't be lost on anyone today that Mr. Scott never reported the incident to administration either. In fact, today, Mr. Scott testified that he was not angry on the video. He was not agitated. He testified initially that the walker was pushed into him when in fact, the surveillance shows that the patient pushed the walker towards him. He grabbed it, shoved the patient backwards, and then the patient slapped him in retaliation. Mr. Scott has testified that he's taken no anger management classes since he was terminated for this incident. He's taken no legal education classes for this incident. He doesn't appear to feel sorry for this incident. In fact, he thinks that he did the right thing out of the circumstances because he was scared that the patient might hit him again. This evidence today shows that Mr. Scott was unable to control his temper and that his actions have resulted in what could have been very detrimental injury to the patient on a physical level. I would ask this board panel to consider revoking Mr. Scott's license to practice nursing in this state in order to safeguard the life, health, and welfare of the public and the patients under his care. Thank you.
Grimes.
Mr. Scott has been an LPN working with vulnerable adults, dementia patients, people that we all care very much for. And during that time, there's been no evidence of any remotely inappropriate actions by Mr. Scott other than this one incident. We're not here today to try to minimize the incident or the importance of this patient's well-being. We've heard a lot of terms like aggressive and anger, and we just heard a question about why Mr. Scott has not taken an anger management class. I've had that discussion with Mr. Scott. I've had serious discussions with him about whether or not he was angry, whether or not he had an anger problem. And that was early on. If he had taken anger management classes, then in a sense, that would have been a concession that he had acted in anger. He may have been frustrated. You've heard his testimony. He may have wished there was somebody else to help him, but he did not act out of anger. I wish we had sound. I believe the sound to this video would clear up some of the discrepancies that we have here. Mr. Scott has been devoted to his patients and wants to continue to serve patients. He's willing to do whatever the board wants him to do, whatever the board believes would make him a better nurse. But he's simply asking for the right to continue to be a nurse. Thank you very much.
Thank you, counsel. Ms. Osmond, what's the next matter on the docket?
What's the next matter? I believe it's Roby, but I didn't know. I think the board panel may have indicated that they had to make a change, so I'm not sure based on availability. Yesterday it was Roby when we left, but does the board panel wish to proceed with Roby currently?
Present.
Is Roby present? Yes, she is.
Okay, at this time, I entertain a motion for the board panel to go into closed determination regarding whether executive session is necessary in this matter. Second. Been moved and properly seconded. All in favor, please signify by saying aye.
Aye.
Any opposed? Motion carries unanimously. I now entertain a motion for the board panel to exit to executive session.
I will make it.
Hold on.
Sorry.
For deliberation on license number P 326-724.
I'll make that motion.
But it's been moved and properly seconded. All in favor, please signify by saying aye.
Aye.
Any opposed? That motion carries unanimously. The board panel now exit to executive session for deliberation on this matter. And I think we will try to be back by we'll try to be back by 12:30, although it's possible it may be sooner, but I will let council know. Thank you.
Thank you.
Thank you, everyone, for your patience. We are back on the record. I'll entertain a motion for the board panel to return to regular session.
I still move.
It's been moved and properly seconded. All in favor, please signify by saying aye.
Aye.
Any opposed? That motion carries unanimously. The board panel is now back in regular session. Following deliberation on license number P 326-724, the board panel renders the following. The license is revoked. A copy of this order will be forwarded to the licensee within 30 to 45 days, conclusion of this hearing. Are there any questions? Hearing none, that concludes this matter. Parties are excused. License number P 334056. Shawanda Roby. Board panel will take up that matter beginning at 12:15.
Let me double check, Jan. Wanda Roby? Oh, I'm sorry. Miss Roby? Over here yelling back here. Yeah.
Thank you, Jan. All right, as with the other matters, we will begin with opening statements. We will hear arguments from both sides. At the conclusion of that, we will have closing statements. Prior to the closing, of course, there will be an opportunity for questions for the witnesses. Once we complete the arguments again, we'll have closing statements. The board will make findings of fact and conclusions of law and render its decision, a copy of which will be forwarded to the licensee within 30 to 45 days of these hearings. I will note for the record that there is a quorum present. These hearings are open to the public. At this time, I ask that all witnesses be sworn in. All right, thank you. Ms. Roby, you are not represented by counsel today, is that correct?
No, sir.
You understand you have the right to be represented by counsel?
I didn't at first, but now I do. But if I wasn't gonna get in anyone anyway.
Okay, so you are ready to proceed with this matter today.
Yes, sir.
You understand you have the right to have witnesses testify on your behalf?
Yes, I do now.
You understand you have the right to have subpoenas issued by the board on your behalf?
Yes, sir.
Okay, you are ready to proceed.
Yes, sir.
All right, thank you, ma'am. Any preliminary matters, counsel?
Yes, Your Honor. I would like to introduce into evidence exhibits B1 through B13 and respondents exhibits R1 through R3.
Have you had a chance to look at those, Ms. Roby?
Yes, sir, I have.
Objection to any of those exhibits?
No, sir.
Right, they will be admitted, or they are admitted, rather. We'll begin with opening statements. Counsel.
We're here today for a hearing before the board panel to discuss possible disciplinary action against Ms. Lewis. Mississippi Code annotated section 73-15-29-1L gives the board the authority to discipline a licensee for unprofessional conduct as identified by the board in its rules. Mississippi Code admin part 2820 rule 1.2F4 states that refusal of a drug screen is unprofessional conduct. On or about November 24th, 2020, Ms. Roby was employed at the Bolivar Medical Center long-term care facility as an LP. It was discovered that 169 narco pills were missing from a locked cabinet which contained medications on hold to be destroyed. There are also scratch marks on that box that could have been the result of someone prying the box open. These marks had not been noticed before. Subsequently, the facility conducted drug screenings on all employees. During this drug screening process, Ms. Roby became very emotional and was leaving the facility before testing. When questioned, she said several times that she did not want to lose her license. She stated she did not take the pain medication, but said that she had smoked marijuana on Sunday and took a pain pill on 11/23/2020. She stated the pain pill was a narco. She was informed she needed to do a drug screening and refused. Pursuant to the authority found in Mississippi Code annotated 73-15-29-1, this board panel has authority to discipline Ms. Roby as it sees fit.
All right, thank you, counsel. Ms. Roby, if you have an opening statement, you can make it at this time.
Okay. I'm here to take full responsibility for my actions, but I also know that I am human and I am not without fault. And I made a big mistake in my judgment on that day, and I am sorry.
Thank you, Ms. Roby. Counsel, you may begin.
The board would like to call Ryan James as a witness. Please state your name, county of residence, and current place of employment for the record.
My name is Kevin James. I live in Rankin County. I'm employed with the Mississippi State Board of Nursing.
How long have you worked for the board of nursing?
8 years.
And during that time, have you participated in any investigation resulting in disciplinary action against the licensee?
Yes,
And is it part of your duties with the board to investigate complaints received related to individuals licensed by the board to practice nursing in this state?
yes, it is.
If you would please turn to what's been marked exhibit B2 and ID that document, please.
B2, excuse me, exhibit B2 is a licensure documentation.
And when does it say that Ms. Roby was first licensed in Mississippi?
She was first licensed in 2/1/16.
And what type of registration she held, licenses she held since 2016?
Licensed practical nurse.
Can you go to exhibit B3 and ID that document for us?
Exhibit B3, excuse me, it's Mississippi Board of Nursing licensure verification.
And what does it show as far as her license is concerned?
Her license is currently active.
If you go to B5 for us and ID those documents,
B5, excuse me, is a notice of complaint and memo stating that she had received service.
and on the second page of B5, can you ID that document?
Yes. Actually, B5 is a complaint filed by the Mississippi State Board of Nursing.
And what does the complaint state that Ms. Roby is charged with?
Said the respondent violated Mississippi Code, I noted 73-15-29-1L. Of professional conduct as identified by the board in its rules. Excuse me, 30 Mississippi Administration Code 2820, Rule 1.2 F4. Refused to submit a drug screen.
In that second paragraph, can you read what the facts are that support that charge in the complaint?
Sure. Charge 1, the respondent violated Mississippi Anotic Code 73-1L, and that the respondent has engaged in unprofessional conduct as identified by the board in its rules, namely practicing the profession while under the influence of alcohol or other mood altering substances as evidenced by any of the following: refusing to submit drug screening.
If you could go to B12 and identify that document for the board, please.
Exhibit B12 is the work schedule of the respondent.
And what does that document show? On November the 24th, was Ms. Roby scheduled to work?
Yes, she was.
And on exhibit B6, can you identify that document for us as well, please?
Sure. Excuse me. Exhibit B6 that states that Ms. Roby was terminated from Bolivar Medical Center long-term care facility on November the 30th, 2020.
So we can say from this letter and the work schedule that Ms. Roby was employed at Bolivar Medical Long-Term Care Facility on November the 24th, 2020.
Yes, we can.
Can you go to B7 and identify that document for me, please?
Sure. B7 is a letter from Patsy Rowe, a nursing home administrator at Bolivar Medical Center.
Can you tell us what that letter states happened on November the 24th, 2020?
Yes. Letter states on about November 24th, 2020, Ms. Rowe was employed at Bolivar Medical Center long-term care facility as an LPN. It was discovered that 169 narco pills were missing from the lock cabinet, which contained medication to be held to be destroyed. There were also scratch marks on the box that could have been the result of someone trying to pry open the box open. These marks have been, been noticed before. Subsequently, the facility conducted drug screens on all employees. During the drug screens, Ms. Roby was very emotional and was leaving the facility before testing. When questioned, she said several times that she did not want to lose her job, her license rather, sorry. She stated that she did not take the pain medication, but that she smoked marijuana on Sunday and took a pain pill on 11/23/2020. She stated the pain pill was a narco. She was informed that she needed to do a drug screen and she refused.
So Ms. Roby admitted to not only smoking marijuana, but also that she had taken a narcotic.
Yes.
And going to B13, would you identify that document for us, please?
That would be the PMP for Ms. Roby.
Can you tell us what this document shows?
It gives the dates of 9/28/2019 through 9/28, I'm sorry, 9/28/19 through 9/28/2020.
And what does it show is under the prescriptions?
It shows tramadol, 50 milligram tablet written 11/30/2020, and it's still the same date.
So this prescription was filled for about 6 days after Ms. Roby refused the drug test and admitted to taking narcotic.
Yes, it was.
Could you please go back to exhibit B8 and we'll identify that document for the board, please?
BA would be the drug and alcohol-free workplace document from Bolivar Medical Center.
And on page 2 of that document, what does it say in our testing if there's a refusal for drug testing?
It states that refusal test will lead to termination.
So Mississippi Code, Admin Code Part 2820, Rule 1.2 F4 states it is unprofessional conduct for licensee refuses a drug test. Would you say that Ms. Roby is in violation of that code?
Yes, I would.
Good question, John.
Ms. Roby, do you have any questions for this witness?
Can I ask him about the dates? That he said that they gave me a drug, they tried to give me a drug screening, and the date that I was terminated. The day that they tried to give me a drug screening was November the 17th. As of what day they terminated me, I do not know. Because I didn't go back, but the drug screening date was on the 17th of November.
Okay, did you have any questions for him?
No.
Any questions from the board panel for this witness?
No, sir. No, sir.
Any follow-up counsel?
Yes.
This witness can be excused unless you have some more testimony. You have another witness, counsel? Ms. Roby, you may share with the board your side of this matter.
I'm not trying to make excuses for what I done. I did do what was said except for the narco. I did not know at that time that my mom had given me an ibuprofen, but this was a time when COVID was going on. And my birthday was November the 15th. I had took a week off work. We had a big party, a big celebration with some coworkers. And like I said, I did consume the marijuana. That is my fault. It just was a time where the world was in turmoil. Before that day that I had taken off of work for my birthday, I had worked double shifts all the time there. I mean, we was under a lot of stress. I had seen a lot of people die. A lot of my family members had died, and I just was just relaxing at that time, and I made a wrong judgment in consuming the marijuana. When it was time for me to go back to work on the 17th, I was supposed to return to go back to work on the 17th of November. That I had been hurting that weekend too, but that day I was hurting, and I didn't know why at that time. So I called my mom and I asked her, do she have something for pain? Because I didn't. And she was like, yeah. I was like, Mom, would you bring me some? I'm hurting really bad. I got to be at work at 3. So she got off work and she brought me a pill, which I thought was a Norco, because I did know that she had a prescription for Norcos. And I was willing to take one that day, not knowing what was wrong with me. But I was hurting, and I knew that we were short of staff at that time. We were short of staff, and I didn't want to leave anybody left at work, because we always talked about it, because COVID was going on, how short we were. I would get to work sometimes, we only had one CNA, and we all had to do, a tremendous amount of work. And so I did take what she had given me. And so when I got to work, that's when everything was going on. But I did refuse the drug test because I admitted to consuming the marijuana and what I did think was a narco. When they did call me in, she was like, "Shawanda, what's wrong? Just explain." I was like, I did not steal the pills, which I know they did find out I did not steal the pills at a later date. But by then I had already lost my job. It was too late. I do know why now, why I was hurting so bad. Thanksgiving morning, I had to call the ambulance and for them to take me to the hospital. And my diagnosis was ovarian cyst. So that's why I had been hurting so bad that during that time. And I didn't know. Yes, I did have a prescription for Tramadol. I do not like taking pills. I don't take pills. I mean, I got to have blood pressure pills. I had to make myself take. But that is the only reason why I did take the pain medication from my mama. But like I said, I'm not here to make excuses. I'm here to admit everything I've done. I'm saying I did. I did take a pain pill. I took somebody else's medication, which is still wrong. And I know that. I do know that. So I'm not putting blame on anybody. It's my responsibility. I have already lost a lot because of this. Not only that, I've been shamed. That was my reputation. That was my name. And so, like I said, I've already lost a lot. But I'm here to accept whatever decision you guys make. And that's all I have to say.
Thank you, Ms. Roby. Any questions for Ms. Roby, counsel?
Yes, Your Honor.
May proceed.
Will you state your name, your residence, and your current place of employment?
Shawanda Roby. I stay in Drew, Mississippi. My current placement is Allegiance Hospital, Greenville, Mississippi. But I don't work at the hospital. I work in an IOP. It's off the facility.
Could you tell the board your educational background? Where did you attend school?
I attended Drew High School. I went on to Mississippi Delta Community College. That's where I got my CNA certification. I also got my cosmetology license from Greenville. And I went to Terminated College to obtain my license practical nursing
What year was that?
in 2015.
Can you tell us where you've worked over your career?
I've worked at Bolivar Medical Center, Cleveland Nursing and Rehabilitation, and Allegiance Greenville Hospital.
Did you have, at any point in your other careers at other places, have you had any disciplinary actions or had any drug tests or anything like that?
No, sir, I haven't had any disciplinary problems.
Prior to these allegations made against you today, have you had any previous disciplinary actions that have been before the board?
No, sir, I haven't.
Are you currently in any type of treatment program?
No, sir, I'm not.
Any counseling?
No, sir, I'm not.
Can you tell us kind of what happened on November the 24th that night with you refused the drug test? Kind of circumstances surrounding that?
On November the 17th, when I made it in to work, everybody was in a panic. Like I said, I had took time off from work, which you have the records of me working. And like I said, my birthday was that November the 15th that I had taken off. I had took off a whole week and I knew I did consume the marijuana. Yes, I did. So I didn't want that positive drug screening on my record. I'm admitting to it. That's what happened. And like I said, I thought my mom had given me a narco. So when I get home, I'm crying hysterically and I'm telling her about what happened. And I said, I admitted to her, mama. And she said, I didn't even have any narco at work when I came over to your house. I bought you a 800 milligram ibuprofen. And that's what she said. So at that time, I was in a lot of pain. I really didn't even just look at the pain pill because normally I would look up stuff because like I said, I don't take pills, but I did not. And so she was like, why did you say that? Because I thought that's what you had given me.
So why did you think that it was a narco?
It was white and I knew she had narcos.
There was no feeling, you didn't have any accurate side effects or anything like you felt like you were taking a narco versus just taking an ibuprofen?
I'm 300 pounds plus medication with a narco because I have had a prescription for narcos. Like you said, I had the prescription for Tramadol. It doesn't affect me like it may affect somebody else.
Do you normally, have you taken them before? Is it something you commonly take?
No, but I have taken them in the past because I've had surgeries. I have had a surgery and I've always been heavy.
You said you had smoked marijuana on your birthday.
Yes,
How often do you smoke marijuana?
I don't smoke marijuana. This was during COVID. This was something like we was partying. And that was just that one time. And we was all talking about, I hang with nurse friends. What goes on, how much stress we was under at work. That was just this one time thing that we did.
So no history of it before?
No, sir.
Do you have any history of any other drug or alcohol abuse?
No, sir.
You said that you took your mom's medication and you knew that wasn't right, but is that something you normally do, is take medications that's not prescribed to you?
No, it's not. But I have taken medication that is not mine. Even when I was a little girl, my mama used to give me medication that was not mine.
Would you say,
If I have a cold, she might give me my brother cold medicine. But that's not something I normally do. That was because I had to go to work that shift. I wasn't gonna call in. I was not gonna call because I was just coming back to work. I wasn't finna call in.
are you taking any medications now currently?
Yes, I am.
What are those?
High blood pressure medicine, atenolol.
Is that the only medication you're taking?
I have a prescription for potassium, ibuprofen, and iron. Those are the only ones.
Have you ever been arrested or any criminal history?
No, sir, I have not.
I have no further questions, Your Honor.
All right, thank you. Any questions from Ms. Roby from the board panel?
Ms. Roby, your license in February of 16, you admit to poor judgment. Was the date around your birthday the only time that you consumed marijuana?
Yes, no, sir. In the past, when I was younger, high school, yes, I have.
Since being a nurse?
No, sir, I haven't.
That's the only time? since
Yes,
being a
sir.
nurse?
Yes, sir.
Please let him finish the question before you respond.
Okay.
Thank you.
Have you taken any other narcotics since this event?
The tramadol that was ordered to me, yes, I did. I had to take it.
But it was prescribed.
Yes, sir.
What date was that? Are you still currently taking that?
Oh, no, sir, I'm not. That was in November 2020, 26.
And so you have not used marijuana since this event?
No, sir.
You consider yourself an addict?
No, sir.
Other question.
Ms. Roby, I have one question that is of concern for me. Is it appropriate for a nurse to take a narcotic before reporting for their shift?
No, sir. I mean, no, ma'am, it's not. It's not.
That's my greatest concern, is that you were prepared to go to work, or should I say you did go to work with the assumption that you were taking a narcotic. Would that put my patients at risk?
Yes, it would.
That's all.
Anything further from the panel?
Yes. Since were terminated, have you had any other drug tests?
Yes, I have. I've had the current job I'm at and the previous job that I got after leaving Bolivar Medical.
Okay. And you're still employed currently as a nurse,
Yes, ma'am, I am.
and you haven't had any kind of disciplinary action
No, ma'am.
by employment?
And can I also state this? That previous job at Bolivar Medical called me and asked me to come back to work 2 times after this incident.
Okay. To your knowledge, did they ever figure out where the Norco that was missing had gone?
Yes, I do. They did figure it out.
They did.
Another nurse admitted to it, and She has lost her license.
So have you ever diverted drugs from your place of employment or used for your own?
No, no, ma'am, I haven't.
Thank you, that's all.
One more question for you. Have you ever taken any drugs from a facility you worked at for your personal use?
No, sir, I haven't.
Anything further from the panel? Any follow-up, counsel?
No, Your Honor.
Ms. Roby, is there anything further you'd like to share with the board on this matter?
Yes, sir. The facility I have been working for now for 2 years, we don't even have medication. We pass no pills. So addicts would want drugs.
All right. Counsel, we hear you close.
Mississippi Code annotated 73-15-29-1L provides the board has the power to suspend or revoke the license of a licensed practical nurse who engages in unprofessional conduct. Administrative Code, Part 2820R 1.2 F4 states that the refusal of a drug screen is unprofessional conduct. Ms. Roby refused a drug test because she did not want to fail. She admitted to smoking marijuana and to also taking what she believed was a narco, which happens to also be what was missing from the facility. Accordingly, we would respectfully request this board panel consider all available options allowed by law in regards to Ms. Roby's license to practice as an LPN in the state of Mississippi in order to safeguard the life and health of patients.
All right, thank you. Ms. Roby, if you have a closing statement, you can make it at this time.
I am learning daily from this mistake, and I do know that I am not trying to ever be in this situation again. Thank you.
All right, thank you. Entertain a motion for the board panel to go into closed determination as to whether executive session is necessary in this matter.
I will make the motion.
Moved and properly seconded. All in favor, please signify by saying aye. Any opposed? That motion carries unanimously. I'll entertain a motion for the board panel to exit to executive session for deliberation on license number P 334-056.
I'll make that motion.
Second. It's been moved and properly seconded. All in favor, please signify by saying aye. Any opposed? Motion carries unanimously. The board panel will exit to executive session for deliberation and decision.
No, I ain't gonna forget you. Yes.
I just texted
Here.
No, I text you like. Go get some.
Go ahead.
All right, thank you everyone for your patience. We are, or will be back on the record shortly. Okay. All right, I'll entertain a motion for the board panel to return to regular session.
I'll make the motion.
Second.
It's been moved and properly seconded. All in favor, please signify by saying aye. Aye. Any opposed? The motion carried unanimously. The board panel is now back in regular session. Following deliberation on license number P 334056. The board panel renders the following: formal reprimand, $500 fine to be paid on or before 60 calendar days from the execution date of the order. A class entitled Facing Legal and Ethical Issues in Nursing. A copy of this order will be forwarded to the licensee within 30 to 45 days of the conclusion of these proceedings. Ms. Roby, what is your current mailing address?
202 Green Ave, Drew, Mississippi, 38737.
Thank you. Are there any questions? No questions, you may be excused.
Thank you.
Yes, ma'am.
I'm just upset.
Yeah, we need to. He's here. He's here. Thank you. Thank you all for coming.
Good luck, y'all. Bye.
Thank you. Bye.
Preston Peterson. And we will begin this matter after a short recess.
the hearing officer. I'm an assistant attorney general, special assistant attorney general. I'll be the hearing officer for the rest of this afternoon. My understanding, the next matter for hearing today is the case concerning license number R912710 Preston Peterson. Mr. Peterson, are you present?
Yes, sir.
And are you representing my counsel?
No, sir. No, sir.
And you understand your right to counsel?
Yes, sir.
You understand you have the right to have an attorney represent you today at this hearing?
Yes, sir.
You understand you have the right to present witnesses on your behalf and to present other evidence on your behalf?
Yes, sir.
And you also understand you have the right to have the board issue subpoenas on your behalf to compel witnesses and to obtain other evidence on your behalf.
Yes, sir.
So with that understanding of your rights, are you ready to move forward with your hearing today?
Yes, sir. I have my wife as a witness as well as 3 exhibits for myself.
Okay. Are there any preliminary matters that we need to discuss?
Yes, Your Honor, we'd like to introduce some evidence. B1 through B8 and R1 through, let me check. Yeah. Can we just do R1 through R2? The respondent.
All right. So you have some exhibits also?
Yes, sir.
R1 and R2.
And excuse me, again, counsel, what exhibits you want to introduce?
B1 through B8.
So does any party have any objection to these exhibits?
No, sir.
There you go.
So let exhibits B1 through B8 on behalf of the board be introduced, and respondents exhibits R1 through R2 be introduced in this hearing. Okay. Each witness, I believe Ms. Peterson said you had one witness.
Yes, Your Honor. My wife, Hannah Peterson, and
Right.
myself.
Does the board have any witnesses?
Yes, sir. Casey Loper is on Zoom.
All right. So at this time, let's swear in both of these witnesses.
Each witness raise your right hand, please. Do each of you solemnly swear that the testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes.
I do.
Okay, just for everybody's understanding, let's go with the procedure that we will follow. Both parties will give an opening statement. Board counsel will present the board's case first, and then respondent, you will present your case, and followed by the board counsel's rebuttal. Then we'll have any closing statements on behalf of both parties. As far as questioning witnesses, there'll be direct and then cross-examination, and then possible redirect if that's necessary. At that time, if any member of the board's hearing panel would like to question the witnesses, they can do so at that time. After everything is presented, the board will excuse itself for an executive session to hear this matter and to make a determination. And then the final order and the findings of fact and conclusions of law will be reduced to writing and will be sent out 30 to 45 days after the conclusion of this hearing. For the record, this hearing is open to the public. And for the record, there's a form of the board, a hearing panel here today. And so at this time, I'll let the board's attorney present the board's case.
Thank you, Your Honor. Today, we are here because Mr. Peterson has violated Mississippi Code annotated 73-15-29-1F. And he has engaged in unprofessional conduct by negligently or willfully violated any order, rule, or regulation of the board pertaining to the nursing practice license. Specifically, an MMVP monitoring agreement was voluntarily signed by Mr. Peterson on March 24th, 2022. By signing the agreement, Mr. Peterson agreed to be bound by the terms contained in that agreement. This agreement required Mr. Peterson to practice total abstinence of any amount and any kind of alcohol, any illicit drug and narcotics, any prescription controlled substances, and other mood altering substances. Despite this requirement, Mr. Peterson admitting to drinking alcohol, failed a drug test, and also failed to submit a specimen on 3 occasions. Mr. Peterson was also required to participate in a 12-step support program and provide proof of that attendance. No proof was ever provided. Mr. Peterson failed to complete the required intensive outpatient program and failed to enter the recommended residential treatment program. The agreement required Mr. Peterson to also obtain a sponsor and provide documentation of that sponsor. No documentation was provided. Mr. Peterson has been unable to return to practice according to acceptable prevailing standards of safe care. Despite entering into the agreement, Mr. Peterson has failed to comply with the terms and conditions contained in that agreement. As such, he is in violation of the terms of the agreement and Mississippi Code annotated 73-15-1. This board panel has the power to revoke or suspend Mr. Peterson's license for non-compliance.
First of all, thank you all for being here today. I just want to say I'm here to humbly ask consideration from the board to consider alternative disciplinary actions other than permanent revocation of my license and present the evidence that I have that I attempted to comply with the nurse voluntary program unsuccessfully, and I'm aware of that.
Thank you, Mr. Peterson. This time, would you like to call your first witness?
Yes, Your Honor. I'd like to call Casey Loper. Casey, please state your name, county residence, and current place of employment for the record.
My name's Casey Loper. I'm a resident of Rankin County, Mississippi, and I am the program manager at the Board of Nursing
How long have you worked for the Board of Nursing?
since January 2020.
And what is it that you do for the Board of Nursing?
I am the program manager for the Mississippi Nurse Voluntary Program, which is the alternative to discipline program.
Can you tell us what the purpose of this voluntary program is?
It is to assist nurses who self-identify as having a substance abuse problem, transition into recovery, and support them through monitoring in order to help them sustain recovery and make sure that the public is protected at the same time.
So this is a voluntary program, correct?
Correct.
How does the nurse get into the program? What are the requirements?
The requirements are set forth by Mississippi Admin Code 2826. They have to have a license in good standing with the state of Mississippi. They have to identify as having a substance use or abuse issue. They have to have caused no harm to a patient. And they have to be willing to do the things in the monitoring agreement.
So you're familiar with the terms that are contained inside that agreement?
Yes.
Would you say they're confusing or worded in a way that somebody wouldn't understand it with a degree?
I don't think that they're confusing, but we do go over it with them 2 times prior to them signing, just to make sure that there's no questions.
So they understand the terms that they're signing to?
They are acknowledging that they understand the agreement whenever they do sign it.
Would you please go to Exhibit B5 and identify those documents for the board, please?
B5.
Yes, ma'am.
Okay. B5 to me shows that it's a letter that was sent to Mr. Peterson about the hearing. And then the charges against him. And then an order suspending his license with receipt of that.
And on the second page of B5, can you tell me what charge 1 is against Mr. Peterson?
Failed to maintain abstinence as evidenced by admitting to use of alcohol.
Could you go to exhibit B8 and identify that document for us as well, please?
That's the Mississippi Nurse Voluntary Program Monitoring Agreement that Mr. Peterson signed.
And what's the date of that document?
March 24th, 2022.
And would you please read the first sentence of A under binding effects of terms and conditions?
By signing this MMBP agreement and entering the program, I agree to follow and be bound by the terms and conditions of this agreement.
And did Mr. Peterson sign that document?
He did.
Would you please go down to C? It's titled abstention. And does it state, I quote, "I will practice total abstinence"?
Yes.
So is it fair to sum up that paragraph by saying total abstinence includes any and all drugs and alcohol?
Correct.
Did Mr. Peterson initial that clause?
He did.
So he was also aware of that requirement as well.
Yes.
And going back to the complaint, what does A state on that complaint?
Failed to maintain abstinence as evidenced by admitting to use of alcohol.
How did he admit to the use of alcohol?
We received documentation from his IOP that he used synthetic urine and was caught using synthetic urine for IOP and was dismissed from the program as a result and recommended a higher level of care. When I talked to Mr. Peterson about that, he did admit to using alcohol and using synthetic urine in order to try to pass the drug test.
So he was also aware of this requirement as well, total abstinence, the alcohol.
Yes.
Did he initial next that provision?
Yes.
Going back to exhibit B5, would you read B?
Respondent failed to submit valid specimen on 3 separate occasions, and respondent failed to submit any specimen on 3 additional occasions.
Will you identify exhibit B6 for us?
B6 is a report that's run through our online monitoring, the database that we use to check in and to have communications and online selections and everything. And that is the compliance report that was ran related to Mr. Peterson.
So what does this show exactly? Just, can you tell us kind of what it shows?
It shows that Mr. Peterson, up until the date of 9/11/2022, failed to check in 36 times, no showed for 6 drug screens, and had 4 drug screens.
Would you please go back to B5 and tell us what C states Mr. Peterson failed to do?
I'm sorry, what?
On exhibit B5 under C, what does it state that he failed to do?
On 5, it says he's failed to submit a valid specimen on 3 occasions and failed to submit any specimen on 3 occasions.
And on B8, under F, it says treatment for providers. What does it say there?
It says that he's required to undergo an assessment, that he was being provided services through Region 4, I believe. I'm not really good with Roman numerals, I apologize. Mental health services. And he was doing IOP at the time of his intake. It does say that he may require reassessment in the event of lapse or suspected relapse, and abide by any further recommendations.
So did it require that documentation be submitted for that provision as well?
Yes.
Did Mr. Peterson initial next to that provision so that he was aware of it?
Yes.
Did Mr. Peterson provide any proof or documentation that he completed the intensive outpatient services?
I'm sorry, the speaker cut out.
I'm sorry. for that provision, did Mr. Peterson provide any proof or documentation that he completed the intensive outpatient services?
No, we received documentation that he did not complete intensive outpatient.
Going back to D in Exhibit B5, what did it also say that Mr. Peterson failed to do?
You said on B?
On Exhibit B, yes, ma'am, under D5, I'm sorry, B5, D.
That he failed to submit valid specimen on 3 occasions and failed to submit any specimen on 3 additional occasions.
I'm sorry, Casey, under D on that.
Under
right above-
D,
Yes, ma'am.
okay. It says that he failed to submit proof of 12-step support attendance monthly and also failed to provide documentation of obtaining a sponsor.
On B8, Exhibit B8 on page 4, what does G 12-step support require?
It requires him to attend 3 AA, NA, Celebrate Recovery, or Caduceus meetings a month. And it instructs them on how they log that in and submit that documentation. It also requires them to get a sponsor within 60 days of signing their agreement. And that sponsor date was due on May 24th, 2022.
So have you received any documentation that Mr. Peterson was required to submit that regards to that 12-step program or sponsorship?
No,
Did he also initial next to this provision?
he did.
Going back to B5, one more time, will you tell us what E states in regards to Mr. Peterson's non-compliance?
That he failed to comply with the terms and conditions of the program and or the monitoring agreement and has been unable to return to practice according to acceptable and prevailing standards of safe care.
And going down to Q, on B8, the program completion termination, does it state that if the participant fails to comply with the terms and conditions of the MMVP program, that participant will be removed or terminated from the program?
Yes,
Does it also state that if they are unable to practice according to acceptable and prevailing standards of safe care, that participant may be terminated from the program as well?
yes,
Was Mr. Peterson aware of that provision?
he was.
Did he also initial next to it?
He did.
Can you tell us how that standard is determined?
The prevailing standards of safe care would be being able to practice by obtaining a return to work assessment or a fitness for duty assessment that would say that he was able to practice nursing in a capacity that was not likely to cause harm to the public. He did receive an assessment, and the assessment said that he could return to practice after completing the intensive outpatient program. Since he did not complete the intensive outpatient program and experienced a lapse or relapse, he was unable to return to the nursing practice.
Okay, you said earlier that the agreement was signed on March 24th, 2022.
Yes,
What date is defined as the creation date in Exhibit B8? It's under S, it says length of MMVP agreement.
that the agreement would end on or about March 24th, 2027, if it was not extended or terminated.
So the creation date was March 24th, 2022, is that correct?
I'm sorry, the
The
creation date, yes, is March 24th, 2022.
And you said it lasts for, so this agreement would last until March 24th, 2027, which was 5 years.
Correct.
And the order suspending Mr. Peterson's license for non-compliance in B5, what was the date on that?
August 2nd, 2022.
So going by those dates, Mr. Peterson didn't make it 5 months into his 5-year agreement.
Correct.
I have no further questions, Your Honor.
Peterson, do you have any cross of this witness?
Your Honor. Ms. Loper, do you recall when we first started speaking about the Mississippi Nurse Voluntary Program? Around about the date that the first time that we spoke?
I can't recall the date. I do apologize. I don't have that in front of me.
Do you recall when I was required to sign an agreement that I would not practice as a nurse?
You signed that with the eligibility agreement, which was prior to intake.
But you don't recall the date?
I don't have the date in front of me, and I don't want to testify to a date I'm not 100% sure of.
Did I contact you prior to missing any drug tests? The first drug test that I missed, did I contact you prior to that?
I honestly don't remember. I do know that you were very good at communication.
So it's possible that I contacted you prior to missing any drug tests.
It is possible, yes.
On exhibit B6. You said I failed to log any of my meeting dates and times. I was told to log those in the Spectrum Compliance app. Do you have any of the logs of the dates that I did enter?
I didn't receive any logs. I didn't receive any reports.
So was I told to enter the log into the Spectrum Compliance app?
Yes.
Okay. Did I have an assessment completed by a licensed addiction counselor twice as I was asked to do by you?
You had an assessment completed 2 times by a board-approved assessor.
Can you tell me the dates of those assessments?
I don't have the dates in front of me.
No further questions.
There you go.
Ms. Loper, you're dismissed. Thank you for your testimony. Counsel for the board, do you have any other witnesses?
There you go.
Questions for Casey?
Please call your first witness.
I'd like to call Hannah Peterson.
Well, my name's Hannah. I'm Chase's wife.
Could you pull the mic a little bit closer to you? Thank you.
That better? Okay. You want to ask me a question?
I would just like to ask Hannah to testify on my, if she's aware that I've gone to meetings, as well as my, if I've used any mind altering or illegal substances since the last time that I admitted to using alcohol in May.
Well, no, he has not. But I just would like to say a few things myself. When this all started, it was really hard because I have never personally been involved with anything like this. I don't have an addiction. I've never had that struggle, and neither has Chase until this happened. So it was really hard. We didn't know how to handle it, what to do, how to get help, how to ask for help. And it took a few months. It took a little bit of a time for us to figure out how to recover from this, both of us, because, you know, it took a toll on me and it took a toll on our kids, this whole situation. It was a struggle, and I think that has a lot to do with the things that he missed, the things that he didn't do. I will say that I have watched him work really hard on himself I've watched him really miss his job, really, really miss his job. He loves his job, loved his job. I have seen change in him. We do have 4 kids. We're busy all the time. So I think that had a lot to do with why he missed a lot of the meetings, why stuff like that. He has been going to meetings still. He still goes to meetings just for himself, not for nursing, and just for himself, to help himself. But he has not been drinking. He has not had any alcohol, no drugs, anything like that, in months. So that's all I have to say right now.
So my question to you is, starting in May of 2022, after I was discharged from the intensive outpatient program from Region 4, did I attend 3 meetings a week with an approved AA, NA, or CDA sponsor the whole month of May and June?
Yes, yes.
Did I obtain a sponsor through AA before the said date, May 24th?
Yes.
If we can turn to Exhibit R2, it's a letter from my sponsor. You like to read that?
My name is Michael Hayes, and I am an active member of Alcoholics Anonymous, Narcotics Anonymous, and Chemical Dependency Anonymous for 2 years. I also was in the outpatient rehab program with Chase Peterson. Chase has been very active and present in his recovery since I met him in March. This includes attending outpatient rehab 3 times a week for approximately 7 weeks, at least 1 meeting a week at our home group in Booneville, Mississippi, since he has left outpatient treatment in March. Chase and I have spoken daily as well as attended meetings together since he asked me to be his sponsor the first week of June 2022. Chase has grown a lot in his sobriety, and to my knowledge, he has been alcohol and drug-free for 5 months. Chase is a very responsible and caring man who was caught up in substance abuse very quickly, and this caused him to act out of character and become in question with the Board of Nursing. I understand it is your job as the nursing board to protect the rights and safety of patients, and I believe Chase is very compassionate about nursing and has the same concerns at heart. I recently went through surgery for my kidneys and had no one at home to help me. I called Chase to help with a wound dressing change, and he did not hesitate to show up and assist me, as well as continue to check on me daily. Sincerely, Michael Hayes.
Thank you. Did you witness me attempting to log my attendance to these meetings as well as check in daily to the Spectrum app?
Yes.
Were you aware that I contacted Casey Loper before I missed any drug tests, explaining to her that we were experiencing financial difficulty due to me being out of nursing since January of this year and jobless for the first 3 months? And she stated that she was aware and understood financial difficulties, but of course could not excuse any missed drug tests.
Yes, that's right. That's right.
Have I been employed since leaving nursing since March of this year?
Yes, he has worked several. He's had to do what we could since he lost his job as a nurse. And he has done everything he could right now he's working as an electrician or working with an electrician. And he loves it, but he's ready to get back, or wishes he could get back to nursing. But he's worked every day since he lost his job as a nurse, doing whatever he can to provide.
Yes.
Mr. Walker, do you have any cross examination?
No, Your Honor.
Does the board panel have any questions? for the speaker?
I have a quick question, and you may or may not know, but you read the letter
from Michael Hayes. There's no date on that letter. Do you have a date? An estimate date that was written?
The date that I asked him to write it was Saturday, this past Saturday. So is that October 1st?
Question.
Sure.
So while we're on that, so, and your wife read that he asked you to help him with the wound dressing change, and you did not hesitate to show up and assist. When did that happen?
It was in the end of August, maybe.
So your license was suspended on August the 2nd,
Yes.
and then you were performing nursing care?
No, ma'am. He asked me to come assist. I didn't act as a nurse. I was acting as a friend.
All right, thank you.
Anybody else on the panel have any questions? Ms. Fisher, I'd like to ask you one question. Were you aware that your husband was not complying with his agreement?
Yes and no. It, like I said, during that time, we've had 3 babies back to back to back. I had 3 under 3. I have 4 total. So it's just been crazy. So sometimes we don't see each other for, a week, because we're going back and forth and going to bed early, So sometimes he didn't tell me everything, but I mean, I knew some of it. I knew we couldn't afford a lot of it to do, like the drug tests that he had to take. We couldn't afford to pay for those for him to take. And I think that had a lot to do with why he wasn't signing in to that app, because that's the app that tells you this day you got to go take a drug test. When it came up to do that, we didn't even have the money in the bank to do that. We were barely affording our house payment. So we just could not afford a drug test. There was the ones that we did afford. I think my mom and maybe his grandmother gave us the money for it. We just couldn't afford them.
Thank you. Any further questions?
Only for Mr. Peters himself, not for his wife.
Are you the next witness?
Yes, sir.
Go ahead and testify.
Unfortunately, I don't have here today the information that I entered into the Spectrum Compliance app, like I questioned Ms. Loper about. I don't know if you guys are familiar with that app or not. It's reasonably accessible, but I did check in every day as soon as I was told to for the first couple of months until after I'd taken a couple of drug tests, which were $100 a piece, by the way. And as my wife said, we've struggled financially significantly since January, as you can imagine. But the first chance that I couldn't afford a drug test, I contacted Miss Loper and asked her what would be the appropriate thing to do if there were any other options, anything I could do, since I couldn't afford to pay $100 at that time for a drug test. And as I've said before, she said she understands financial difficulty, but of course, the drug test can't be excused, which I understand, but I don't know if there's any alternative to that. And I did enter my meeting dates. I went 3 times a week, as my sponsor mentioned in that letter, the whole month of May, June, and July. But since I've been out of the program, I've still only been going at least once a week to stay active in AA. I think that's all I have starting out.
Walker, do you have any comments?
Yes, Your Honor. Mr. Peterson, will you state your name, your residence, and your current place of employment for the record?
My name's Preston Chase Peterson. I live in Alcorn County. And what was the other?
Where are you working at?
I'm currently employed with Spencer Electric in Alcorn County, Corinth, Mississippi.
Have you got any kind of electrical degree or anything?
No.
Can you tell the board your educational background?
Graduated from Kossuth High School in Alcorn County, Mississippi in 2014. and went to Northeast Mississippi Nursing or Community College for my associate's degree in nursing, and graduated in 2019.
When you graduated in 2019, was that your RN license?
I passed the NCLEX in June of 2019 for my RN licensure. Yes, sir.
Before today, have you been before the board with any disciplinary action before?
No, sir.
I know you're attending the counseling. Are you doing any other type of treatment program?
Actively, what I'm attending are Alcoholics Anonymous, Narcotics Anonymous, and Chemical Dependency Anonymous meetings. All three different associations, just because different organizations meet on different days where I'm from. So
How many would you say you're attending on a weekly basis?
since I've been excused from the voluntary program at least once a week, sometimes 2 to 3 times a week. But as I said before, the whole month of May, June, and July, or the beginning of July, I went 3 times a week. Some weeks I went 4 times.
We don't have any documentation of those.
No, sir. Unfortunately, not here today. I wish I could access the app, because I could show you where I did enter the dates for, I know, the month of May and June prior to me being excused from the program. I don't know if they didn't play over for Miss Loper to see, or if I didn't completely enter them correctly, but I know I still have them on my phone.
Have you had an issue before? Like, when did you start with the drugs and alcohol use? Is that something that's always been?
As far as drugs and alcohol abuse, I don't think I really realized, or maybe I didn't have a problem up until maybe the fall of 2021.
So after you were already a nurse?
Yes.
You taking any medications now?
No, sir.
And I know you and your wife have both stated that the reason for your non-compliance was a lot was the money, but you continued to drink even though you knew you were going to take drug tests. Is that correct?
I did drink on one occasion while I was in outpatient program, but I would like to add that was very early in my recovery process, and I was very vulnerable. I made a poor decision to consume alcohol.
You still consume alcohol now?
No, sir.
Have you taken any, I know you're attending the groups, but have you taken any drug tests, or any urine tests for drugs or alcohol since you were required to?
The last drug test I took was in June of this year. After I was sent for a reassessment, I mentioned that to Casey about the 2 assessments. The second assessment I went, it had to include the experience that I had with the outpatient program. The licensed addiction guy, Bobby Scott was his name. He had to include in his report that I informed him that I was removed from the program for the using fake urine and for alcohol at the end of the outpatient program. But he also stated that due to my being active in AA and the other organizations, and the way I presented that day, that he thought that I was fit to go back to work at that time, as long as I continued to comply with the board of nursing, or the Mississippi Nurse Voluntary Program. He was unaware that that assessment was pretty much the end of my voluntary program.
So I know the money was an issue for the drug test, but what about the meetings? Was it because of your kids, or, I mean, you knew you had the meetings when you signed it?
I did go to the meetings so I wasn't required to go to the meetings while I was in the outpatient program, which I started at the end of February or the beginning of March, just before signing the agreement, because I was told by Casey to do so. And those counted as my meetings. I believe it was a Thursday when I was discharged from the outpatient program. That following week, I attended 3 meetings. And from then on until I missed the check-ins, and Casey told me that I had to have a reassessment, I continued to go to meetings, and like I said, I still continue to go to meetings today. I just stopped logging them after I was discharged from the voluntary program.
You said you received your license where you passed the NCLEX in June of 2019.
Yes, sir.
So that would put you practicing as a nurse right at 3 years. Is that correct?
Yes, sir.
Before you were suspended. So you entered into the agreement that was 5 years, which was longer than you were a nurse.
Yes.
I have no further questions.
Does the board panel have questions?
Yes.
Go ahead.
Mr. Peterson, I kind of want to build a little bit of a better timeline here. So what caused you to enter into the MVP program?
So in December of 21, would you like me to just start from the beginning and kind of give you the whole story? Okay. Like I said, in fall of 21, prior to that, I drank recreationally, maybe a time or two a week, and didn't use any substances. Made a poor decision to use an opiate substance from a high school friend from the streets, the beginning of that fall. And I firmly believe that those substances were laced with fentanyl. So I developed a dependence to those substances like within a couple weeks and would get sick without them. So in December of that year, a few months after the substance abuse began, I had to work a stretch in a row in Tennessee on a travel contract. And I was very sick on the third day that I was there. So I diverted some medication for personal use. After that, I self-reported and waited to hear back from the board. And I believe the second week of January of this year, I received a letter back and a phone call that I should sign to agree that I wouldn't go back to work as a nurse until I was saw fit by the Board of Nursing or the nurse voluntary program. I signed that and I waited. I had my first assessment done towards the end of February. Bobby Scott, the licensed addiction counselor, advised that I go to outpatient program since my substance abuse history was so short, as far as the length of time it lasted goes. And which I did pretty well immediately. But speaking on the financial concerns, I signed, like I said, January, I think it was 7th actually, but so the first or second week. I didn't work from then until March because I didn't know what was going to come about, and we lived off of my savings. And as my wife said, we have 4 children, so it's been a big change on a lot of fronts and happened very fast for us. But then I entered the outpatient program the end of February, beginning of March. I was in my last week of the program. I had gone 3 nights a week and an individual therapy session the whole 7 weeks and completed everything good up to that point, and made, like I said, a poor decision to consume alcohol. And out of fear, the next day I was drug tested. So I used fake urine and I admitted to that. So I was discharged from the program and required to have another assessment done, which I made an appointment for and did immediately, which was the beginning of June. And that's when the licensed addiction counselor said that he thought, based on what I told him, that I was active in meetings at that point because I had left outpatient therapy, started meetings immediately. And at that point, other than the dilute results on the drug test, through the voluntary program, I had not failed a drug test at the time. So he said I could go back to work as long as I continued to comply with the nurse voluntary program. And the nurse voluntary program had that reviewed and didn't agree with it and stated that I had to go to inpatient rehab or terminate my contract that I had with the voluntary program.
So how much time did you complete in the outpatient?
I think it was 7 weeks because I'm pretty sure 8 weeks was the total program. And then, like I said, it was a Thursday when that happened. I think the following Thursday I was going to complete the program.
How many drug tests did you pass in that time that you were in the outpatient program?
4 or 5, I think.
As far as the synthetic urine, where did you obtain that urine?
A gas station.
And when did you get it?
The day before.
So you purchased it before or after you found out you had to take a drug test?
The day before. When I drank.
Did you know about the drug test that you were gonna have to take? So you
No, I drank.
bought the urine with the anticipation that you would fail a drug test.
I drank that day, and that day I bought the fake urine. And the following day I took the test.
Have you ever used synthetic urine on a drug test before that?
No, ma'am.
Have you ever used anyone else's urine?
No, ma'am. Honestly, I never thought I could get away with it, and clearly I couldn't.
What would you say your sobriety date is?
May 20th.
Of 2022?
Yes, ma'am. Sorry.
Had you ever had, prior to when you said you diverted meds for personal use, that was in December of 21. Had you ever diverted medication before that?
No, ma'am.
Were you under any disciplinary action from that facility for that?
The following day, they called it to my attention that they were aware. And asked me to take a drug test, and I refused. And that same day I called and self-reported.
Were you terminated at that point from the facility?
I assume that went with the refusal of the drug test. I'm sure those are
That was with a travel
simultaneous.
assignment, is that
Yes, ma'am.
Do you have at this point, any of your documents from your assessor recommending, outpatient treatment?
I have those emails, and I meant to bring them today and failed to do that, but I do have them if I could turn them in when I leave or a later date. I'm sorry.
So when you did not complete the outpatient program, that was at that point, they recommended that you did an inpatient?
The Region 4 recommended a higher level of care or wait 6 months and to start that program over because that's their policy. So that if you get discharged from that outpatient program, that's the only recommendation they can give.
Okay. Had you considered getting in with an inpatient program?
I have.
Okay.
Honestly, I wish I would have done that in January.
Do you feel at this point that you could maintain sobriety?
Yes.
And as far as drugs of choice, you mentioned opiates and alcohol. Is there any
Yes.
other drugs that you used? And
That's it.
Any particular opiate?
No, not really. Like I said, the ones that I never really used opiates until the fall of 21, so I don't really have a big history with those either. And I think those were fake. So
And what drugs did you divert while you were at work in December of 21?
It was in one day. I got I think 2 oxycodones and a vial of morphine, I think.
Okay. And what did you do with those?
I took them home and used them that evening.
And what did you do with the morphine?
But used it that evening.
How did you use it?
IV.
Was that the first time you've ever used IV?
Yes.
But the only time you've ever used an IV drug?
Yes.
I don't have anything further.
Thank you.
Any other?
So I believe, Mr. Peterson, the question I have for you, based on the fact that you were offered MNVP, what is your expectation from this board panel today?
I'm honestly unsure. Pretty much the whole time since I've self-reported, I've doubted myself, and I felt that I probably just should accept that I lost that opportunity for myself. I've never really struggled with self-doubt until this, but it was such a rapid process, and I felt very guilty. And I thought, with 4 kids and working full time, there's no way I was going to be able to go to 3 meetings a week and pay $200 a month for drug tests, even if I tried my hardest, even if I stayed sober. And like I said in the beginning, I really did try very hard and still didn't succeed. But my expectations from the board, I expect you guys to protect the public, obviously, but I trust that y'all have more experience with other situations like mine, and I trust that y'all make the correct decision. I don't really know. I mean, this isn't something I deal with regularly. I know that I'm very compassionate about being a nurse, and that's one of the things I've struggled with since January too. Is I feel like being a nurse is part of my identity. I was really proud of being a nurse. And through COVID, I traveled a lot and took a lot of crisis assignments, and was under where I lived in a high stress environment pretty much my whole nursing career. And I don't know, I guess it just all caught up with me, and I made poor decisions, but I trust that y'all make the correct decision today.
So with that answer, if we choose to ask you to drug screen and meet all those conditions that were already put forward for you, you have a plan financially to follow through?
My plan has been day to day, week to week, financially. I'm currently not really in any position to pay $200 a month. I almost brought bank statements today. I'm the only income in my home, and it would probably not even be beneficial financially for my wife to go to work, because we have 3 kids that aren't in school, so we'd be paying as much as we pay for our house for childcare. So my options are very limited. I would do my best to afford the drug test, but I really don't know how soon that would be possible without losing my home and not being able to eat. Thank you.
Any other questions?
Just a couple of things. So I just want to clarify, so you were caught diverting in December of 2021?
Yes.
And it was after you were caught that you contacted the Board of Nursing to enter the voluntary program? Okay. That's the only other thing I wanted to ask is, why do you think that there's a waiting period? Like for the outpatient treatments, 8 weeks, and you said there was a 6-month waiting period. That was their policy for you to repeat. Why do you think that is?
I guess you had the opportunity to complete it once and you messed up. So I guess maybe they wouldn't just let you sign right back up and waste their time.
Yeah, so it takes more than 5 months. And so, sometimes people need the time to figure out how they're going to move forward. So as you said, it's our responsibility to protect the public while you figure that out.
Absolutely. And if I had any complaints of the voluntary program, that would be the only thing, is that I've felt rushed. And I'm not super experienced in substance abuse. Like I said, it was a very brief period. but the physical withdrawals and the psychological impact something like that has on you, as well as being the sole financial provider for your home. It's a heavy load and hard to deal with 3 meetings a week and $200 a month, work full time and be a father, and fulfill everything that I can. Right. I agree with going to meetings and I agree with taking the drug test, but I just don't see how I can be expected to afford it currently.
Got family support.
My mother-in-law helps some, but my wife is from a family of 6, so she has 3 siblings still in high school, and a single mother. So that's pretty much it. My mother's an addict, an active addiction. We don't currently speak. And my father has been in prison for 13 years until March of this year. So he's out now, and he supports me as a father, but not financially. He can't. The next closest relative is my grandmother, who's on disability. So I help her more than she can help me.
But regardless of what happens, people do get through this. It just takes longer than.
Teresa, I have a question. Before you became a nurse, what profession or line of work did you have?
I was a manager of a Subway.
So when did you become a nurse? What year?
2019.
Are there any other questions? So at this time, we need to have closing statements. Forward.
Thank you, Your Honor. He voluntarily entered into the MVP agreement with the board. In that agreement, he consented to be bound by the terms of that agreement. In a matter of less than 6 months, he managed to violate not one, but multiple terms of that agreement. Furthermore, he was licensed as a nurse just over 3 years ago, as already before the board facing disciplinary action. Mississippi Code annotated 73-15-29-1 gives the board the power to revoke, suspend, fine, place on probation a licensee who engages in unprofessional conduct as set out in the rules and regulations regarding the practice of nursing. Accordingly, we would respectfully request this board panel consider all available avenues in regards to the license of Mr. Peterson to practice as a registered nurse in the state of Mississippi in order to safeguard the life and health of the patients.
Anything further?
Thank you, Your Honor.
Once again, I just want to say thank you for all your time, for being here today, and for giving me the opportunity to speak for myself. And like I said before, I trust that y'all make the best decision. Clearly, I'm out of control in this. I have no control over this decision. And the one thing I have learned through the process of early rehabilitation and sobriety is how to deal with things as they come, and just accept that you don't have control of everything. So I'm just going to take it as you give it to me. Thank you. Yes, Your Honor.
Are there any further proceedings or matters that we need to discuss before the hearing panel? Okay, do I have a motion for the hearing panel to consider going into executive session to deliberate?
Make that motion.
All right, duly made and seconded. Is there any discussion? All right, is there a motion to go into executive session to deliberate?
Make that motion.
All in favor?
Aye.
At this time, we will take a short recess for the panel to go in and deliberate the decision. Thank you. Is there a motion from the hearing panel to go back into regular session?
I make that motion.
All in favor?
Aye.
Okay, so we're back in regular session and at this time, I'll announce the hearing panel decision. Following the deliberation on the matter of license number R-912710, the board hearing panel renders the following decision based on clear and convincing evidence. Your license is hereby revoked with drug-related recommendations. And you will get a written order in 30 to 45 days after the conclusion of this hearing, setting for board's decision. Are there any questions?
No, Your Honor.
Is there any further matter from either council? Anything?
No, Your Honor, sorry.
Anything from the panel?
I just want to say-
Okay.
So, Mr. Peterson, I speak for the panel. I want you to know that this is not the end. And we really want to see you back here in a year. And we hope that you'll take this time to take care of yourself. So you can certainly continue to take care of your family and then take care of the patients, because we need you in nursing and we need you well. We hope that this will give you the opportunity to do that.
Thank you. I hope the same.
And
Y'all are dismissed.
Where's the files at for the next? He just left to go get them.
Dealing with us.
Mr. Mercier, is it Mercier?
Yes.
Are you gonna do the motions first?
Yes.
Okay.
Which one are we doing next? Who? I'm sorry.
Jennings?
Okay, Jennings. I'm looking at tomorrow.
I believe Mr. Mercier has some motions that he wants to take out before the matter. Mercier. Not down that first. Mercier.
I'll answer to Mercier, Mercier, Mercer my whole life.
What are you?
Really, Mercier, Mercier.
RCA?
Yeah, my name Cajolas. I've answered to many things.
Yeah, yeah. When I was in grade school, they got to the M's, I had to listen intently and they got close.
Okay, y'all ready to proceed? Okay.
Yes.
All right, the next matter for hearing this afternoon is matter of license number R-893757, Stacy Jennings. Is Miss Jennings present today?
No, Mr. Conjolas, for the record, I'm Doug Mercier, Mercier representing Miss Jennings. We just got notice about this officially. That's the reason for the motions I filed. And I put a call into her today, but I've not heard back from her. I can get into it in the motion and explain a little bit more procedurally why I've asked for this.
Mr. Mercier, your client did not get notice of this hearing?
What happened was there was a continuance, the first continuance, she asked for, I guess it was in June. And in June, there was an agreed order entered for continuance. I entered an appearance and filed the request for continuance and requested disclosures. There's an affidavit attached to one of the.
Okay, we'll get into that. in a minute.
And so I didn't think we were going forward. I've been speaking to Ms. Saltzman earlier this week about my cases, and I have two. I know for sure, which is the next one here we have after this one,
Right.
and then the one tomorrow. And then I didn't think we're going forward until I received notification from her yesterday. Hey, the Jennings case is going to be ready tomorrow afternoon.
I did receive notice of this hearing today.
That type of notice, yes.
Well, that's the important notice. That's critical. And I appreciate that now. And we will discuss the other matters that you mentioned in a few minutes. Okay, obviously there's some preliminary matters. Is that correct, Council?
Yes, Your Honor.
So, who goes first? Who has the preliminary matters? Does the council for the board? Or does Ms. Mercier?
On behalf of Ms. Jennings, I have filed two motions. One is a second motion for continuance of hearing, and then the other one is a motion to dismiss the case.
Okay, we need copies for the panel and myself.
I handed folders out and it contains copies of the two motions we filed along with emails and documentation, some case law.
Okay. I think what we need to do, unless both councils disagree, is hear the motion to dismiss first. Thanks.
Yes, sir.
Is that agreeable? Okay.
The motion to dismiss is not necessary if the continuance is granted. The only reason I filed the motion to dismiss is I just got the disclosures last night at 6:57 PM. And so I haven't even had a chance to review them, but there's some imperfections in the complaint that can be remedied, and I don't mind if they're remedied. But without, a continuance, I'm prejudiced. So I've got to go forward with one of them, at least the continuance.
Okay, council, for the board, what do you say? As far as what do we take first? What do we hear first? I'm sorry.
Do you want me to respond to, the motion to dismiss makes the most sense to handle first, I think, but I certainly will do the motion for continuance first if you'd like to do that. I'm going to handle the motions. Mr. Walker's going to handle the actual case if it goes forward.
I'm more comfortable hearing the motion to dismiss first, and so I think we'll proceed in that manner. Mr. Mercer, do you want to present your motion?
Yes, you give me just 1 second. I need to find the relevant statute.
All right.
May I proceed?
Yes.
On behalf of Ms. Jennings, I have filed a motion to dismiss. It's not lengthy and it's fairly self-explanatory. And it's based on infirmities of the complaint that was filed and the lack of disclosures, timely disclosures in this case. First of all, in paragraph 1, I say that the complaint filed in this case fails to state a legally sufficient or cognizable claim, it should be dismissed. Well, if you'll look at Exhibit 1, which is the complaint, it says that in the charge 1, it says that Ms. Jennings has violated Mississippi Code annotated section 731529 1F and that she has negligently or willfully violated any order, rule, or regulation of the board pertaining to nursing practice and licensure. And then it becomes specific, namely Mississippi Administrative Code, Part 2826, Rule 1.8A5. In that, respondent failed and or refused to report all alcohol or unauthorized substance use regardless of amount or route of administration. And then it goes further to say Rule 1.8L, any confirmed positive drug screen for which the Mississippi Nurse Volunteer Program has not received prior written authorization and confirmation from an approved provider. And it continues. And then it goes in the very last thing it says, and Rule 1.8F, any noncompliance with the contract or unsuccessful termination from the program is unprofessional conduct as in violation of the rules and laws regarding the practice of nursing and may be used to support any future disciplinary actions. When you break this down, there's three things that they're saying. They're saying essentially that Ms. Jennings failed to refuse to report alcohol or unauthorized substances use. That's 1.8A5. They're saying under Rule 1.8L that that there was, I guess, a confirmed positive drug screen for which the Mississippi Nurse Volunteer Program has not received prior written authorization and confirmation from an approved provider. And then the third one, the 1.8L, which is non-compliance with the contract. If you look further in the complaint that charges Ms. Jennings, which is supposed to give her notice under the due process clause and the requirements, it states that respondent voluntarily signed a Mississippi Nurse Volunteer Agreement on March 4th, 2020. Respondent has failed and or refused to comply with the agreement as follows. And it says in paragraphs 1 and 2 that she failed or refused to submit urine specimens on 1, 2, 3, 4, 5 dates, and that she failed or refused to check in with affinity on 1, 2, 3, 4, 5 dates. And you turn to the next page and there's nothing else. So out of the three allegations under charge 1, there are no facts, no specifics whatsoever that pertain to 1.8A5 in failing or refusing to report alcohol or unauthorized substance use. Is the complaint's void of any specifics or facts. There's no way to defend that charge. She's not put on notice of anything. The next part under Rule 1.8L, any confirmed positive drug screen for which the program has not received prior written authorization and confirmation. Again, if you look down there, there are no facts whatsoever that demonstrate there was any positive or confirmed positive drug screen. The only things that are listed are failure or refusal to submit urine specimens, or failure or refusal to check in. So without the information or knowledge of what the board staff is alleging that she did, it's impossible for her to have notice to be able to defend this. The charge was made by Avery Lee, Senior Special Assistant Attorney General. Ms. Lee states in the acknowledgement under oath that the matter and facts set forth herein are true to the best of her knowledge based on information and belief. But that's not been made in this complaint. Ms. Lee is not here for me to question her about what information she based those allegations on. I was not provided any information as far as disclosures on this matter until 6:57 p.m. last night. And in my brief cursory review of that, I did not see anything that pertained to the failure or refusal to report alcohol or unauthorized substance under Rule 1.8A5 or the confirmed positive drug screens under 1.8L. I'm not saying they're not there, I just simply haven't had the opportunity to review them. I had a criminal matter up in Atala County, Kosciuszko yesterday, and I didn't get back until the afternoon. And I started prepping my witnesses for the hearing. Was aware we were going forward with after this one and the one I have tomorrow. So it could be there, but it's not stated in the affidavit. It's not charged properly. It's not given notice. The second thing I say is the complaint. Well, let me finish talking about that one, about the, well, there's two components to notice. You have the due process under the Fifth Amendment. Every one of you sitting on that board, and Mr. Conjolas, you as an attorney, and me as an attorney, and these two attorneys over here, we don't have a right to a license. That's a privilege. But once we obtain that privilege under the law, it becomes a property interest. That's the law. Nobody's going to dispute that if they know the law. And in order for your property interests to be taken away from you or infringed or disciplined, you're entitled by law, by the U.S. Constitution, to have notice, substantive notice of what your charges are so you can adequately defend them. Otherwise, if there are imperfections in the way something is done, then an agency or a board, whether it's the nursing board, the medical board, the bar, the surveyor's board, they can say anything they want to and not give you proper notice and just get you in front of a hearing and take your license away. So what the protection is we have is the U.S. Constitution, due process. That trumps every board's regulations, that trumps every state statutes and every state's constitution. So under the Fifth Amendment, this complaint does not comport and comply with the Fifth Amendment due process notice requirements. It's unquestionable. There is U.S. Constitution case law that I cite here. Let me read it. It should go, wait a minute, further, and this is the quote, the notice must be of such nature as reasonably to convey the required information. Now that's from the U.S. Supreme Court case of Mullane versus Central Hanover Bank and Trust Company. That is a 1950 case. That's how old this law is, citing a 1914 U.S. Supreme Court case. And it has also been cited by this state under Mississippi State Board of Contractors versus Hobbs Construction, as well as many other cases. I didn't go through the exercise of trying to cite them all in a string cite, but it's recognized law. If you're a licensee, in order for someone to discipline or take away your license, you do have rights, although it's not a right to have a license, it's a privilege. But once that is conveyed to you, you do have rights in the manner and methods in which it's attempted to be disciplined or taken away from you. There's another notice provision under the Mississippi statutes. The Mississippi statutes under, let me see if I can find that, if you'll bear with me. Under a Mississippi Code annotated section 73-15-31, which I have not cited directly. There's a manner and method in which notice.
Excuse me, you said 31?
Correct.
Yeah.
There's a manner in, that is entitled disciplinary proceedings. That's the title of that section. I'm trying to find the one on the there's a particular statute that I'm looking for that pertains to actually giving the notice. Let me see if I can find it. It may be 29. I may be mistaken.
I'm going to ask a question at this time.
Sure.
Council, for the board, as far as the importance and requirement of due process notice of the allegations against you, are you willing to stipulate that that is what the law states?
Willing to stipulate that Mrs. Jennings received due process under the law and that she received notice and today is having an opportunity to be heard, which are the two elements of due process in Mississippi.
I'm sorry, I can't hear her.
Yeah, the point I'm trying to make is, with all due respect, Ms. Mercier, I don't think there's a disagreement, but I want to know, sure, from both councils, that the panel and the Board of Nursing understands that they are obligated to give due process notice of allegations and that that is the law. And so I'm just trying to save some time. Can we stipulate to that fact?
Are you saying, can we stipulate?
That point of law? In other words, Mr. Mercier, I'm not trying to take it away from him, but I'm just saying, we're talking about the important right of due process. I think, like you said, we're all attorneys here, and the panel sits and here's a lot of cases. We understand that is a point of law and a requirement of this Board of Nursing to give due process notice of allegations. That's all I'm saying. Yep, we agree to that? Okay. Thank you.
Bear with me. I'm sorry. I'm trying to find this.
Appreciate you. I appreciate the stipulation. I'm just trying to save some time. And I think the question is, was based on the motion and as expressed by Mr. Mercier, question is, was the respondent given due process notice of the charges or allegations against it?
And there's two types of due process. There's the substantive due process and the procedural due process. And I'm looking for the statute. It's either 29 or 31, which states the manner in which the notice is given to the nurse. And it states that there's three ways. They can either give them certified mail delivery. They can give them personal service. If that doesn't work, then they can publish for 3 weeks. And in the certified mail, if you'll look at the last page of the complaint, the complaint itself, last page of it, see, there's a certified mail return card and it's not signed by Ms. Jennings. It says C-19 under the signature. And then under the received by printed name, it says C-19. That card was apparently returned to this board, and this board is using that to try to establish that Ms. Jennings received the original complaint.
But did you say that she got notice of this hearing, which has the original complaint?
She got notice of this hearing through me, but not through the requirement. That's a statutory requirement that can't be waived as far as I know. Now,
How
when
did you get notice?
I got notice because we entered into an agreed order of continuance. So the first one, there's only,
Was your client there?
no, my client was not there. That's something that Ms. Saltzman and I worked out. And the panel, I don't know if it's this panel, but a panel agreed to it. And we have an agreed order of continuance.
All right.
But I guess what I'm saying is I'm not conceding that that satisfies the statutory requirement of service by certified mail.
Understand.
The last thing was actually the next to last thing is that there's a requirement in the regulations under Mississippi Administrative Code 30, 18, 28, 25, 1.7C. And I can turn to that one. And it's entitled, Part C is entitled Disclosures. And it says that parties shall comply with disclosure as requested within 10 days of the day the request was made, or within 10 days of which the information or material was acquired by possession, custody, control, or became within the knowledge of party. Both parties shall make every effort to facilitate disclosure in a timely manner prior to a scheduled matter before the board. Now I want to go back to that first part of the first sentence. The parties, that's both parties, the board and the respondent, shall comply with disclosures requested within 10 days of the day the request was made.
Right.
If you'll look at Exhibit 2.
Excuse me a second. I don't think we have exhibit 2.
Talking about exhibit 2 to his motion to dismiss that he filed today.
Do we have it?
It should be in your folder, yes.
No.
An affidavit.
We have that. So you do? Okay, thank you.
Here, I can get it.
Let me give you another copy, maybe the copy machine. So I just switched copies. Missing one.
Okay, you can proceed.
I'll continue. Exhibit 2 is an affidavit from Jessica Welch. She's my paralegal. She's giving testimony under oath that in June of this year, 2022, this is paragraph number 4, she personally delivered to the Mississippi Board of Nursing at this location the request for disclosures attached as Exhibit A to the affidavit. And if you turn over to Exhibit A, there's a request for disclosure under pursuant to Mississippi Code annotated, Mississippi Administrative Code 30, 18, 28, 25, 1.C4. And as is my custom, I usually try to repeat verbatim exactly what the regulation allows to be requested. I do this in just about every single case. So that's what I had requested. That was not provided to me within 10 days of any date during the month of June. It was provided to me yesterday evening at 6:57 p.m. by Mr. Walker. And the reason it was provided to me when I first learned from Ms. Saltzman that this hearing was going to go forward, because I didn't think it was, I didn't have the disclosures. I asked for a continuance and I didn't hear a response from her. What I did get was an email from Mr. Walker saying that, here are your disclosures at 6:57 p.m. and they will be prepared to go ahead and go forward tomorrow.
I'm sorry, I think you misspoke because I did respond. The email is in your folder.
Well, as far as whether or not you would agree or not object,
Wasn't my case, but I did respond.
I had no prior knowledge of Mr. Walker's involvement. I never met him or heard of him till today. So I'm sorry. I didn't know whose case it was. Nobody's informed me that. This case first started off with Ms. Avery Lee, and then it went to Ms. Saltzman, and now it's with Mr. Brandon Walker. So, I mean, it's been through 3 attorneys at least. But nonetheless, I didn't receive it until 6:57 PM, and it still doesn't comport with the requirements of the regulation because it doesn't give me the witnesses.
May I ask a question? Mr. Mercer? On the affidavit, Ms. Welch could not specify the date in June that she personally delivered this.
No,
She just couldn't remember.
no. I mean, we're busy. This is my first time to be in front of you,
Yes.
but I handle a lot of cases for medical providers here, the medical board, pharmacy board, dental board. I handle a lot of them. And so she couldn't remember specifically when, and she does almost all my work for me.
And with all due respect to you, you do appear before the Board of Nursing.
Yes, for 15 years.
And you are familiar with the rules and procedures that are required and that govern these hearings. Is that correct?
And yes, sir, I'm speaking about one right now. And in all due respect to you and this board, I think the rules should work both ways, not just against the respondent. And, but I think it should work also in favor of the respondent and against the board.
And board takes due notice of that, so. And I agree.
As even this, and let me just tell you my thought process, if I may.
Yes.
All right. I sought to get a second motion for continuance. And there would be no prejudice to the board. The only prejudice would be to my client if she did not obtain the continuance, so I could get the disclosures and prep her and review them and prepare to make a presentation to the board so that you can have everything you need to make a sound decision. I did not get that from either Ms. Saltzman or Mr. Walker last night. This morning, I came over here to the board at 8:30. Actually, I'm sorry, I think it was 8:33 because Ms. Saltzman was already seated here. And I presented her the second motion for continuance that I had drafted this morning to make it formal because I didn't know, if she felt uncomfortable having to, agree to it. I don't know the position that the board is taking now with you counsel, but I wanted to do it the right way. So I came in and presented to her. She said, I need to speak to Mr. Walker. So she got Mr. Walker to come in. We went into the hall and he wouldn't agree to it. He said, you can present your motion to the board. So let me
I'm just trying to
okay.
keep us, but I want to be sure we stay on the issue of the motion to dismiss. And so can we get back to your argument and the merits of that right now?
Yes, because it's all part of it. I'm sorry, I'm going kind of around the world on it. Here's where it comes back home. I saw that there were imperfections in the complaint.
Yes.
And as you mentioned, I practiced for this board. In the 15 years I've been before this board, working with Brett Thompson and Wesley Mutziger, we always work things out. If they had something wrong with a complaint and they needed to amend it and redo it, I didn't complain. If we had a hearing scheduled and they had a witness that couldn't come, wasn't available, I said, fine. If they had some documents that subpoenaed and weren't here, I said, fine. We always worked it out.
Yes.
So in order to protect myself and my client, though, I saw, okay, let me look at this. If they want to do it that way, then I've got to assert these defenses. But if it had been a continuance, then they could remedy the problem and I would never have to file the motion to dismiss to begin with. It would be a moot point. It'd be moot.
Understand. Is there anything further on the motion to dismiss?
I don't think so.
Counsel to the board. Response.
Just as some background,
Thank you,
this
Mr.
case
Martin.
was originally scheduled for June the 9th, 2022. That is evidence today. And these documents, Mr. Counsel opposite, Mr. Messier, called me the week before July 20th and requested a continuance from the July 20th date. We entered into an agreed order of continuance that's also in your packet that references that he acknowledged that this hearing was set in July on the 20th. It also acknowledges that he authorized waiver any further service of process for hearing, and it set the new hearing date within the agreed order of continuance that he electronically signed on July 18, 2022. Now, last night while we're in hearings, I checked my email. I try to be nice. I provide him with what the order I believe will be of the day. He then responds back and immediately. wants
Excuse me,
to
the
continue.
order of cases.
Yes, because he wanted his cases to be at the end of the docket today. So I respond back, and then he immediately responds back and tells me that he didn't know about Jennings and it was gonna have to be continued. I referred that, I sent that email to Mr. Walker and said, this is your case. He came in this morning on the day of the hearings requesting a motion for continuance in this case. This is not the second continuance. This is the third. It was set in June, July, and October. Also, in his motion to dismiss, he talks a lot about notice, but due process in an administrative hearing is two elements. There's two elements: notice, 3 months of this. Hey, I don't know, Mr. Messier cites to these rules, but they're rules that benefit us too. But back to due process, it requires notice and opportunity to be heard. That was given here. Mr. Mercier knew in June that his client had a hearing. It was reset for July. He knew, he called me the week before and asked for a hearing then. I said, it's kind of late, but I'll give it to you. He had a hearing at the Board of Medical Licensure. Be there in October. Then last night, he suddenly doesn't know anything about this hearing. These requests for disclosure that are attached in this affidavit, I've never seen a request for disclosure for Mrs. Jennings. In fact, Mr. Messier, as he says earlier, has 2 cases on this docket. We complied with the disclosure request on those cases. The disclosure request for his other 2 cases, we sent him the disclosure. We complied. We're not non-compliant. The affidavit he attaches says from his assistant during June of 2022, I personally delivered this.
Okay.
What date?
Let me
On A, the request for disclosure, it's not dated.
Let me interrupt you, just to make it clear for myself and the panel. Are you saying that in the other 2 cases, you did receive this request for disclosures and you did respond?
Yes.
But in
Of
this
course.
case, you did not have received.
We never received anything from Mr. Messera related to Mrs. Jennings'
Thank
case.
you. I just needed to be sure that was clear.
And there's nothing on any of these documents that he's attached that has a date. They're not stamped filed as received by the board. I have done a search of my electronic drive to make sure I didn't miss an email somewhere. I never received anything from Mrs. Jennings. I would have disclosed these documents. I understand that there's a 10-day disclosure time period. I understand the rules. I'm not trying to be hard, but to come in on the day of the hearing and request a continuance,
All
on the
right,
day of the hearing when we have set this, and this is the
All right.
third setting,
Let's just, like I told Mr. Mercer, let's just stick right now with the motion to dismiss.
or I'll continue on. If you look at the second page of his motion to dismiss, he says the complaint filed in this case does not meet the statutory notice requirements of Mississippi Code annotated 7315-3. That statute doesn't mention notice. Number 5, the respondent requested disclosures from the board staff as provided by Mississippi Code annotated. See Exhibit 2 attached here too. However, board staff failed to provide the required disclosures within 10 days as required. Again, the things that he attached are not dated, and I stand on the record as saying I've never received any requests for disclosures in Ms. Jennings' case, nor has Mr. Walker. Number 6, the board does not disclose what witnesses it intends to call at the hearing of this quasi-criminal procedure violative of the confrontation clause of the 6th Amendment of the United States Constitution. That applies to criminal law, not to administrative law. I put a case in there from 2022 in your packet so that you know that the 6th Amendment does not apply in this case. Mr. Mercier wants us to follow the 10-day disclosure rules, but he's not following the continuance rules, which also require that he give us 10 days notice for a continuance. He's following it the day of the hearing when we have a lot of other things to do other than respond to these motions. He could have done this 10 days out in compliance with the rules, but he chose not to. He had that option. He didn't do it, but he had that option. But he wants us to follow rules. And ironically, by the way, the 6th Amendment, speedy trial.
All right, is there anything further?
You know, I just want to say, being on the other side of this, it's very disingenuous to state that you have submitted requests for disclosure to council opposite when you have not. And then request a continuance based on those disclosures requests. Thank you.
Okay, is there anything in rebuttal?
Yes, first of all, let me say that there is an error on the statute. I said 73-15-3 in the motion. She's correct. And in my haste this morning to get it done over here before 8:30, I left out the 1 after the 3. It's 73-15-31. And, you know, specifically, it's on subparagraph 1 of that statute. So I do apologize for the typographical error. As far as whether or not Ms. Saltzman has received the request for disclosure, I'm not saying that she did receive it, but I have seldom, when I have brought something over here or my paralegals brought something over here, do we file it with the lawyer? We file it up front. That's how it's done. The lawyer doesn't come out and take it out of her hands. There's been 3 lawyers on this case. Even if it were to go to the lawyer, you have Avery Lee, you have Ms. Saltzman, you have Mr. Walker. So there's at least 3 lawyers. But that's not what the rule requires. If you read the rules say it's required to either be sent to this board by certified mail or hand delivered. My office is 2 blocks from here. Most of what I do is hand delivery. I do send some things certified mail, but most of it's hand delivery because it's just so much easier and not as cumbersome. You don't have an affidavit or any testimony from whoever sits out front during June the 6th or 7th, any day during June, to contradict what Ms. Welch says. Ms. Saltzman doesn't sit out front. She's got an office in the back. So all I'm saying is she talks about disingenuous. It's not, there's no requirement to deliver it to the lawyer. It's to file it with the board.
Okay.
I have one more thing. This is considered, and I can pull the law up for you. I didn't think it was necessary, but looks like I'm gonna have to do it. This is considered a quasi-criminal proceeding. When you have a licensee's license involved, it is a quasi-criminal proceeding. I'll be happy to provide you with the Mississippi law that says that. So yes, the confrontation clause in due process are applicable.
Anything in rebuttal from board?
The only thing I will say is that Mr. Mercier is well aware of today's hearing. If he dropped the ball, he dropped the ball. It's not because either Mr. Walker or myself had any type of intent to not disclose anything pursuant to the rules. He makes a lot of arguments about the rules, but again, he forgets that he didn't request disclosure from either one of us pursuant to the rules. He didn't request this continuance until the day of the hearing. There's a reason there's a 10-day requirement in the rules. He electronically signed and sent back an agreed order of continuance, acknowledging the hearing was set for the second time on July the 20th. He authorized waiver of any further service of process and agreed that it was noticed for Wednesday, October the 5th at 8:30. He signed this on July 18th, 2022. He comes in today and he makes a lot of arguments about his client not getting notice. He's had August, September, 2.5 months, almost 3. He's had notice.
Let me ask you a question. And that you talked about continuance and you've talked about continuance. How many continuances have already been granted in this case?
This is her 3rd setting.
This is a 3rd request. All right, as far as the motion to dismiss, what is the process in as far as delivering to the board pleadings and things of that nature? How are they distributed internally when the mail or the personal service comes in?
Mr. Mercier is in fact correct that it says that they should be dropped off at the office or sent by certified mail. However, on all the cases I've worked with Mr. Mercier so far, everything has been done electronically. All the disclosures, all his requests, all his motions, everything that I've received from him has been done via an email.
So, but if something was dropped off, how do they know where to deliver? How does an employee of the board
The receptionist would stamp file it.
stamp out and then she'll just
Give it to us,
either give it to you or to
Mr. Walker,
Mr. Walker.
put it in our mailbox or call us to come get it.
That's what it looks like right there. I filed this by hand, not electronically today.
Right.
When I'm required to file something, 9 times out of 10, I'm going to be bringing it over here and just dropping it off by hand, or my paralegal brings it and drops it off, because that's what the rules say. I don't want to get hamstrung in a situation like this. With Brett and I, we cooperated. It wasn't a problem. Ms. Saltzman and I have only been dealing with each other for a few months, so we don't have a lot of experience together. But when I do file things, I have no way to file it electronically with the lady up front. So it gets this stamp on it right here. If I can, I have to ask for it. They don't always give me the stamp. I have to
She
ask
didn't
for
ask
it.
for the stamp. Your
What?
your paralegal did not.
I do not know. She's off the rest of this day because her birthday is tomorrow.
Obviously, she didn't ask for it because it's not in her affidavit. I mean, that would have been an important part to put in there, right?
I don't know. It was hurriedly put together. Everything this morning has been pretty hurried. If you would like for me to try to get more information, I'd be more than happy to do that. But this is what I brought over. This is the way I do it.
All right. But your paralegal brought it, right?
The request for disclosure, yes. And let me say one last thing. There is a difference between, I think you pointed it out, what's filed up front and distributed versus what I may email to somebody under a certificate of service or something of that nature. And so when I have to file something, when it's to be filed, that's totally different. And that's not what the rule says. The rule says, as we both agree, that it's either dropped off here by hand or sent by certified mail.
Does the panel have any questions about this matter that you would like to address to either council?
I have a quick question. How many continuances is normal?
I have only been here since the middle of June. The rules provide that you can give up to 2 continuances. I'm sure that in the past, just based on the dockets that I've seen, probably council previous was probably a little more generous with that. And there could be various reasons for that. But the rules provide that you can request up to 2 continuances, but it's a may and it's a rule.
Right, no, I understand. I just, in my experience, I've not seen us go beyond 1, sometimes 2. So that's my question. Thank you.
Okay, if there's anything further from anybody on this motion to dismiss.
Well, Ms. Saltzman and myself got into the second motion for continuance, and I'm not aware that there's 3, but
I'm sure the record.
Yeah, from the time that I've been hired, this is the second one. But I'm assuming you don't want to hear the second motion for continuance until you rule on this.
I hate to, I don't know of any other way to do it than to see if the panel wants to go into executive session to decide the motion to dismiss. I know that's dragging things out, but I think that's the only way to properly handle the motion to dismiss. Then we'll take up the motion for continuance, because on the merits, there's 2 different arguments. There are a lot of same procedural arguments that can be made, but on the merits of each motion, there are 2 different arguments. So do I hear a motion for the board to consider going to executive session to hear the motion, to deliberate and decide on the motion to dismiss?
I'll make the motion.
There's all in favor?
Aye.
All right, is there a motion to go into executive session to hear the motion to dismiss?
I'll make the motion.
All in favor of going to executive session? So the hearing panel will go into executive session to consider the motion to dismiss at this time. And as soon as we deliberate and reach, as soon as the panel reaches this decision, we'll come back in and announce.
I would be writing it. No.
Okay, we're back on the record. And do I hear a motion from the panel to go back into regular session? All in favor, go back into regular session?
Aye.
So we're back in regular session and the board panel, hearing panel has decided after deliberation and discussion to deny the motion to dismiss. So what's next up for consideration or hearing is the motion for continuance in this call.
May I proceed?
Yes.
You have before you the second motion for continuance of hearing. According to Ms. Saltzman, this is the third motion for continuance. It's the second motion I'm aware of, second motion that I have filed. Under the rules, if there are unusual circumstances, then the board can grant a motion for continuance. In what I had testified to, or not testified, but what I had stated earlier was that this is unusual. I've never had this happen before. And in my 15 years over here, I've never had a situation where a request for disclosure was not given to me until the night before the hearing. So there's no way that I am able to review those, meet with my client, prep my client, and come forward today to be able to present a defense. The prior motion for continuance, as Ms. Saltzman stated, was requested because I had a conflicting hearing date with the medical board on the same date as the hearing here at the nursing board. And that was agreed to and it was granted. I don't know technically and procedurally how that works with this board. Since it was an agreed order, I don't know if that is the same as the board granting its own order. That's not an agreed order. But in any event, this is the second one that I have filed. And the reason for the filing is because I did not receive the required disclosures. Now, if there is, well, and in my position is that constitutes unusual circumstances. If the board decides that it can't grant more than 2 continuances, if there has been if this would be the third one, then I would ask the board, what is a respondent to do if there have been 2 continuances and something does occur that constitutes unusual circumstances? Let's say the respondent has a stroke, is hospitalized, or there's a witness that for whatever reason can't get back in the country. There's a numerous things that could happen. So there has to be some mechanism, some provision, I would think, to take care of a situation that is unusual and that would prejudice another party. If there was another continuance, there would not be prejudice to the board. It may say, well, we need to go ahead and have this case addressed, but that's not prejudice in the meaning that we normally ascribe to it. Prejudice is when a respondent doesn't have the documents that are needed to be able to go forward with the defense and the hearing. Now, as far as the documents, you've got in the record there before you with the prior motion that was denied, the affidavit of Jessica Welch saying that she delivered the request for disclosures here. And there's no requirement, as mentioned earlier, that they be delivered to the attorney. It simply says here, there's sworn testimony from her, from my paralegal, that says she did it. And that's my normal course of business. That's the way I do things. When I file these other things, I'm going to be filing the request for disclosure. I may even file more than one just to prompt the board, which I've done. Because I like to get updates, and sometimes I don't get updates, but my client's telling me, hey, there's some more information out there. And so I just, either send an email or I just file a separate request for disclosure, more than one. But I guess my point is, in this situation, it is unusual, and that should constitute good cause for another continuance, because there's no doubt that the respondent here, my client, will be prejudiced if she's forced to go forward, just having received partial disclosure last night and still not a list of who the witnesses would be. So, I'm still at a disadvantage, even if you say, well, they gave it to you last night. I still don't know who the witnesses would be. The only witness I know is Avery Lee, who I would like to call. That's the only one that's listed I have any knowledge about. So no, Avery Lee is the charging, she is the charging witness in the.
Request the board and subpoena them?
I did not. It is the board's witness that made the complaint.
But the respondent, I'm preaching to the choir, the respondent has the right to request the board to subpoena a witness.
Well, considering that it is the board's attorney, or it was the board's attorney, that seems like a misnomer. They'd be like me subpoenaing Ms. Saltzman or Mr. Walker. They are the charging witnesses who work for the board.
Right.
So I guess what I'm saying is, there's, I think, a broad list of unusual circumstances that you can say constitute good cause for a continuance. This is not something as mundane as saying, well, the client doesn't have enough gas money right now, or the client's going to be inconvenienced, or even me saying, that I have another conflict, because, I don't think I've ever had two conflicts in a row like that, but it could happen. But this is an unusual circumstance, and it's not happened in my 15 years of practicing over here at the nursing board. I've never been before this board asking for this kind of relief. Never been before the medical board and asked for this kind of relief, or the pharmacy board, or the dental board. This just normally doesn't happen. So it is unusual. And so I am asking for another continuance.
Counsel for the board.
I think we've somewhat been through it, but I'm just going to point out on the second motion for continuance of a hearing, second paragraph, and this is submitted and filed by Mr. Messier previously on or about June the 6th, 2022. Respondents Council made an entry of appearance and made respondents' first and only prior request for a continuance, and requested disclosures be made by the board in accordance with Part 2825, Rule 1.7. There's obviously a dispute about whether those requests were ever received. The requests that he does and has attached to the motions to dismiss were not dated. They weren't stamp filed. I've represented on the record that I did not receive them. But all that aside, his client's case was set on June the 9th, July the 20th, and October the 5th. This is the third setting for his client. He did not request disclosure from me at any point of documents. Last night when Mr. Walker sent him a copy of the documents, it was a courtesy. Even then, he didn't ask for the documents or for a witness list. We have no obligation under the rules to provide him anything if he doesn't ask for them first.
What was the document that board counsel submitted to him?
The second motion for consideration of hearing in paragraph 2, he acknowledges that he's had this case since June the 6th, 2022.
Okay, thank you.
And then in the agreed order of continuance that he and I executed and agreed upon when he called me the week before the last hearing. It says that he authorizes waiver of further service of process related to this hearing. And it further goes on to set the hearing and continue it until Wednesday, October the 5th, 2022 at 8:30 a.m. Now, Mr. Messier has gone to great lengths today to assert that I have somehow not responded properly to discovery. And I do feel it's a little bit of a personal and very disingenuous attack. However, that is not the case. I would have agreed to a continuance, but we can't have continuances on the day of if there aren't extraordinary circumstances. The rule requires exigent circumstances. He continues to quote the rule. It says exigent circumstances. What are those? He has been representing this client since June the 6th, 2022. What are those circumstances? He had a client, she's had 3 hearing dates, and he is here today asking for yet another one. The board panel sits 6 times a year. It takes a lot to get a group of individuals together. I understand that things happen. If he had had a stroke, as he mentioned previously, I would have granted the continuance. However, this is not an exigent circumstance. He has known about this since June. Thank you.
May I respond?
Yeah.
The rule doesn't say exigent circumstances. You're free to look at it. It says unusual circumstances, nothing about exigent. That's a higher standard and a higher bar she's trying to ascribe to it. It just simply says
It's
unusual
correct.
circumstances.
It says unusual circumstances. We're
It's-
1.7 AC.
As far as anything personal, it's nothing personal. There have been multiple attorneys who handled this file, and I don't know what else has gone on internally. It could have gone across anybody's desk. I don't know. I mean, I don't know internally how things work here. So I'm not trying to attack Ms. Saltzman, but I am saying that the board did not provide the requested disclosures. I don't know if that's Ms. Saltzman's responsibility, a paralegal's responsibility. I don't know whose responsibility it is. I just know that they haven't been provided. Now, she tries to make some hay out of the fact that there's not a date on the she tries to say that there's something to do about the fact that there's not a date on the request for disclosure that was filed. Well, there's also not a date on the notice of appearance of counsel and first motion for continuance of hearing. That's, if you look at the end of it, it's not dated either. So, I mean, that's neither here nor there, but
Don't you agree that the date would be helpful? On this?
absolutely a date would be helpful. But I can promise you that I can go in my files and I can pull some of the documents and cases that I have filed in this board that don't have any dates on them. But I can otherwise prove they were filed because they were used at the hearing. I mean, everything doesn't get filed stamped when it comes over here. I don't date everything that I file. Maybe I should. I do in circuit court or chancery court, but this is an administrative hearing. There's a lot of things that are relaxed here, including the rules of evidence. So it's a little different. But what I'm trying to say is I didn't date the original notice of appearance of counsel and motion for continuance of hearing back in June. That wasn't dated either. So, I mean, on neither one of the 2 documents that were prepared about the same time did I put the date on there that I prepared them. Thank you.
Point out is 4.17A. A says a motion for continuance must be filed with the board at least 10 days prior to the scheduled hearing or upon a showing of good cause at any time prior to the hearing. That's the standard. That's what Mr. Messier should have done. We did not receive anything in our office requesting disclosure of documents, and what he was provided last night was purely a courtesy by us. Thank you.
May I add one thing?
Okay.
I think both Ms. Saltzman and I, although we're talking about 2 different positions, the real issue is whether or not prejudice will occur here. I mean, whether or not it was Ms. Saltzman's office, the board staff that dropped the ball, or whether or not it was my staff that dropped the ball, although my staff has provided uncontradicted testimony sworn to, which you don't have any sworn testimony from board staff contradicting that. You simply have generalized statements from Ms. Saltzman. But regardless, if the board wants to do the right thing is to give me an opportunity to review these documents and have a hearing and present what I can to the board so the board can make the best decision possible. There's no prejudice by continuing this. Apparently, they don't have a lot of witnesses they intend to call, but this is not something that prejudices the board. An administrative prejudice is not what we generally consider prejudice. We've got to put it on the docket next time. I mean, you weigh that against the prejudice to a nurse losing her license. And I personally don't think there's any comparison as far as the prejudice goes.
Is there anything else from board counsel? Anything else? Did the panel have any questions?
I got one question.
Yes, sir.
Ms. Saltzman, I got one question. And I just want to make sure I heard right. Mr. Messier was representing Ms. Jennings' case in June.
Based on
July.
his second motion for continuance, if you look in the second paragraph, he says on or about June 6th, 2022, he made an entry of appearance.
So what I'm hearing is he's had since June to represent to protect her license.
He
Is that
has,
what I'm hearing?
yes.
And so in June, in July, and now in October, he's not prepared to protect her license. Is that what I'm hearing?
I will just state on the record that he has been her counsel of record since June the 6th, 2022.
Good enough, thank you.
Okay, is there any further questions from the panel? One thing I just want to point out, and it's important, to be fair to all parties. And it's also important to deal with the substantive issues, because that's what's really critical here as far as prejudice. There's a temptation, and I don't think it's proper, to ask board counsel, let's go through the request for disclosure and see what the answers are. But I'm not going to do that, because I don't think that would be proper. The answers to the request for disclosure. I think panel needs to decide on this motion for continuance. And then we'll let the record speak for itself and we'll move forward after that. So is there anything further that we want to talk about before we deliberate?
Okay, Your Honor.
I don't think so.
Do I hear a motion to consider going to executive session to deliberate and rule on the motion for continuance?
I make the motion.
All in favor? All right, is there a motion to actually go into executive session to determine whether or not to grant the motion for continuance?
Make the motion.
All in favor of going into executive session? We'll go into executive session, the panel will, and we'll get back to you shortly. Is there a motion for the hearing panel to go back into regular session?
Motion.
Second that.
All in favor? All right, we're back in regular session and board panel has considered and deliberated on the motion for continuance filed by respondent Stacy Giddings, license number R-893757, and has rendered the following decision. It denies the motion for continuance. So it's time. I think we move forward. Okay. As all parties are aware, there's a procedure that is usually followed in these hearings. Both parties will give an open statement. Board counsel will present the board's case first, then the respondent will present his case, followed by the board counsel's rebuttal. Then we'll have closing statements. Rules of evidence are, we don't follow strict rules of evidence as we've already discussed. After direct, then cross, and then redirect, the board panel may ask the witnesses questions. And after the conclusion of all the witnesses, presentation of the witnesses and their testimony, all the presentation of all the other evidence, the board will deliberate and render decision and determine the findings of fact and conclusions of all. The written decision will be sent to the licensee within 30 to 45 days after the conclusion of this hearing. At this time, I just want to restate for the record that Ms. Stacy Jennings is not present today, but her counsel, Doug Mercier, is present and representing her. Is that correct, Mr. Mercier? Correct. So, are there any preliminary matters that we need to talk about? Any further preliminary matters?
Yes, Your Honor, we'd like to introduce into evidence exhibits B1 through B15.
Mr. Merced, do you have any exhibits you want to introduce? Or
I don't think any that I want to introduce, but I have some objections to the exhibits that we just.
Can you state those objections?
Could I have just a minute to look through them?
Yes.
Mr. Cajolis?
Yes, Your Honor.
The respondent does not object to exhibits B1 through B4 or B6 through B10 or B12 through B15. The respondent does object to exhibit B5 and exhibit B11.
Okay. Can you state the basis for your objection?
Yes, as we've already discussed previously, the complaint, which is exhibit B5, does not comport with due process. And it makes allegations that for which specifics are not provided. It was not served on Ms. Jennings in accordance with statute. B11 is not it's an agreement, but it's not fully signed. If you look at the last page, it's not signed as proved and accepted. That's my only objection as to it.
Response of counsel for the board.
As far as, Your Honor, as far as B5 is concerned, it states sufficient facts to charge the respondent with. It states that she did not comply with the terms, and it states when she didn't comply with those terms. I would also further point out that in the agreed order that has already been discussed, to continue this, he waived any further process, and it was accepted then on its face. So there was no issue with the complaint at that point when he agreed no further process was needed. He's already accepted process. And
It's the same complaint.
same complaint. It's the same complaint that was accepted. As you can see, from Avery Lee on the 6th. Exact same complaint.
What about B11? Is that correct? I mean, yeah. The other objection on
The other objection with B11 is that was signed by, that's only, he's talking about the form. That's not to any, it was also signed, it was signed by Ms. Stacy Jennings. Yeah, and this is just the contract she made to be in the program. This is the term she violated. She signed that agreement, and it's also signed by the MVP representatives for the board. The approved acceptance of form, that wasn't having to sign off by the committee. She's a signed agreement to the contract she entered.
Okay. Anything further?
There you go.
You know, I'm pretty simple, but my contracts professor, taught me that if a document has to be approved and accepted as a foreign substance by somebody, then it should be signed by them. I don't have any objection if they want to introduce one that's actually a document that forms the contract that's been approved and accepted. I mean, just rules. Everybody talks about rules. That's a rule. So, I mean, that's all I'm saying. If you're going to try to hold her to something, to this contract, let's see the contract that's approved and accepted, fully executed, not halfway. That's all I'm saying.
Counsel. The board, is it executed by the committee?
Yes, sir. She signed it on the 4th of March.
All right, I will overrule both objections and introduce the evidence. Exhibits B1 through B15. Okay, Ms. Mercer, do you have anything that you'd like to introduce? All right, so at this point in time, there are no further preliminary matters. Counsel for the board, please give your opening statement.
Thank you, Your Honor. We're here today because Ms. Jennings has violated Mississippi Code annotated 73-15-29-1F, and that she has engaged in unprofessional conduct by negligently or willfully violating any order, rule, or regulation of the board pertaining to nursing practice licensure. Specifically, an MVP monitoring agreement was voluntarily signed by Ms. Jennings on March 4th, 2020. By signing the agreement, Ms. Jennings agreed to be bound by the terms contained in the agreement. This agreement required Ms. Jennings practice total abstinence of any amount and any kind of alcohol, any illicit drug, narcotics, any prescription controlled substances, and other mood altering substances. Ms. Jennings was also required to participate in random drug screenings as part of the program. As part of that drug screening, Ms. Jennings was required to check in with Spectrum Affinity. The agreement stated that she would be responsible for all charges related to the drug screenings, and that a minimum of $75 would need to be kept in her account. Even though Ms. Jennings agreed to these requirements, she failed or refused to submit urine specimens on 5 different occasions. She also failed or refused to check in with Spectrum Affinity on 5 other occasions. It really comes down just to a matter of compliance with an agreement that was voluntarily entered into by Ms. Jennings. Any non-compliance is a violation of the terms of the agreement and Mississippi Code annotated 73-15-29-1 gives this board panel power to revoke, or suspend, or discipline Ms. Jennings for non-compliance.
According to the complaint, that was filed by the board staff, they allege in charge 1 that the respondent has negligently or willfully violated any order, rule, regulation of the board pertaining to nursing practice or licensure, namely Mississippi Code annotated Part 2826, Rule 1.85. In that, respondent failed and refused to report all alcohol or unauthorized substance use regardless of amount or route of administration. It also says that under Rule 1.8L, any confirmed positive screen for which the Mississippi Nurse Voluntary Program has not received prior written authorization and confirmation from an approved provider, and any drug screen that is confirmed as adulterated or substituted specimen shall result in the nurse applicant ceasing nursing practice until further evaluation and receipt of written authorization to return to practice from the MNVP program. As I said earlier, in the motion down below where the specifics are given that's supposed to support the charge, there's nothing there pertaining to any failure or refusal to report alcohol or unauthorized substance use. There's nothing, if you look under specifically regarding all charges, the only thing that is supported with any specificity there is failure to submit urine specimens, failure to refuse to check in. There's nothing there that applies, pertains to, or supports the charge that she violated Rule 1.1A5 or that she violated Rule 1.8L. As far as the other part, the Rule 1.8L, that's the non-compliance, which there is specificity outlined on the face of the complaint there by not, according to the allegation, by not agreeing or by failing or refusing to submit urine specimens or failing or refusing to check in with Spectrum Affinity. Now, I'm sure that we're going to hear about the documentation to support those, but I would like to renew a motion to dismiss that part of the complaint or those parts of the complaint that charge Ms. Jennings with violations of Rule 1.8A5 and Rule 1.8L because it's not listed with specificity in the complaint.
Let record note, Mr. Mercier's continuing objection as stated, and I overrule that. Objection. Is there anything further, Mr. Mercier?
I have nothing further in opening.
Do we have any witnesses?
Yes, Your Honor.
Mr. Mercier, do you have any witnesses?
I have no witnesses.
Okay, we need to get the witnesses sworn.
Yes, Your Honor. We have Casey Loper on Zoom.
Casey, will you raise your right hand, please? You solemnly swear that the testimony you're going to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, counsel. Call your first witness and proceed.
Casey, will you please state your name, county of residence, and current place of employment for the record?
My name's Casey Loper. I reside in Rankin County, Mississippi, and I work for the Board of Nursing.
How long have you worked for the Board of Nursing?
Since June 2020. January 2020.
Will you please tell the board what it is that you do for the Board of Nursing?
I am the program manager for the Mississippi Nurse Voluntary Program.
Can you tell us what the purpose of that program is?
The purpose of the program is to assist nurses who have substance use or abuse issues to transition into recovery and to monitor those nurses as they return to nursing, to assist them in returning to nursing as well as protect the public.
This is a voluntary program, is that correct?
Correct.
Can you tell us how a nurse gets into that program?
A nurse can self-report directly to our program staff. A nurse can also be referred to us internally through the investigations department.
So Ms. Jennings qualified for that program?
She did.
In regards to that monitoring agreement for the MVP program, is it part of your duty to make sure that the nurse applicant complies with all the terms and conditions of that agreement?
Yes.
So you're familiar with the terms contained in that agreement?
Yes.
And the terms confusing in a way that someone would not be able to understand those terms?
Objection, speculative.
Are the terms of that agreement worded in such a way that they're reasonably understandable for a normal person to understand?
Yes.
Would you turn to Exhibit B5 and identify those documents for me, please?
B5 is the certified mail that was sent to Ms. Jennings regarding her hearing from June and the charges against her in the complaint.
On the second page of B5, can you tell me what is charged against Ms. Jennings specifically?
That she failed to submit a specimen on August 19th, 2020, September 2nd, 2020, October 13th, 2020, October 30th, 2020, and December 16th, 2021, as well as failing to check in on 4/22/2020, 11/7/2020, 11/18/2020, 1/27/2021, and 2/3/2022.
What also is she charged with violating MB5?
In the charge one, it does say that she has neglectfully or willingly violated, failing or refusing to report all or unauthorized substance use regardless of amount or route of administration.
In regards
And
to terms of the agreement, does it say whether she complied, is she charged with violating the terms of the agreement?
Yes. It says non-compliance with the contract or unsuccessful termination from the program is unprofessional conduct.
Would you please go to Exhibit B11 and tell the board panel what that document is?
B11 is the monitoring agreement that Stacy Jennings signed on March the 4th of 2020.
Would you please read that first sentence under A? It says binding effects of terms and conditions.
Says by signing this MMVP agreement and entering the program, I agree to follow and be bound by the terms and conditions of this agreement.
You already stated that Ms. Jennings has signed that document.
Yes.
Did she place initials next to that provision on the document?
She did.
Would you go next to Exhibit B15 and identify that document?
Sorry, I'm trying to find it.
Okay.
I don't know why I'm having a hard time locating it. I apologize.
Should say spectrum compliance report at the top.
I have B13 that says that. No, B13. I'm sorry. Never mind. That's why. Okay, I'm sorry about that. Yes,
You're fine.
I have it.
Okay, can you tell the court what that, or tell the board panel what that document is, please?
This is the report that's run in our online system that we use to check in, communicate, submit reports, and that participants are notified of their selections.
Would you go to page 2 of that document?
Yes,
See the date that says 8/19/2020.
yes.
What does it say to the right of that date?
It says no show.
Can you tell us what that means?
It means that Ms. Jennings was selected for testing that day and did not perform a drug test or did not submit a specimen.
And the line right under that has the date of 9/2/2020. Can you tell us what that says to the right of that date as well?
No show.
And the line under that, does it say the same thing?
Yes,
And there are several on that page.
yes.
Are you aware of any other dates that she did not show for a drug screen?
Ms. Jennings has continued not to show for drug screens. The last one on the report that was ran was on 6/21/2022. I'm not sure if she's missed one since then. After they are referred to the legal department, Ms. Jennings and I had a discussion in which she agreed that she was going to continue to check in and continue to drug test as selected. And she has stopped doing that.
If you go back to exhibit B11, and on page 3, under E, during drug screens, in that first paragraph, what does it say Ms. Jennings is required to do in order to be in compliance?
You said under D?
I'm sorry, E.
E. That she's to submit to 18 to 24 drug screens a year. And that can vary based on various reasons. It gives her the check-in information, where to call, the website that she could go to, and the procedure for checking in, and what she is to do if she's selected for testing.
Did Ms. Jennings initial next to that requirement as well?
She did.
So she was aware of that one also.
She was.
Please go back to B15. The first page, there's a box labeled check-in.
Yes.
Can you tell us what that shows?
That she missed 18 check-ins as of the date of the report, which was July the 8th, 2022. She has continued to miss check-ins after that as well.
So if she misses a check-in, does that mean she could also miss a drug screen as well?
Yes, anytime that they miss a check-in, they're at risk of missing a drug screen.
And would you go back to B11 on page 7 and the costs?
Yeah.
The first sentence, would you please read that to us?
I accept responsibility for payment of all costs incurred while a participant in MFPP.
And then Ms. Jennings initial next to that provision as well?
She did.
And also under E, what's the minimum amount that Ms. Jennings was required to keep in her account?
$75.
Did she ever complain of not being able to fund her program, the drug screening specifically?
She did after she had started the program. She said that multiple times that she had issues related to money and not being able to afford testing. Explained to Ms. Jennings that while I understand that people have money issues and things of that nature, that MMVP is not able to distinguish whether somebody will not test or somebody cannot test for financial reasons, and that they are expected to test in order to be in compliance with their agreement.
Would you go to B12 for me and identify those documents as well?
B12 is communications that were documented with communications that were had with Ms. Jennings.
You said these were in reference to money for Ms. Jennings?
Some of them are probably related to some other things, but yes.
And the last date on that message from Ms. Jennings on B12, was it, can you tell me the date on that?
2/24/2022.
And was that the last contact you had with Ms. Jennings in regards to her having issues funding the drug test?
To my knowledge, that's the best of my knowledge would be that last note date. That last note date, yes.
You've done several of these MVP agreements, is that correct?
I have.
Would you say the terms of hers were stricter than on any of the others, or?
Ms. Jennings had less expectations laid out in her monitoring agreement than the majority of our monitoring agreements.
And what makes you say that?
Our participants are expected to attend 3 NA or A Celebrate Recovery Caduceus meetings a week. Ms. Jennings was not given that expectation or the expectation of having a sponsor. She was also not given the expectation of reporting her involvement in MMVP to her employer.
Thank you, Casey. I have no further questions.
Thank you. Ms. Loper?
Yes, sir.
I want to make sure I understand your testimony. You were asked a question by Mr. Walker about the wording of a document being understandable, reasonably understandable to a normal person. You remember that?
Yes, sir.
Which document were you looking at the time?
The monitoring agreement.
Ms. Loper, are you an expert in determining documents that are understandable by people?
No, sir.
Training in that, do you?
Sir,
Training in that, do you?
I'm so sorry, it's cutting out.
You don't have any education or training in that area, do you?
Not in being an expert, no, sir.
You were asked a lot of questions about the results that are shown on Exhibit B15 and the report, excuse me.
Yes, sir.
Let me make sure that I understand what I'm looking at here. This is a comprehensive list of all of the dates that Ms. Jennings was supposed to check in and be tested, and also the results, or what am I looking at?
Yes, sir. So this is a report of the days that Ms. Jennings did not check in, the days that she was selected for a test and the results of that test.
So just so I understand, because I don't know that it was clear for the record, how does a participant like Ms. Jennings, or in this instance, in fact, Ms. Jennings, how was she required to check in on these dates where it says on B15 first page, it says event missed check-in? You see what I'm talking about there?
Yes, sir.
So
she can check in one of three ways. She can check in via the online, any any web browser. She can go to the online website and check in that way. She can check in via the Spectrum app on her phone, or she can call the number listed in her contract and provide her PIN number and check in that way.
And the actual test results, I see in the next section on the first page of Exhibit 15, it says selection. Does that mean those are dates that she was selected to be drug tested?
Yes, sir.
And then what about the actual results of the drug tests? Are those on the third page of B15?
Yes, sir.
Looking at the results for the drug tests, how many negative test results do you have, and how many positive test results? Let me just ask you this way: out of all the drug test results for her on Exhibit B15, page 3, how many are positive?
If you go by like saying that the result was positive, none. If you go by missing a test, being a positive test, then all of the ones that are no showed would be a positive test result.
Well,
so she did not submit a specimen.
Let's first talk about the ones where there's an actual test conducted. All right. So for those where an actual test is conducted, how many are shown to be positive?
None.
Now, you tried to say something about if she didn't show up, that's a positive test. Are you saying you counted as positive, or in fact it would have been positive?
We have no test result to show she's negative.
But you don't have any to show she was positive either, do you?
She chose not to submit a specimen on those days, so we have no way to show she was negative on those days, sir.
Ms. Lucker, I'm not trying to argue with you. I'm just asking you the inverse side of that. And you don't have anything to demonstrate she was positive on those days that she didn't test, do you?
I do not, no, sir.
And all of the test results for Ms. Jennings were reported to the board.
From Spectrum?
Well, yeah, all of these that we're looking at on B15 were reported to the board.
Yes, sir.
Were there any other test results that you're aware of conducted pursuant to the agreement, which is B11, other than what we see on B15?
Not that I'm aware of.
So B15 is a universe of drug test results for Ms. Jennings.
That for the record that we have for the Mississippi Nurse Voluntary Program, yes, sir.
And there's no laboratory result indicating any positive test for Ms. Jennings in that universe that we're looking at?
No, sir.
If you would, take a look at Exhibit B11.
Yes, sir.
You were asked questions about B11, and I guess I may have missed part of it, but in general, how would you describe this document?
This document is the MMVP monitoring agreement, which is a legally binding document once they sign up for the program, which outlines the terms and conditions of which they're to which they are to comply with in order to be a participant and complete the program or be terminated from the program.
And you said it's a legally binding agreement. Is that right?
Yes, sir.
And who is it legally binding on?
By Mississippi Nurse Voluntary Program and the nurse applicant listed as Stacy Jennings.
All right, if you would, look at the last page of Exhibit B11.
Yes, sir.
Who, with the Mississippi Nurse Volunteer Program Eligibility Committee, approved and accepted Exhibit B11?
There's no signature, sir.
Is that the normal way that y'all handle your contracts with your participants?
I don't know what occurred prior to me doing documents and things like that. I do know that this has been removed from the document in the name of anonymity for the program.
I'm not sure I understand what you're saying.
So in order for us to have a eligibility committee member sign off on an agreement, we would have to disclose confidential information. And so in the name of not disclosing confidential information to eligibility committee members, we have taken that off of the form.
Okay, so you're telling me that the identity of the participant is not protected to the same degree as the members of the eligibility committee. Is that what you're telling me?
I'm not sure I understand the question. I'm sorry.
Okay. Are you telling me that the identity of the participant, like Ms. Jennings, is not protected to the same degree of protection afforded members of the eligibility committee?
No, sir. I'm saying that Ms. Jennings, her information is protected more than the eligibility committee, which is why we have taken that off, because we would have to disclose to the eligibility committee who she was in order for them to sign the document.
I don't think we're talking on the same page. Look at the first page of the Exhibit B11.
Yes, sir.
Who does it say is the nurse applicant there?
Stacy Jennings.
So her identity is disclosed on this document. Would you agree?
Yes, sir.
Okay. Can you point to me the provision in this agreement which says that no one with the eligibility committee is required to sign in approval and acceptance, as we see it, the blank on the last page of Exhibit B11?
I can't point that out to you. I'm not aware of that being in the document.
Well, you can take a minute to look if you want to, or you can just stipulate that it doesn't exist.
That it doesn't exist, I want to make sure I'm answering correctly.
Certainly.
Please repeat it.
Yeah, what I'm asking you, just to make sure about this document, is there any provision in B11 which says that a signature for the eligibility committee is not required for approval and acceptance on the last page?
No, there's nothing that says that it is required or not required.
And how long have you been administering contracts for participants?
I probably did my first contract around April of 2020, if I had to guess.
And you would agree with me, for a contract to be binding, it has to be signed by the parties, both parties.
Yes, sir.
And you'd agree with me that this one is not signed by both parties.
No, sir, I would not agree with that. It is signed by Mississippi Nurse Voluntary Program listed as number 1 in the agreement on page 1, and by Stacy Jennings on page 9, which is listed as a nurse applicant number 2 on the as being the parties involved.
I see Stacy Jennings' name there, and I see that that she signed it and her name was notarized. I'm looking for the signature of the eligibility committee that approved and accepted this contract.
Yes, sir. But I'm saying that we've agreed that there's no signature there. But I am also saying that this is an agreement between the Mississippi Nurse Voluntary Program listed on page 1, number 1, and that was signed off on by an MMPP representative signature of Greg Taylor.
I got a question as hearing officer, just for clarification of what she is testifying. 'Cause I don't understand something.
I'm trying to find out.
I'm not, I need to, I would like to ask her a question, just for the record. Ms. Logan,
Yes, sir.
I think you testified, correct me if I'm wrong. Did you say that the signature of the eligibility committee member is no longer required? Is that what you said?
I'm sorry, I can barely hear you.
Okay, what I'm saying, did you testify on the last page of the monitoring agreement that no longer is the eligibility committee member signature required? Is that correct?
It's no longer a part of the form. No, sir.
Now, but on the date this monitoring agreement was executed by the parties, March 4th, was that true?
It was on the form at that time. Yes, sir.
But was it required at that time?
I don't know of any monitoring agreement that has the eligibility committee signature on it. There was debate about confidentiality, and which is why it was ultimately removed by the legal department.
Okay. But you don't know when the legal department removed it?
I would have to go back and look.
Okay, thank you.
Ms. Loper, let me ask you a follow-up question on that. And I'm not going to ask you to try to give a legal opinion, but factually, you'd agree that B11 does not contain a signature of someone with the MNVP eligibility committee.
Your Honor, objection.
No, just,
Twice already.
What did you respond, Ms. Loper? What was your answer?
no, that there's not a signature of the eligibility committee. There is a signature of the MMVP representative.
Thank you. And I want to make sure I understand your position too, because I had a hard time hearing you at the very beginning, and I apologize.
That's
But I
okay.
think you testified that you work for the Board of Nursing.
Yes, sir.
You're an employee for the board, but I didn't hear your position. I know it's something with the MNVP voluntary program, but I didn't hear your position.
I'm the program manager.
And I think you said you've been doing that since 2020. Is that right?
January 2020. Yes, sir.
If you would, take a look at B5.
Yes, sir.
Back up. I'm sorry. Let me take you back to B15. I apologize.
It's okay. Yes, sir.
Let me make sure I understand that any and all test results for Ms. Jennings were reported by Spectrum to the Board of Nursing.
Any of the selections from Spectrum were reported to us.
So any unauthorized substance use that would have been detected for Ms. Jennings would have been reported if you had a test result for it.
It would have been, yes, if she tested positive for any test for MMVP, we would have received those test results. Yes, sir.
And Ms. Jennings wouldn't have had any way to refuse or prevent Spectrum from reporting those results to the nursing board, would she?
No, she would just be able to refuse taking the test to begin with.
But she couldn't refuse to report them.
No, sir, not to my knowledge.
And that's the same for any confirmed positive drug screen detected by Spectrum in the MNVP program. She could not prevent a confirmed positive drug screen from being reported to the board.
Not that I'm aware of.
As a matter of fact, you probably have some mechanism to ensure that it's reported to the board. Is that right?
I honestly don't.
Ms. Logan.
Yes,
is
sir.
there a way for a person who's being screened to interfere with the reporting process at all?
Not that I'm aware of.
Have you ever experienced that?
No, sir. Not to my knowledge.
Thank you.
Ms. Loper, as a part of what information is collected by the program, does the program collect all information regarding drug screens conducted and the test results performed by anybody else other than Spectrum?
Only if we're made aware of that. So if she did not, with her not having to disclose from her employer, if her employer had a positive drug screen, we would not be aware of that because they would not know to let us know.
And by the same token, you would know if there was a negative drug screen by the employer either.
Correct. Yes, sir, that's correct.
The Spectrum does not regulate any other tests except their own, correct?
Correct. If we were made aware of somebody being positive, we, by an outside entity, we would enter that into their documents in the program, in the database, but it wouldn't show as a selection and a positive or anything like that.
Thank you.
Board's indulgence, I think I may be done. I need to ask you a couple more questions, Ms. Loper, about the process.
Yes, sir.
Whenever you said a participant is going to check in, you said there were 3 ways they could check in. Is that right?
Yes, sir.
And if they don't check in on any of those 3 ways, is there any sort of a backup or an email or a text or anything sent to them, say, hey, what's up? Are you in the hospital, or are you out of the country? Do you not have access to communications? Is there any attempt to contact them?
There has been attempts to contact occasionally, but it is ultimately the responsibility of the participant to inform the case manager why they missed a check-in, and to figure out if there's anything further that they need to do.
Yes, ma'am. I understand it's their responsibility, but I guess what I'm asking is there some sort of procedure where automatically there's something generated to the nurse to find out the reason that they missed it?
No, sir. There's nothing automatically generated from this check-in.
Do you know from Exhibit B15 what the reasons were that Miss Jennings did not check in on the dates it says she missed the check-in?
From B15?
Correct.
there would be no way to know from B15 that doesn't include the notes and documentation of accomplishment.
So there's no way to know if, well, let me back up. Are there such a thing as excused missed check-ins?
As an excuse missed check-in, no, sir.
So you miss it,
Well,
you miss it.
There's you can be excused from checking in. So if Miss Jennings were to have provided us documentation of being in the hospital, her check-in would have been excused. If she were to provide us documentation of a procedure that was about to occur, we would excuse her from checking in that day, possibly.
That's what I was referring to. So that there is.
Yes, sir. We have the ability to excuse check-ins. The missed check-ins that were that happened with Miss Jennings were not excused. The ones that are listed, they would not show up as a missed check-in. They would show up as an excused or a check-in not required, depending on the situation.
And if she had submitted what she believed to be an excuse and it was not acceptable to the program, would it be reflected anywhere in Exhibit B15?
No.
Where would it be reflected? Ms. Loper, where would it be reflected?
B12 is a history of notes related to Miss Jennings. There's the possibility that the notes would contain something sent by her that says that she missed a check-in, any discussion that we had related to that. I know that there was one in here that I was trying to find. The notes in here also explain some of the excuse testing that she had and the reasons why. So B12 would contain notes related to Miss Jennings and her participation in the program.
Your Honor, on B15, top of B15, it has a summary. The very first box that says selections, there's a box that says excuse. It's one of the ones that excused, no show, notified, and resulted.
Okay, so that's. Yeah, but that gets reported and that's part of the record and that's part of that system too, besides the notes.
I believe that's what he was asking. Casey, is that what that shows right there? And there's on B15, that first page? And that box that says summary, it says excuse at the top.
So yes, she had 4 excused check-ins. Well, 4 excused tests. Those are for her selections. Her check-ins only reflect missed check-ins. The selections show 4 excused selections. So 4 days that she was selected for a test, that she had what we felt like was more valid of a reason not to test that day and to excuse it. Like her father being in the hospital, and we've received a note from the hospital stating that she could not leave and come back in order to stay with him. Was one of them that I recall. Then she no-showed 7 tests. She was notified of 1 test, meaning she did not perform that test, and she took 35 tests.
So out of all the tests she was notified of, she failed to take 1?
No, she was. So the way that Spectrum has it set up is that they are notified, that's processed, it's resulted. So Miss Jennings was notified of a test, of 1 test, which she did not process that test. She did not perform that test. She was just alerted of the test and did nothing related to it.
When you say she did nothing related to it, and excuse my ignorance here, but
It's fine.
do they go to a testing center? Is that what they do?
Yes, so Spectrum has testing sites all around the nation. And so she selects her testing site and she goes to that testing site in order to perform her test.
Okay, so in this situation, you're saying this one where she was notified, she did not go to a testing site.
Correct. It's the same as the no-shows. It's just listed differently for that one.
For the note, I'm sorry, were you finished?
I was going to say it would take me going back to look at why that was not listed as a no-show and was only listed as a notify to figure out the wording on that one, but it ultimately means she didn't go to the test.
On exhibit B12, you said there were notes there and that might contain information about excuses. And you said the first page of exhibit B15 up in the summary section shows that there were 4 excused. Do you know if the notes in B12 reflect other excuses that she gave that were not accepted other than those 4 that are shown that were accepted?
Not without going through and reading each one.
No, that's okay. I'm just didn't know if you knew off the top of your head how that worked. Now, looking at the exhibit B15, that first page in the summary, it says there were how many negatives?
She had 33 negative drug screens.
And it says 1 non-negative, but that's not the same as a positive, is it?
No, so the wording on that for me is confusing. Non-negative means that it was, it resulted positive. The test result was MRO or medically reviewed to determine that there was fermentation in the urine and that it did not indicate substance use.
So it was not a valid test result. It wasn't valid to show a positive test result.
It does not show a positive test result.
What's the last category there? Value out of range mean?
Value out of range is a specimen that was submitted that did not meet criteria to be considered accurate testing. So some value that you have a window related to creatinine, related to the pH, related to the gravity. And one of those numbers was out of that range and cannot be considered to be a valid specimen.
And the behind the summary or the first 3 pages of the spectrum report, there's the compliance report with drug test results, and it appears to be about another 73 pages, and that's just all the drug test results. Is that what comprises the rest of it?
Yeah, that's a summary of the dates that she was selected for testing, whether she tested or not, the drug test results of that, and then the actual drug test itself and the results. Yes, sir.
What time period do these 35 resulted selections cover for Ms. Jennings?
From the time she signed her contract from March of 2020 until the last resulted one that I show is from 5/11/2022.
Okay, so I got to 5/11/2022. That's the last one you have. And was it positive or negative?
It resulted negative.
What's the first one?
7. Well, the first one that she did attend was going to be on August the 4th, May the 8th, 2020.
All right. So that's a little over 2-year period. I'm sorry, go ahead.
Well, I thought you were asking a question. Sorry.
Under the terms of the agreement that is B11, if this were a valid agreement between the parties, what are the options of the program and what are the options of Ms. Jennings with the missed check-ins and the missed tests that you're showing?
I'm not sure I understand that question. What are the options?
Yeah, I guess I'm saying if this is an agreement, and I have not had time to read it, to be quite honest with you, under its terms, what does it allow the program to do with Ms. Jennings' participation if she does not follow the terms?
We can do multiple things, one being extending the contract, one being terminating the contract. We can increase or decrease drug testing frequency depending on what's going on with somebody. We have the ability to require more extensive testing and a reassessment if we feel necessary. We can take almost any part of the agreement and requires additional expectations. And then we would put those in effect.
So the missed check-ins and missed tests are not an automatic, you get kicked out of the program.
Not unless they become habitual.
Okay. And does Ms. Jennings, on her side of the contract, does she have any recourse or any remedy to try to get back in the good graces of the program if she has missed check-ins and has missed tests?
Yeah, she can attend. We had done counseling meetings with her, letters of concern with her to address her behavior. We made recommendations for her on how to not miss check-ins, including setting alarms, reminders on her phone, having somebody hold her accountable as well. So it's basically correcting the behavior that she is in non-compliance with, and then that would put her back into compliance with the program.
Ms. Loper, this question does not pertain to the missed check-ins or the missed tests, but for the test results that you have for Ms. Jennings reflected on Exhibit B15, those 35 results, do you see anything that indicates a positive test result that would make Ms. Jennings a danger to practice as a nurse?
As far as the test that she performed, there's no positive test result.
Does that mean you don't see anything that would make her a danger to the public based upon the test results?
Based upon the test results that she performed, or based on the test results as a whole?
My question was limited to the laboratory test results. Well, I guess I'll just rephrase it. Based upon the laboratory test results, the 35, do you see anything that indicates a positive laboratory test result that would be indicative that Ms. Jennings would be a danger to the public if she practiced nursing?
Not based on her negative test results.
Thank you. No more questions.
Yes, Your Honor. Casey, I just want to ask one more time. Did Ms. Jennings voluntarily enter into this program?
Yes, sir.
And did she voluntarily agree to be bound by all the terms and conditions of this program?
Yes, sir.
And that meant any check-ins with the affinity and the requirements that they may have.
Correct.
And was the signature of the eligibility committee, that's done to protect the identity of Ms. Jennings, is that correct? So that she is not known by that committee?
Objection to leading.
The rules of evidence don't apply, Your Honor. He's well aware.
As we know, we don't strictly adhere to the rules of evidence. Go ahead.
Thank you, Your Honor.
The lack of signature was due to discussion about confidentiality as it relates to disclosing a participant's information to our eligibility committee.
That's all I have, Your Honor.
Is there anything else, Mr. Mercer? With this witness?
I have no more questions.
Do you have, is any panel have any questions for this witness? Is there any more witnesses for the board?
No, Your Honor.
Mr. Mercer, do you have any witnesses you'd like to present? Further evidence that you'd like to present?
No, Your Honor. I have nothing.
All right, both parties have concluded the presentation of their evidence, so the next step will be closing statements. Counsel for the board.
Ms. Jennings voluntarily entered into the MVP program with the board. In that agreement, she consented to be bound by the terms of that agreement. She was well aware of the financial requirements came with that requirement, yet she repeatedly missed check-ins and had an excuse when for missing check. The board went so far as to issue 3 different letters of concern before issuing a letter of non-compliance. As I said in the beginning, this all comes down to compliance. Did Ms. Jennings comply with the terms of her agreement or not? And she did not. Mississippi Code annotated 73-15-29-1 gives the board the power to revoke, suspend, fine, or place on probation any licensee who engages in unprofessional conduct set out in its rules and regulations regarding the practice of nursing. Mississippi Code Amendment Part 2826, Rule 1.8F states that any non-compliance with contract, unsuccessful termination from the program is unprofessional conduct and is violation of the rules and laws regarding the practice of nursing. Accordingly, we would respectfully request this board panel consider all available options in regard to the license of Ms. Jennings to practice in the state of Mississippi in order to safeguard the life and health of patients. That's all.
Thank you, Mr. Mercer.
First, address the complaint again. And I renew my motion to dismiss the 2 charges pertaining to exhibit. Well, I'm making a motion for summary judgment. All right, because there's been no testimony or no evidence that indicates that Ms. Jennings violated Mississippi Code Mississippi Administrative Code, Part 2826, Rule 1.8A5, or that Ms. Jennings violated Mississippi Administrative Code, Part 2826, Rule 1.8I. So without that evidence, those 2 parts of the charge should be dismissed on summary judgment, although I'm not addressing the non-compliance aspect under Rule 1.8F. The next point I'd like to make is the validity of the contract, I think, is in question. Ms. Loper can't offer a legal opinion about whether or not the contract is binding. You ask her the question whether or not that line existed when this contract was signed, and she said,
That's not what I asked her. I said, was the requirement for that particular person to sign, was that still in existence at the time this was signed?
I stand corrected, and I think she said it was.
I think she said she was not sure. I think that's correct.
Well, even if the contract were valid, and for the sake of argument, let's say that it's valid. What you're looking at, based on the testimony of Ms. Loper, is that out of the test results, the 35 test results, there's not a single positive test result covering a span over 2 years. Everything was negative. So what you're talking about, if the contract is valid, you're talking about the listed check-ins that weren't made and the no-shows. The check-ins, the refusal to submit urine specimens are listed in the complaint as August the 19th, 2020, October the 2nd, 2020, October the 13th, 2020, October the 30th, 2020, and December the 16th, 2021. That's 1, 2, 3, 4, 5. 4 of those 5 dates are from August the 19th, 2020 to October the 30th, 2020. Now that's about 2.5 month period, which anything could have been happening in someone's life. I mean, but all I'm saying is that doesn't span the 2.5 years. The only outlier there is December the 16th, 2021.
So is that going to your argument, the weight of the evidence?
Well, it's in terms of mitigation.
I'm just trying to understand the point of bringing that up.
Because you're talking about a span of 2.5 years.
Right.
And you had 5 missed check-ins, 4 of them within a span of 2.5 months in 2020, after she had just begun the program. And, apparently the program thought that it was okay because she continued in the program for another, I don't know the date that it says that she was supposedly terminated or reported, but these reports on B15 indicate that she's been checked all the way through, I think it said, what'd she say, 2022 was the last one? Yeah. So apparently the program thought that it was not so significant that she missed those 4 check-ins in 2020, right after she began the program, to kick her out. They kept her in and let her keep going and getting checked, and she continued and had all negative checks. So then there was the one outlier for December the 16th, 2021, that she didn't submit a urine specimen.
So there's not proof that she violated that argument?
Absolutely. But I think this board has the right to do what they want to do. I don't think it's a bright line, all or nothing revocation, versus doing nothing at all. I think this board can say that she can remain in the program. I think you've got plenary power to do what you want, what you think is protects the public, and at the same time takes into account the nurse's license and the needs of the public for nurses. I don't think it's an all or nothing. And I think that considering mitigation like this helps the board come to a just decision. Likewise, it says in the complaint that she failed or refused to check in with Spectrum Affinity on 4/22/2020, 11/7/2020, 11/18/2020, 1/27/21, and 2/13/2022. Well, the same logic applies. On those dates that she didn't check in with Spectrum, you have one in 2020, 2 in 2020, 3 in 2020. Out of those 5, 3 were in 2020. But Spectrum said, you're still good to go, and they kept her in the program. So as far as, what happened after Spectrum made the decision to keep her in the program, you have 12/16/21 when she didn't submit a urine specimen. And then in January of 2021, she didn't check in. In February of 2022, she didn't check in. So those are 3 outliers that have the more recent than what happened 2 years earlier in 2020 that the program apparently found acceptable. So now we fast forward and we're here in 2022 and the program says they don't accept it. And the board is saying, well, we think you're in violation and we're not going to accept that anymore. Although we accepted it in 2020, now we're not going to accept it because this complaint was filed May of 2022. So these alleged violations that occurred in 2020 sat there for 2 years or about 2 years before any action was taken either by the program or the board. If they were that serious, why was she allowed to continue in the program and continue doing what she was doing?
I understand.
So based upon the evidence, I believe that there's no evidence there of the first 2 charges that are contained in charge 1, and those should be dismissed on summary judgment. That's my motion to dismiss those. As far as the actual evidence that was presented here,
And that was, for the record, it was overruled.
and as far as the other evidence that was presented here, I don't think it indicates any positive drug screens where you can say that she is she's relapsed and she's a danger to the public. The testimony you heard from Ms. Loper was there are no drug screens, no positive drug screens here from which she could state that the nurse was a danger to the public to practice. So we would ask that the board fashion a remedy that is just and takes into account all of these things. Thank you.
Thank you. Any other further matters before we panel considers going into executive session? Anything else? Mr. Merced, you okay? You okay, counsel?
Yes, ma'am.
Do I hear a motion from the hearing panel to consider going into executive session to deliberate?
Make that motion.
All in favor? Aye. Right. Now, is there a motion for the hearing panel to in fact go into executive session to deliberate this case?
I'm in executive session to deliberate this case.
All in favor? Go into executive session and be back within due course of our deliberation. Thank you for your patience. Is there a motion by the board hearing panel to go back into regular session?
I make that motion.
All right, we're back in regular session. And board hearing panel has deliberated this case. And its decision is that license number R-893757 is hereby revoked with drug-related recommendations. Board's hearing panel decision is based on consideration of all the evidence, which includes the actions and the non-actions of the respondent, Stacy Jennings. Any questions? Okay, written decision will be forwarded to Ms. Jennings within 30 to 45 days after conclusion of this hearing.
I'll request a copy.
Sir?
I'll request a copy.
So, can y'all take care of that?
Yes, Your Honor.
Thank you. Anything else? So, that concludes Ms. Jennings' case and the next case for tonight, as we move from afternoon, is case of license number R-878689 Whitney Gombo. We have a file.
Yes. Her file. She's grabbing them right now.
Oh, excuse us, we're getting the files from here.
Thank you.
You might need it.
Ms. Gombo, you are represented by counsel today, correct? By Mr. Mercier? Deanne, are you gonna be counsel for the board on this?
Yes. I will be.
So, counsel for the board and Mr. Mercier, are there any preliminary matters that we need to discuss now?
Your Honor, I'd request that we introduce into evidence exhibits B1 through B13, as well as respondents exhibits R1 through R4. And R4 contain A, B, C, and D.
A, B, C, and D?
Yes.
Is there any objection from either counsel to board exhibits and to the respondents exhibits?
On behalf of the respondent, there's an objection to B8. The objection is that the document constitutes hearsay. There's no witness to question regarding the information, the observation, its accuracy, or its authentication.
Any other objections?
Objection to B9 and B9A. B9.
Yes, sir.
It contains multiple layers of hearsay. I know that the rules of evidence are relaxed, but we have a statement where someone says, I talked to someone who had a friend with a friend who told me somebody else told me something. That's quadruple hearsay. Exhibit B9 contains that in the first paragraph. And I think that's the only place it's contained in the first paragraph. Again, B9A contains similar multiple layers of hearsay. In like beginning of the text line, maybe going down.
In response, Your Honor, hearsay is admissible so long as it has some sort of relevance in administrative proceedings. Clearly, it's relevant. These individuals witnessed Mrs. Godbold's actions on the day in question and put their, what they saw and what they understood down on the statement.
May I respond? Let me ask you a question of counsel. Counsel from the board, could you explain what V8 is, visual observation technique?
Yes, that is actually, it's truly part of the checklist for suspicious activity. If the hospital or their personnel suspect that an employee is under the influence of some type of mood altering substance, they will complete that.
And so that was completed by,
You see on the next page, Whitney Godbold signed it, the supervisor signed it, Jennifer and Marianne Croft, also the author of some of the emails that are the subject of the objection.
okay, so based on the signatures, the name, the employee, so that was signed by the supervisor?
It's signed by the supervisor and witnessed by Marianne Croft. I believe they wrote in Whitney's name, but she did not sign.
All right, you had a rebuttal to her argument, I think, concerning B9. Is that right?
B9.
Yes.
But B9 and B9, yes. I understand that because this is an administrative hearing, you're gonna have documents which say, you know, you're reporting on something from coworker or things like that. That's not what my objection. My objection is multiple layers of hearsay. I'll give you an example here. It says, Laura Beth shared with Mary Ann that she had been told by a friend that Whitney had claimed yada yada. So that's three layers there. And then it says Laura Beth's friend stated that Whitney's husband told her out. I mean, that's four layers right there.
Your Honor, if we didn't consider hearsay, then the Board of Nursing would never get a complaint at all. Complaints are hearsay. They're made and then we investigate. This is typical administrative procedure. Hearsay is admissible.
My objection is not the other hearsay that's throughout the document. It's the multiple layers of hearsay which give rise to the question, you know, the questionable nature of its reliability. That's what, you know, that's what hearsay is all about. There's what 24 sections of hearsay rules and procedure.
Which don't apply here, Your Honor.
I understand that, but the principle applies, and that principle is reliability. And when you have five people, you get something from five people removed, the reliability issue certainly is prejudicial.
And this board panel is certainly capable of considering the layers of hearsay that you referenced.
Ms. Hershey, is there anything you want to add for the record based on your objection, to your objection?
No, that is my only objection. It's just the multiple layers of hearsay. I don't object to this, the single hearsays here and there in the documents. You gotta have that single guy. I understand that.
All right, I'm going to go ahead and overrule that objection and the objection to BA. I'll admit both of them into evidence. We will admit B1 through B13 for the board into evidence, and also R1 through R4, including A, B, C, and D of R4. And the record will note your objections. Thank you. Okay. Are there any other preliminary matters? I think we've got the exhibits dealt with. Is there anything else? Okay, let's go ahead and let's swear in witnesses for the board and witnesses for the different other respondents.
I have Whitney Godbold and Dave Godbold for the response.
Okay, and then
I'm sorry, Hosina Jones, investigator at the Board of Nursing.
so please give them the oath.
Yes.
Okay, we've already discussed our procedures in the prior hearing, and the same procedures will be followed here as far as examining witnesses and be the standard direct, redirect, rebuttal, opening statements, closing statements. The one thing that's a little different here is after each witness, the board members of the board panel will be allowed to ask questions. And as we know, at the conclusion of all the evidence that's presented, including all the witness testimony, the board panel will excuse itself, go to executive session to deliberate the matter and to render its decision. A written decision will be sent to you, Ms. Gabo, within 30 to 45 days after the conclusion of the hearing, and also at Mr. Mercier's request, a copy to him. For the record, this hearing is open to the public. And for the record, there's a quorum of the board hearing panel present today. And this time we will proceed with opening statement by Councilman Green.
The evidence presented today will show that Mrs. Gabel has violated Mississippi Code Annotated 73-1529-1L, and that she engaged in unprofessional conduct by practicing the profession while under the influence of alcohol or other mood-altering substances, as evidenced by her refusal to submit to a drug screen. Between August 10, 2020 and August 11, 2020, facility personnel observed her having glassy eyes and slurred speech. She appeared tired, was unsteady on her feet, and was crying. After speaking with supervisors, she initially signed documentation agreeing to submit to a drug screen. But before doing so, she changed her mind and decided not to take the drug screen. She was then terminated from the MC on August 11, 2020. Thank you.
Mercer.
Ms. Scotto did not refuse to take a drug screen, and they would show that. In fact, she signed a document agreeing to the drug screen. As far as the appearance of Ms. Godbow, there were medical reasons for her appearance. The documents that indicate that she appeared to be glassy-eyed, it appeared that she was stumbling, it appeared she was unsteady. There were medical reasons. We're going to present the evidence to the board so you can see that there was a reason for that. There is no laboratory testing result of any kind that indicates that Ms. Godbow was under the influence. As a matter of fact, she voluntarily on the next day after this incident, that morning, went to the drug screen on her own. Then later, she took a hair test. All her name. This is not an issue where you have someone who was under the influence. She has a sterling record, got very high review. She worked that day that this supposedly happened with her doctor, who gave one of the ones that gave the letter of recommendation to her. She was not under the influence, and that was a mistake that was made in the reporting of this, and a rush to judgment instead of getting all of the information.
Further. Thank you, Mr. Mercer. Council, do you have anything?
No, Your Honor.
You call your first witness.
The board calls Hashina Jones, investigator, please. Please state your name, county of residence, and place of employment.
My name is Hoshina Jones. I'm a resident of Hines County. My place of employment is the Mississippi Board of Nursing.
How long have you worked for the Board of Nursing?
2 years.
And what are your duties with the board? What are your duties as an investigator with the Board of Nursing?
To gather information that is reported to us, to verify the information that's given to us in an investigation.
If you would, please turn to what's been marked as Exhibit B2 and identify that document, please.
B2 document is a licensure documentation.
And who is that for?
So Whitney Hancock Lynn God.
And what does it show as her type of registration with the board?
RN.
And when was she first licensed?
January 23rd, 2008.
And what is her license number?
The license number is through 878-689.
If you would, please turn to what's been marked as Exhibit 5. And looking at that very first page, please tell us what that document is of the top.
A complaint of notice of hearing.
And when was this hearing first noticed?
January 3rd, 2022.
And what date did it set as the hearing date? in
The date,
body?
the date of the hearing,
Mhm.
Thursday, February the 10th, 2022 at 8:30 a.m.
And is that Mrs. Scott that's sitting over there today?
Yes.
Have you had an opportunity to meet with Ms. Scott before today?
We have met over emails.
Have you ever seen her here in person?
No.
If you would, please turn to the second page and identify that document, please.
Second page is the complaint.
If you would, tell me what the charge listed is on the complaint.
The complaint is charge 1 that the respondent violated Mississippi Code annotated section 73-1529-1. In that respondent engaged in any unprofessional conduct as identified by the board and its rules, namely that the respondent violated Mississippi Administrative Code 2820 R 1.2 F, in that respondent practiced the profession while under the influence of alcohol or other mood altering substance as evidenced by or refusal to submit drug screening.
Who's the respondent listed on this complaint?
Miss Whitney Godbold.
And going more towards the bottom of the complaint, what are the specific facts alleged? in Mrs. Scott-Bold?
While working at the University of Mississippi Medical Center in Jackson, Mississippi on or about 8/10/20 and 8/11/2020. Facility personnel observed respondent with glassy eyes, slurred, appearing tired, exhibiting slurred speech, unsteady, and crying. Facility personnel requested respondent submit to a reasonable suspicious drug screen on or about 8/11/2020. Respondent refused to submit to drug screen. The facility terminated respondent employment on or about August the 11th, 2020.
And if you would, please turn to Exhibit B6 and identify that document as well.
B6 document is an email communication between myself and Ms. Godbold.
And what's the date of the communication?
September the 20th, 2020.
And what does she say in her statement?
And B6, the statement reads, "Sorry, I'm just seeing this. I had no idea of the gravity of not getting the drug screen. I can pass a drug screen any day of the week. I only did not want to go into the ER because of how nurses can gossip. I even asked to go to the employee help like the normal protocol. I took a completely negative screen directly after that I can provide. I do not use drugs and would never jeopardize my career or my patient safety. I still don't understand why all of this happened, and I apologize for not being more educated in the area of what happens if anyone asks you to go take a screen. In almost 14 years of nursing, I have never been in this position. I value my role as a nurse and the people I can help. I would never, ever jeopardize that intentionally."
Return to what's been marked B7 and identify that document, please.
It's agreement of submit to drug and alcohol screening.
And if you would specifically, what it says in the beginning with, "I am aware," it's the second paragraph midway through.
I am aware and have been told that my refusal to submit to a drug and or alcohol screen by blood and or urine test and or medical assessment may be grounds for disciplinary actions against me, up to and including termination.
And did Mrs. Scott-Bold sign this agreement?
There's a signature there, looks like her name.
And what is the date?
The date is 8/11/20.
Please turn to what's been marked Exhibit B8 and identify that document.
B8 is a visual observation checklist.
Where did you obtain this checklist?
From the facility and the scope of my, request by subpoena documents.
And does this checklist specifically relate to Mrs. Gobble?
Yes.
And what does it indicate the visual observation was of personnel that day related to Mrs. Gobble?
Picked up on me. Walking, standing, it says stumbling, swaying, staggering, holding on, slow, slurred, crying, sleeping, fighting, drowsing, fighting, bloodshot, glassy, messy, unruly, tumbling, jerking, and slow.
And if you look at the second page of B8, I think we discussed this previously. Mrs. Gobble did not sign this document. Is that correct?
Correct.
But it was signed by her supervisor. Is that correct?
Yes.
And was it witnessed?
Yes.
And what was the date of both of those signatures?
8/11/2020.
And when someone appears by personnel to be under the influence at a facility, what does that facility typically do?
Typically, would ask for a, drug screen. Suspicious, drug screen.
And during your investigation, did you have an opportunity to also obtain statements from employees at UMC?
Yes.
Okay, if you would turn to B9 and identify that document, please.
B9 is a email, statement from Megan Wiley.
And we don't have to go through the entire statement for purposes of time, but is it fair to say that Mrs. Wiley received, or Marianne Kraft, I'm sorry, received a complaint about Whitney?
Yes.
And then what happened? And looking at the second paragraph.
Marianne Kraft, the manager ambulatory operator, was notified on 18/20 by Laura Beth of concerns regarding Whitney Godbold. Laura Beth shared with Mary Ann that she had been told by a friend, a UMC employee, that Whitney had claimed she could drink alcohol at work and get away with it because she wears a mask. Therefore, no one can smell alcohol on her breath. Laura Beth's friend stated that Whitney's husband found vodka in her work backpack.
Just kind of summarize, what did they then do? What did UMC do after they received this complaint? Did they conduct an investigation?
Yes, they conducted an investigation.
And how did they do that? Was it by an inspection? Tell me the facts of what their investigation involved.
From my understanding, once they went over to the medical mall, and that may be not the location, when they went over to the medical mall to check observations on Ms. Godbold for themselves, they asked her to submit to a drug screen.
And looking in this, I think it's like the third paragraph. Who went over? Was it Marianne Kraft?
Mary Ann Kraft observed Whitney at work at the Jackson Medical Mall on 18/20 to observe Whitney's behavior.
And how did she appear that day?
Mary Ann noted that Whitney's eyes seemed glassy and she appeared tired and her speech was slurred. And Mary Ann and Jennifer Bryant, Laboratory Operation Director, noted that this could be due to a medical condition Whitney had self-disclosed in the past. Mary Ann then observed Whitney at Grants Ferry on 8/11/20 around 8:30.
So let's pause right there. So the next day, Marianne observed Mrs. Godbold again, correct?
Yes, on 8/11.
And that morning, what was her observation?
Okay, that after, on that
At
one,
8:30.
at 8:30, where you stopped me at?
Sorry.
Okay. I was on the road there. Okay, Whitney's speech was normal. Mary Ann then went to Jackson Medical Mall on 8/11 that afternoon to observe Whitney. And Joanne Elliott, nurse manager, accompanied Mary Ann. When Mary Ann and Joanne arrived at the Jackson Medical Mall, Whitney Witness office door was locked. When Whitney opened the door, she appeared intoxicated and sleeping. Her computer was locked and she did not have any paperwork in front of her.
And just to have to not go through it word by word by word, but what did they ultimately observe after she opened the door in the office? But yeah, just what happened.
Okay, Jennifer joined Mary Ann and Joanne at the Jackson Medical Mall to observe witness behavior. The three managers proceeded with following the UMC substance abuse policy. Whitney at first consented to a drug and or alcohol screen and signed a consent form. I advised Mary Ann that they would need to meet me in the main campus emergency department since student employee health was closed. Mary Ann, Joanne, Jennifer, and Whitney proceeded to begin traveling to the main campus. But once inside the car, Whitney stated that she would not consent to the drug and or alcohol screen.
And did they allow Whitney or Mrs. Gobble, I'm sorry, to drive home? After she refused the drug screen?
After she refused the drug screen, Jennifer reiterated that Whitney could choose to proceed with the drug screen or refuse to proceed with the drug alcohol screen. Whitney stated that she would not go to the emergency department for drug and alcohol. Joanne arranged for the Uber to take Whitney home.
And if you just go on to the next page, what did Joan and Mary Ann collect?
Joanne and Mary Ann collected a bottle from Whitney's work area that smelled of alcohol.
And if you would, you can turn to what's been marked as B12 and identify that document.
B12 is a substance abuse policy from UMC Medical Center.
If you look at section 3, item 10, what does it say on the second page?
Item 10 say, if the employee refuses to be tested, the employee should be immediately suspended and told that after further investigation, appropriate disciplinary actions may be taken up to and including termination. The employee identification card will be taken at this time and forwarded to the Director of Human Resources with all appropriate forms. The employee should sign a refusal to submit the drug and or alcohol screening.
If you would turn to what's been marked as B13 and identify that document.
B13 is the prescription profile. Mississippi prescription profile, medical prescription profile.
We call it a PMP.
PMP.
And what does that do? That was the prescription history for someone?
Yes, we'll pull it, prescription history.
And that's just for in the state, is that
In the
correct?
state of Mississippi.
Okay. And who is this PMP on?
Whitney.
Godbold? And during your investigation, did she disclose that she had a medical condition that required her to take some pain medications?
No.
But what does this PMP indicate that she's been prescribed in recent months?
Olanzapine, hydrocodone again, it's Xanax and.
Keep going.
Oh, you want me to go on? Okay, some oxycodone, some gabapentin, Adderall, morphine, tramadol. Pretty much oxycodone again, more hydrocodone.
But the allegations today are what? What are the allegations today about on the dating question on August the 11th, 2020? Do they relate to these prescriptions or do they relate to what?
It relates to refusal of a drug screen.
And what was the suspicion that the employees at UMC observed that caused them to request the drug screen?
It reported that the respondent had glassy eyes, slurred speech, unsteady gait, etc.
And what was retrieved from the trash can?
A bottle, empty bottle, vodka bottle, or something that smelled like alcohol.
And are there statements contained within your investigation that support that the bottle that was retrieved from the trash can smelled like alcohol?
Yes.
No further questions.
Gross.
Yes. Ms. Jones, you were just asked to review these documents, and I'm not going to go through all of them. I do need to ask about some in particular. If you would you go to A6?
Yes.
All right, you read some of that previously.
Right.
At the top, what was sent from Whitney to you. This second sentence or third sentence on the second line, you see where it begins, I even asked?
I even asked to go to the employee's health.
Right, would you read that sentence?
I even asked to go to employee health, like the normal protocol.
Okay, so Whitney is asking to go to employee health like normal protocol. In your investigation, what do you find to be the normal protocol?
Raise your question, please.
Yes, in your investigation, what did you find to be the normal protocol for this facility if they suspect someone of alcohol or drug use at work?
The normal protocol in my investigations would be they would take have an employee to go to their employee health facility clinic. And if that's closed, then they'll have them to go to a lab court or something like that, if they have a secondary.
Let's look at exhibit B12. Which says it's a substance abuse policy for the medical center.
Okay.
Would you agree with me that that is a UMNC policy procedure manual for substance abuse?
Yeah.
If you would turn over to the second page and look at numbered paragraph 9 on Roman numeral 3 procedure and read that for the record, please.
If you have reasonable cause to believe that an employee is under the influence of alcohol, drugs, or both and denies, same being arranged for the employee to take him to an employee health service rapid track for the giving of appropriate specimen for drug and alcohol screening. The supervisor/manager should also contact toxicology, who will come in to be sure the proper chain of command is carried out on the sample. The employee should sign an agreement to submit to drug and or alcohol screening.
All right. So based upon that procedure, correct me if I'm reading it wrong, the employee, if there's suspicion, should be taken to the employee health services rapid track. That's what you read there.
The employee's health service rapid track for the giving of appropriate specimen.
That's a location. The employee health service rapid track is capitalized. That's a location, correct?
Yes.
Now, isn't it true that in exhibit B6, that, and it'll be proven by other documents, that Whitney says, you know, she just asked to be taken to the employee health like the normal protocol?
Yes, that's what's in there.
So show me in exhibit 12, where it states that the medical center should send an employee somewhere other than the employee health services rapid track in this situation.
Well, based on the room number 3 that we was in 9,
Pardon? Yeah.
where it said employee health service rapid track for the giving of appropriate specimen. And then looking back at B6.
No, Ms. Jones, I'm talking about procedurally, where in the substance abuse policy does it authorize the employee be taken somewhere other than the employee health services rapid track if there's suspicion of alcohol or drug use?
Excellent question again.
Okay. We see in
Mhm.
number 9 of
Mhm.
Roman 3 procedure that it says if there's a suspicion, what to be done. And it says that what should be done is to take the employee to a location, we already established that, the employee health services rapid track. And do you agree with me, that is the procedure stated by UMC?
Employees health service / rapid track for the giving of appropriate specimen.
All right, now, that's a location, you agree with that?
That could be 2 locations.
Well, show me where, do you know where the employee health services is located?
So the employee health services at UMC, if I'm not mistaken, is on campus. But if that facility is closed, they will send a persons to a rapid tracking for that same, that does that tracking, the same like LabCorp, urgent care, someone like that.
Show me where it says that in here.
It's not in there, but I'm saying that's my opinion in how.
Okay, I'm not asking your opinion, I'm asking about facts.
Okay, employee health service / rapid track for the giving. So it could be either or.
Well, okay. But there's nowhere other than the employee health services, which you said is the UNT campus that you know of.
I'm gonna object. She didn't draft this document from UMC.
Right.
And we're arguing right now about where she should have gone, and the whole issue is that she didn't go.
Let me ask a question here. You're saying, you're testifying that those are 2 different locations, correct?
Yes, if I have a slash that said, employee health service / rapid track facility, that means that if UMC UMC health services is closed for the night, their clinic is closed, then they still need a safe instance, they close after 5 or close at whatever time. It's a possibility they will send that nurse to an outside source to take that when they said the rapid track. This is what my understanding is.
So rapid track, what does that mean? I'm just asking.
The rapid track would be that, since we're not doing it at the facility health location, then we would send you to another, matter of fact, export you to another location to get the drug screen alcohol done.
Okay, but again, because there's some confusion in the testimony. It's not, that rapid track is not at UMC.
Yes.
It's not?
Yes, the rapid track can be at UMC. They could have a employee health spot that is open and a different location that's open for that at the end of the day or the night.
They could have 2 at UMC. Okay,
Yes.
I'm just trying to understand. Thank you. Mr. Mercer, I'm sorry, back to you.
Ms. Jones, do you agree with me that the only location listed in this exhibit B12 to take an employee, what you just read in that number 9, Roman? Okay, and you stated that it was your understanding that they can take the employee to somewhere other than employee health services if it's closed. Did I understand you correctly?
Right, and they also have a rapid track on their facility.
Just one step at a time, please.
Mhm.
All right, so can you show me anywhere in this document that's where it supports your opinion and your understanding? And if not, can you tell me where you got your opinion?
Same objection. Once again, she did not go. We were talking about where he thinks that she should have gone. But the whole issue today is that she didn't go there. That's the whole issue. He's having the investigator try to interpret a document drafted by UMC that she's asked him to answer this at least 5 times already.
Okay, hang on one second. We have a hearing panel that would like a question, to ask a question for clarification.
Right, just to clarify, if I'm understanding, and I happen to be an employee at University of Mississippi Medical Center. So as I understand it, you're explaining it correctly, that the employee health services is a location that has typical business hours. And then rapid track is when that office is closed, and the rapid track is actually located in the adult emergency department, which is open 24/7. So my point is, I think your understanding, although you didn't write this, is correct with my understanding as an employee.
Yes, and throughout my process of dealing with UMC and having cases like this, if they have one part closed, they always go to the ER and test their employees if that's what they need to do.
That's my understanding. Thank you.
At what time were they trying to take Ms. Godbow Whitney to be tested?
On 8/11, looking at exhibit B9. So, no. Okay, so B9 exhibit, they say request, and they said termination is requested for Godbow due to the refusal to submit to a drug and alcohol screening on 8/11/20. Whitney refused can be found on the 8/11 recording at 2:01, 2:19, 3:08, 3:55, and 4:24.
Is the employee health services closed at 2:00, 3:00, 4:00 now?
I can't advise on that.
You don't know what time it closed?
And that's correct.
Let's go ahead and look at, well, let me ask you this. You were asking questions about the history of Whitney. In your review of the records, would you find that, what you mentioned first, what year did you say that she was licensed? 2008, did I hear you correctly?
She was licensed 1/23/2008.
Is there any record of any disciplinary action against Whitney by this board or any other board?
No, sir.
Did you find any record of any action taken against Whitney by any medical facility or any employer prior to this day?
No, sir.
If you will look at the B7.
Okay, I'm there.
there?
Yes, sir.
That document indicates the first part. You see where it says employee signature,
Yes, sir.
and that's Whitney's signature as far as you know.
As far as I know.
And that's an agreement that's signing an agreement to be, drug tested, drug and alcohol screen.
Yes.
So according to this document, B7, on that date of 8/11/2020, Whitney Gotbo signed a document in agreement to the drug testing and not a refusal, according to this document.
According to this document.
And if you look at B8, you were asked questions about this document, which says it's visual observation checklist. And you went through and you stated the ones that were highlighted. And so you've got these observations by whoever signed this supervisor. Do you know who the signature is on the second page?
The supervisor, Jennifer Bryant, maybe.
It looks like a Jennifer to me too. All right. Are there any explanations for stumbling, swaying, staggering, being unsteady, and holding on, other than being under the influence of drug alcohol?
Is there any what?
Are there any other explanations for that? I'll ask it this way. Isn't it true that Ms. Gonzo disclosed to, according to statements here, she had disclosed to her employer her prior medical history of Guillain-Barré syndrome?
Okay.
You agree that's what it says in there, or we can look at it if you don't know.
Yes, sure.
We'll get to that. Just to do it this way, you'll agree that there are other explanations of somebody being slow, slurred, crying, other than being under the influence of drug or alcohol.
It could be.
And if you'll look on the let's look at B9.
Okay.
You were asked some hodgepodge questions about this document. It says a lot. Who originated, based on your reading of this, who originated the statement that Whitney had claimed to someone that she could drink alcohol at work and get away with it because she wears a mask?
You wanna know who originated this document?
Now, who originated that statement according to the document? I just asked it this way, was it Megan Wiley who originated the document that came up with that information?
This information was given to Megan Wiley.
Well, let's
I'm gonna have the same objection. It's really late here and I'm not trying but we've already ruled on the hearsay and we're going back through this again.
One thing, I just want to caution both parties. I just want to be sure we stay relevant to what the issues are. And I want everybody to be afforded to make their record. And I don't, but I want some cooperation to be as succinct as possible so we can preserve the record, make the record, but do it with some efficiency. So that's my request.
For the record, I feel like I'm not being able to make my record.
Well, you are welcome to make your record. I have not sustained her objection. I want you to proceed, but I don't want to be redundant in what we're doing. And I want you to make your record, And I think I've been very lenient for both parties. And I'm trying to do the best I can under the situation. So, about sustaining their objection, you can pursue it, but just be as succinct as possible.
Ms. Jones, if you would look at the second paragraph of exhibit B9. And I'd like you to read that first, second.
And the first sentence was it Mary Ann Craft, manager, amateur operator, operation?
No, I'm sorry, under investigation summary, once again, Mary Ann observed it.
Okay, Mary Ann observed Whitney had worked at Jackson Medical Mall on 8/10/20, who observes Whitney's behavior. Mary Ann noted that Whitney's eyes seemed glassy. She appeared tired, her speech was slurred. Mary Ann and Jennifer Bryant, ambulatory operations director, noticed that this could be due to a medical condition Whitney had self-disclosed in the past. Mary Ann then observed.
That's all it's needed. That's what I was asking about earlier, about the medical condition. Do you know what medical condition that Whitney had disclosed to her employers in the past that could explain what they were observing?
No, sir.
If you would, look down to the paragraph below that, and on the second line, if you read that first full sentence that begins with it.
Whitney at first consented, that's the one you want?
Yes.
Whitney at first consented to a drug and or alcohol screening and signed the consent form. Pardon? Continue. I advised Mary Ann that they would need to meet me in the main campus emergency department since student employees' health was closed. Mary Ann, Joanne, Jennifer, and Whitney proceeded to begin traveling to the main campus, but once inside the car, Whitney stated that she would not consent to the drug and or alcohol screen.
So she at first consented to what we read a moment ago in the employee policy procedures for UMC, but then she changed her mind according to what this statement says. Whenever they were not going to take her to employee health.
Yes.
If you would, look on the next page of that exhibit B9. Up there at the top, it talks about a bottle being collected from Whitney's work area that smelled of alcohol. See that?
Yes.
All right. Do you know, did Whitney have her own office or share an office?
I'm not sure.
Where's the laboratory test of the contents of the bottle that smelled like alcohol?
You asking me that? I don't have the results of laboratory results on the container that smells like alcohol.
You don't have
No.
any lab results on that?
No.
Where is the bottle that supposedly contained this alcohol?
Not in my possession. We don't collect those type of things.
So it was never confirmed by any type of analysis that what was in that bottle was alcohol or a soft drink or a sports drink or whatever. Do you agree with that?
Ask the question.
Okay, so it's never confirmed by any type of laboratory analysis or test that what was contained in that bottle was alcohol or sports drink or beverage, soft drink or anything.
No.
It was never confirmed, was it?
No, it was not.
If you look down there in the last paragraph, it says the following documents are attached. And it lists 1 through 6, which are statements, but it also has 2 and 3 there. Number 2 says recording the phone conversation with Godbo, Marion Craft, Jennifer Bryant, and John Elliott on 8/11/20. Where, I don't see that attached on my exhibit 9. Do you have that?
Do I have the recording of the phone conversation?
Right.
What you asked, a copy of it? No.
What about number 3 there, the recording the phone conversation with Godbo on 8/12/20?
No.
Is the state trying to introduce that?
No.
Or the state? Yeah, the state.
It's not. The document states that she has attached these things. And if they're exculpatory, I'm trying to explore where they are.
And so it does. Can I just ask a question to the council for the board? Are those- Is that the attachments, are they in our possession?
No, we just have the statements. We don't have the recordings.
You say we, the board of nurses,
Board.
the board does not have the attachments to that statement.
It has the statements that are referenced, Marianne Croft, Joan Elliott, those statements, but it does not have the recordings, and it does not have the bottle that was retrieved from the trash in its
Okay, thank
possession. But again, I know, I just asked for it to be a continuing objection, that a whole issue here, that she smelled of alcohol and was acting suspiciously and was requested to do a drug screen that she didn't do, which would have been the most exculpatory evidence that could be. So,
Well, I know. The difficult thing here, though, is we talked about the statements the board did. And so council has the right to discuss those statements.
certainly, we just don't have the recording in our possession.
Go ahead, council. Mercy. Let me ask a question real quick, can we take, it's 8 o'clock, can we take a 10-minute break recess? Is that okay with you, Mr. Bishop? Okay. You're all right? All right, take a 10-minute recess. Do you have do you have an objection to the hearing panel eating? What? At the panel table? As long as you share it. I didn't know it. I didn't know. No. Okay, since we didn't have a motion to recess, and I just recess this, I'm just gonna go ahead and put us back in the regular session. And I believe Mr. Mercer was on cross-examination of the witness. Okay, Mr. Mercer, will you continue your cross-examination, please? Thank you.
Mr. Jones, let's look back at the VA. Look down at number 8 under the visual observation checklist.
Right.
Right. So one is check.
None.
So the state alcohol odor, right?
Alcohol odor, like alcohol odor, non-alcoholic odor.
And that is checked.
That's correct.
Which proves me that the things that are checked here, such as, I asked you a question about earlier, not this question, such as crying and being sleepy, and fighting and staggering, and swaying, unsteady, that there are other explanations for people who may exhibit that type of behavior, characteristics, other than alcohol or substance abuse.
You said, ask the question again?
Yeah, would you agree with me that if somebody's exhibiting these,
Yes, it's a possibility.
yeah, and so you just don't know because you're not a medical professional.
That's correct.
Let's look at the PFP, which is exhibit 13.
Okay.
And I didn't follow your testimony earlier. I was trying to take some notes. But you made some comments about what's on here. Is there anything listed in here on exhibit B13 that was not prescribed by a licensed medical provider?
Everything on this PMP is prescribed by a medical provider.
And is it your experience that a medical provider normally will prescribe medications that show up on the PMP that he deemed to be reasonable and necessary for that patient's health and well-being? He or
Yes,
she.
yes.
And the date of this occurrence was August 10th and 11th of
Correct.
2020.
Yes.
All right. On that date, what medication would, looking at the PMP, what medications would prescribed by a medical provider would Whitney have had prescribed to her?
Again?
Yeah, it was not a good question. On the date of August 10th, 11th, 2020, according to PMP, was Whitney, did she have any prescriptions that she should be taking on that date according to PMP?
The closest one to that 8/11, was it 22? 2020? Oh, let me go back then. Okay. The closest one that could have possibly would be 5/22/20, the hydrocodone.
And that was 120 quantity for 30 days, is that right?
Yes,
So if she was taking it as prescribed by her doctor, she would have been out of that by the end of May. You agree with that?
yes.
Is there anything wrong with a nurse taking prescriptions prescribed by her medical provider.
No, it's not.
So there's nothing remarkable about this PMP for Whitney Godbow. Do you agree with that?
There's nothing remarkable about it.
You agree?
The prescriber prescribed it.
No, I'm just saying, there's nothing unusual or remarkable. It's just part of your standard operating procedure. You just have to get this part of it.
Yes.
Did you interview Mary Ann Crowder?
No, sir.
He is the one who authored Exhibit B9A, correct?
B9A is the author, Mary Ann, yes.
And the author of Exhibit B9 is Megan Wiley. Did you interview Megan Wiley?
No.
And the author of Exhibit B9B is Joan Elliott. Did you interview Joan Elliott?
No.
So you have no way to ascertain whether or not the statements in these emails, Exhibit B9, B9A, and B9B are true. You agree with that?
The statement, so not the statement is true.
What I'm saying is, if you did interview the people who authored those exhibits, you didn't ask them any questions to verify the veracity or truthfulness of what's contained in the emails, did you?
No.
You were asked a question earlier. And you read a statement, I believe, that someone stated that Whitney appeared tired. You remember that?
Ask the question again.
You were asked a question earlier and you were reading from one of the statements and you said that Whitney appeared tired. Remember that?
Yes, it's in one of the statements I was reading.
In your experience as an investigator, do you often come across nurses who are tired?
In my 10 years of working here at the Mississippi Board of Nursing, I haven't come across any that was tired.
Never heard of a nurse that was tired.
That was just straight tired, that was related to a drug screen issue. They just say they're tired from working 12-hour shift, and that's general talking, general conversation.
That's what I mean, Ms. Johnson.
Yes, general
Nurses do
conversation.
get tired.
I'm tired of working a 12-hour shift, that's general.
No more questions.
Can you redirect? You are. Oh, excuse me. Board, have any questions? Or panel members? You are excused. Does the state have any other witnesses?
Honor.
Respondents, turn to present their evidence.
The respondent called Whitney Godbow.
Still on oath.
Yep, thank you.
Ms. Godbow, state your name for the record, please.
Whitney Hancock Gobble.
Ms. Godbow, you're here today with accusations that you used an alcohol drug screen test at UNC on August 11th, 2020. Would you give the board benefit of your nursing education background?
I graduated from where I graduated, nursing education, Hines Allied, in December 2007. So by the time I did my board, my board's right after 123.8 that she was reading earlier. Immediately went to work into surgical trauma ICU there for 5 or 6 years, worked at Batson Hospital. Then, in the PACU, my husband's job moved to Hattiesburg, moved there. I did some hospice call there and then started working in the ER there. And that's when Merritt bought over Wesley. So that was a very big, busy ER. When we moved back, I learned that there was a Merritt in Canton. So immediately, I never really even broke employment with Hattiesburg Merritt. I went there to interview and the bosses just got on the phone and they just said, it was an informal interview. They said, don't let her leave without hiring her. And just began picking up shifts there. And UMC called me from this department and asked me to come back and work there. So I did that too. I was working both jobs, just, doing part-time benefits with both. Or, I was doing part-time benefits in the ER. Then once I got back on UMC, I went back on their benefits and did PR. Yep.
August 2020, August 10, 11.
Mhm.
2020 particular, where were you working?
August, when that was happening, I was at
Who were you working for?
UMC
Right, and where did you work?
in dermatology.
What locations?
Well, it's they have the pavilion. They also have a clinic in the Children's Hospital. They have Grants Ferry. And then me and my co-nurse Tracy and Dr. Brodell, which is the chair of the department, we opened the location at the medical mall from ground zero because we're trying to help, the rural patients be able to afford their medications because some of those medications are very expensive. So that's how the medical mall came about.
In August of 2020, were you working all those locations or you working?
Worked at all of those locations and I was working still in the ER on the weekends.
All right, you got the exhibit for you. Take a look at exhibit R4. All right,
Almost there, I think. That was the drug fair.
all
Okay.
right, I'm showing you exhibit R4. That's a letter on UMMC letterhead Department of Dermatology. It's support of you, and it's from Dr. Robert Brodell. Did I pronounce it correctly?
Yes.
Okay.
He's the chair of the department.
Okay, and how is he, what connection do you have, or did you have to him?
I was his
August-
personal
Let me
nurse.
finish this question, she can't do that.
I'm sorry.
In August of 2020, what was your connection to Dr. Brodell?
I was his personal nurse.
Okay, and what does that mean, personal nurse?
I was there. He also did pathology, so I would get there early in the morning and start up clinic and then, get the patient settled and text him, say, hey, come on down. I got 3 rooms ready. Helped him with procedures, help the residents.
And on the dates of August 10th and 11th, we're also working with him on those dates?
I was.
Okay. Now, you also have letters of support from Gabe Godbow, your husband here, Kathy Duke, Lacey Hales,
Yeah.
Kristen Russell, and Christine Stuck. Now, we're not gonna read these or go over these, but these are people that know you.
Very well.
Where are you working? Well, you left UMC August 11th. Where did you go to work after that?
I continued to work at the ER in Canton. I've never missed any work since.
At the ER in Canton.
Yes, in Canton, at the Merit.
Okay. All right, is that where you work today?
Yes, sir.
Okay. What are your plans? In education and nursing people.
My plans, my son is, so he'll be 18 this month, so he'll be going to college. So, actually had another interview Monday with Select. They asked me to interview with them, and they do an education program that will help you with your master's. So I was, had applied with them as a PRN position while, he's going to college, have more time to then continue to bridge on to my master's since I've gotten my bachelor's from UMC.
The accusation are that you refused to take an alcohol drug screen on August the 11th, and that you appear be under the influence of something, some
Yes, sir.
intoxicating substance. Do you understand those allegations?
Yes, sir.
There was something I read earlier. It's from one of the emails. It was exhibit B9. And in exhibit B9, that's Megan Wiley writing to Cecilia Bass, Chris Morgan, Pamela Greenwood, 16 Kimberly Sims. Now, in that exhibit 9, she states that Mary Ann and Jennifer Bryant, ambulatory operations director, noted that this could be due to a medical condition Whitney had self-disclosed in the past. What is that referring to? What medical condition?
When I started back at UMC in dermatology, I mean, just 1 in a million chance, I ended up with Guillain-Barré, which is very long, serious condition. You have to learn to walk again and lots of physical therapy, lots of, so they kind of went through that with me,
Okay, so
that department.
So how serious, and as you know, I didn't really know about Guillain-Barré until you educated me.
Right.
So for anybody that may not know, for the record, how serious is that condition and how serious was it for you?
Very serious condition. I mean, there's people that end up on ventilators. By the time he dropped me off at the ER, because, nurses are difficult patients, they finally just threw me in there. My numbness was up to my ribs. And so they had to do spinal tap and start me on the IV infusions, and I had to go through a lot of treatment.
So how long did this treatment for you last?
I was in the hospital probably for 2 weeks on the IVIG infusions and the steroids continuously. After that, I left in a wheelchair, and then I was in physical therapy like 3 or 4 times a week, and I had to go to the UMC infusion center every week. Started at twice a week, then down to once a week for 6 to 8 hours a day.
What are the symptoms of Guillain-Barré?
Weakness. Your legs, I always remembered at nursing school, Guillain-Barré from ground to brain. So you just start as a normal nurse, like we're on our feet all day, and you're thinking, oh, my feet hurt, I'm tired. You prop them up. And then I started having difficulty getting out of the bath. And then as an athlete, I always had big muscles. So you think, okay, well, let me work out more. And then, I've got 10 pair of yoga pants with holes in the knees because you just start falling. And then I got self-conscious, how far you have to walk from UMC, especially like from the pavilion to the stadium. I would kind of stay behind and pack my stuff because I started getting self-conscious. I couldn't keep up with the other girls getting to the car. Okay. And I'm looking at my legs, why are you not working? Why are you not walking? And, it goes from atrophy and goes from there. Then you start the awful nerve pain. And so you see my, PNP and stuff, it looks crazy, but it's awful, awful nerve pain that, goes with it. And then, yes, sir.
Excuse me. When were you experiencing these symptoms in relation to?
When I first started at UMC, I was in my first 90 days of employment when I got Guillain-Barré.
And that was what year?
That
About.
was, if this all happened in 2010, that was about
This happened in 2020.
2020. I'm sorry, that was probably about 2018. that I got it, and I recovered for about 2 years, and then you get the after effects of it, you start, like, your bones start breaking because of all the, like, the high doses of steroids. I had multiple, ortho breaks, so.
Thank you. Let's go ahead. I guess the question is, did you have long-term residual effects from?
Yes,
these
the
drugs?
weakness is something, and I can compensate for the weakness a lot, because I worked out, I did all the physical therapy. But when you do get fatigued, you can kind of start to see your legs being shaky or being off, not being able, if you were on the ground, like at a stretcher, standing up, you kind of have to, help yourself. If you're fatigued, you can't compensate for it as well. Doesn't mean you can't nurse or I wasn't fit to be a nurse. The symptoms are more evident. I guess you could say I can't, hide them as well. The weakness, even your speech, things like that,
What,
because it affects your whole body.
what other negative health effects did you suffer